Thank you. Welcome to the second hearing of Portfolio Committee Number 8, Customer Service for the Inquiry into Budget Estimates 2025-2026. I acknowledge the Gadigal people of the Eora Nation, the traditional custodians on the land on which we are meeting today. I pay my respects to elders past and present and celebrate the diversity of Aboriginal peoples and their ongoing cultures and connections to the lands and waters of New South Wales. I also acknowledge and pay my respect to any Aboriginal and Torres Strait Islander people joining us today. My name is Emma Hurst and I am Chair of the committee. I welcome Minister Hoenig and accompanying officials to this hearing. Today the committee will examine the proposed expenditure for the portfolio of local government. I ask everyone in the room to please turn their mobile phones to silent. Parliamentary privilege applies to witnesses in relation to the evidence they give today. However, it does not apply to what witnesses say outside of the hearing. I urge witnesses to be careful about making comments to the media or to others after completing their evidence. In addition, the Legislative Council has adopted rules to provide procedural fairness for inquiry participants. I encourage committee members and witnesses to be mindful of these procedures. Welcome and thank you for making the time to give evidence today. All witnesses will be sworn prior to giving evidence. Minister, I remind you that you do not need to be sworn as you have already sworn an oath to your office as a Member of Parliament. For all other witnesses, could you please state your name and position title and swear either an oath or an affirmation? And I'll begin with my first witness to my left.
Thank you, Chair. My name is Peter Day, Executive Director of Strategy and Regulatory Policy with Agriculture and Biosecurity within the Department of Primary Industries and Regional Development. I solemnly, sincerely and truly declare and affirm that the evidence now about to be given by me shall be the truth, the whole truth and nothing but the truth.
Thank you.
Rachel Connell, Deputy Secretary, Department of Primary Industries and Regional Development. I solemnly, sincerely and truly declare and affirm that the evidence now about to be given by me shall be the truth, the whole truth and nothing but the truth.
Thank you.
Thank you, Chair.
Thanks, Chair. Tina Baldock, Acting Executive Director, Sector Development for the Office of Local Government. I solemnly, sincerely and truly declare and affirm that the evidence now about to be given by me shall be the truth, the whole truth and nothing but the truth.
Thank you.
Thank you.
Good morning, Chair and Committee. Kirsten Emma Fishburn, Secretary, Department of Planning, Housing and Infrastructure. I solemnly, sincerely and truly declare and affirm that the evidence now about to be given by me shall be the truth, the whole truth and nothing but the truth.
Thank you.
Brett Whitworth, Deputy Secretary, Local Government, Department of Planning, Housing and Infrastructure. I solemnly, sincerely and truly declare and affirm that the evidence now about to be given by me shall be the truth, the whole truth and nothing but the truth.
Thank you.
Yeah. Good morning. Jennifer Hickey, Executive Director, Sector Performance. I solemnly, sincerely and truly declare and affirm that the evidence now about to be given by me shall be the truth, the whole truth and nothing but the truth.
Thank you. And we've got some people in the overflow. If I could ask people to come forward with their name, please. Oh, sorry, we'll be swearing them in at 2. Apologies. Thank you. Today's hearing will be conducted from 9:15 to 5:30. We are joined by the Minister for the morning session from 9:15 to 1 p.m. with a 15-minute break at 11 a.m. In the afternoon, we will hear from departmental witnesses from 2 p.m. to 5:30 p.m. with a 15-minute break at 3:30 p.m. During these sessions, there will be questions from the opposition and crossbench members only, and then 15 minutes allocated for government questions at 10:45 a.m, 12:45 p.m. and 5:15 p.m. We'll begin with questions from the crossbench. Thank you and welcome, Minister. Good morning.
Morning.
Minister, I wanted to ask some questions in regards to the pet registry. Are you aware of any issues regarding the rollout of the New South Wales pet registry?
Yeah, they have required considerable more funds because the amount that they estimated requiring is underestimated.
Thank you. So you've been briefed on both the significant delays and the cost blowout of the project?
Yes.
Yes. I'd like to read from an email from within the Office of Local Government that I've cited about this issue, about the pet registry upgrade. The email says, an extremely ill-advised executive decision brought about the cessation of the project in August 2024. This decision was unfortunately made as a result of negligent and ignorant advice from, and as a former staff member, I won't mention their name, and DIO that led to a waste of around 25% of the remaining project capital budget, along with bringing about the health and safety impacts on the Healthline team due to the 4-month delay introduced to the project timeline. What's your reaction to that specific email and those comments?
I haven't seen that email or heard of the contents of the email, but this project was commenced before I was the minister by the former government, and I know that the next steps require the allocation of funds, and there has been some discussion within government as to whether or not those funds should be allocated, because whether the allocation would be productive or not, and that's a matter that the government will have to discuss. There are frequent submissions from various government departments, all who want money to put even more money into computer programs that don't work. So it would not come as a surprise, I suppose, to members of this committee that there's some other computer program within the public sector that's struggling, like the planning portal.
Mm-hmm.
It's a lot better now, Minister.
That's better. Never better when I used it. But yeah, I'm concerned though. If you let me have a copy of that email, I'll chase it down, because it's obviously a lot more serious than I thought it was.
Thank you. I might actually read another quote as well. So the quote that I have permission to share with you is: the current work order is for 3.46 million for less functionality than the 2.44 million work order, and will not be delivered until January 2025. The recent decision that has led to a 4-month slip in delivery timeframes and additional 1 million spend for a reduced functionality work order was based on completely misinformed position. My understanding is that a lot of the delays that have been occurring in the rollout of this registry have significantly increased the expenditure so much that they therefore are spending more but actually getting less functionality for the pet registry. It's now sort of in a position where it's become a bit of a mess. There's a lot of functions that were promised from the original pet registry prior to you taking government. But since then, it's just sort of been this rolling project with failure after failure. I guess, what will your next steps be?
I don't know. I'd like to have a look to see what you have. I don't know. I don't know who's actually doing it. I understood it had been outsourced to.
It's the Department of Customer Service.
Department of Customer Service, not within the Office of Local Government.
Well, these emails are coming from within the Office of Local Government, who
Anyway,
obviously has responsibility for the pet registry, but then it's being built elsewhere, is my understanding.
Yeah, it's been built out the side. I mean, when I became Minister for Local Government, the Office of Local Government had the grand sum of 45 people. So it had been under-resourced for a long period of time. So they wouldn't have had the capacity to put something like that together.
My understanding is that the 21 million or so that's been allocated to the pet registry has now been exhausted. Is that correct?
I think that's my memory. Maybe Mr. Whitworth.
That's not quite correct. We still are using some of that money. We have redirected that for the delivery of the puppy farm component, so the breeder identification number. And to be fair, I don't quite know whether you were given accurate information with that last quote, because that relates to the current work order, I suspect, which is all about the breeder identification number.
No, sorry, that was about, it was either about the car or it was about, I think it was about the, I'll get back to you, but it wasn't about the current change into the puppy farm stuff.
I'm aware that you would like to talk to the Minister, and I don't want to take up his time, but I'm quite happy, in fact quite eager to go through the pretty significant challenges we've had with the pet registry this afternoon, and the pretty significant work that we've had to do to address some fairly major flaws identified through an assurance process and health check that led to major changes to the governance arrangements.
And now that, Minister, if you're aware of this, now that the rest of any funding has moved towards implementing the puppy farm legislation, the section of that pet registry, what will happen with the functionality of all the other aspects that people are still waiting for, including portals for vets, portals for councils, portals for rehoming organisations and enforcement agencies?
Right, Mr Whitworth.
That continues to be something that we will put propositions to government about in terms of getting funding for that. You're very correct, we don't have those portals for vets, councils or rehoming organisations or enforcement agencies. That was always what we've called stage 2. So we'll talk about stage 1 being the delivery of the registry itself and the ability to link to the Service New South Wales account, so that's Link My Pet. Then we talk about stage puppy farm, which is about the breeder identification numbers and the link to the ability to have people register litters with their on the pet registry. And then the second stage would be those portals to provide access, and they're quite critical, but the pet registry functions now without those portals. It just doesn't deliver the full functionality that we had hoped.
Thank you. Minister, did you put any sort of budget bids or campaign or put in submissions to the Treasurer in regards to trying to get more money for the pet registry in the last budget session round?
It was contained, I think, in a departmental submission. From my recollection is, anyway, it was, wasn't it? Yeah.
Yes.
So you had requested more money, and was any of that
I
money?
don't know. Well, we didn't get any more. We didn't get any, did we?
No.
No.
The money wasn't allocated.
No.
And when did you first hear, Minister, about the significant issues in regards to rolling out the pet registry?
Probably at the time, or shortly before the time, I adopted the departmental submission in respect of funding.
Sorry, say that again.
Probably not shortly before the submission went to the government in relation to funding of it.
Okay, so that was the first that you heard
Yeah.
about some of the problems with the pet registry.
Look, I've been a bit troubled with this pet registry because not just its functionality, but the data that's going in it, because they're just taking the old data and they're just bringing it into the new registry. Now, I don't know that there's another way, but you know, there are going to be all these dogs and cats that are probably may or may not be dead or may or not be registered in the new registry. So the theory is that over time, after a period of time, dogs won't live anymore. But you know, as you know, cats can live for a long period of time. So what do you got to take a decade or 15 years before its accuracy? So I've been a bit troubled by the registry, but I don't have another solution.
Thank you. Mr Whitworth, can I ask when you first became aware of the issues regarding the delays and the cost blowouts?
The delays in?
The pet registry. Sorry, the question was to Mr Whitworth.
So I was aware when we went to, it was probably around April, May 2024, when the business case was resolved in January 2023. It had identified that by July 2024 we would have full functionality, but we didn't. And it was also around that time that I had discovered that we hadn't been able to deliver on the portals. And the more that I went into it, including getting a health check, an assurance check through the digital restart and ICT processes of the government, realised that the agile programming environment that our program managers, project managers, both in Office of Local Government and in the Department of Customer Services, had failed to deliver in terms of timeframe and budget, and that was blowing out. And so we weren't going to be able to deliver. I won't tell you my emotions at the time, but I was pretty annoyed. I had people telling me that I was wrong, yet I still hadn't been able to deliver a project. I had people telling me that we needed to change, that we should just stay the course and that the government would give us more money. I knew that the government would struggle to give us more money. So it has been a really challenging process, and I, working with the Department of Customer Service and working with my colleague Deputy Secretary from the Department of Customer Service, who has responsibility for that area of delivery, we totally revamped the governance arrangements for the project around the end of 2024.
Thank you. Dr. Conn.
Thanks, Chair. Good morning, Minister.
Morning.
I wanted to ask you about the recent Supreme Court judgment regarding Councillor Diley at the City of Parramatta, which I imagine you would be aware of.
Yeah. Well, I'm aware of the judgment. I haven't had a chance to read it thoroughly, but I'm aware of the judgment and I'm aware of the reporting of it.
So, more specifically, there was in the judgment, the censure of Councillor Diley was quashed. Do you think that this is an isolated issue, or is this part of a systemic issue of councillors being penalised when they speak out against a majority decision of a council?
I'm extremely annoyed that if the newspaper coverage of the facts of the matter are accurate, because it is another example where this cottage industry of code of conduct examiners has ignored the implied freedom of political communication that all people are entitled to, as well as councillors. I don't see these things, these code of conduct examiners' reports, as a matter of course. The ones that I've seen over time are either people who have sought my advice, my legal advice, because that's the only basis they can show it to me, where I've drafted responses and invited the attention of code of conduct examiners to their right of freedom of political communication. And those rights have been completely ignored by the code of conduct examiners, quite reprehensibly so. I'm aware of other examples where council officers have tried to intimidate councillors from asking for a traffic study at a location. I'm aware of other instances where other councillors have spoken to the media. The confusion seems to result from inconsistency between words of the compliance document and the implied freedom of political communication. So what was released earlier this year is an effort to try and stop it, is a guideline from the Office of Local Government, effectively telling councils that whatever words may or may not appear in any regulation or code of conduct that is inconsistent with someone's rights for freedom of political communication, that they are invalid. To try and put a stop to this. The other matter I'm gravely concerned about in relation to the newspaper report of Councillor Diley is not the fact that, well, I'm concerned that firstly she had to spend, I think reportedly $80,000 of her money in relation to a censure. Most councils cop it behind closed doors, and that's why that's going to stop. But the other is that the poor conduct of certain council officers to affect a particular result. I think the assertion is that they weren't satisfied with some sort of draft. Now, if that's the case, that's improper. Anyway, I'll have a look at the judgment, but it seems to me that the council is going to have to pay I suppose, Councillor Darley's costs, but it seems to me that she's also owed an apology as well.
My understanding as well was that there was
most disappointing
Minister,
exercise. I'm sorry.
I wanted to ask a follow-up question. So regarding the same case, my understanding is that there was an additional issue at the City of Parramatta where the councillors were given incomplete advice, that they were debating the recommendations of a report without actually having access to that report in its entirety.
Yeah, I think that's the justification that Acting Justice Schmidt used under the procedural fairness guidelines. You know the way council operates as well as I do. I mean, whether they had the extra one or had they not had the extra one, they probably would have. I don't know this, but the way some of those councils operate, if they've got to fix someone up, they fix them up, or they don't.
Sure.
I mean, they would have known.
I suppose more
they would have known
broadly,
the factual circumstances. I mean, if this be true, if the report's true, she shared a report from a newspaper on a Facebook page. Now, if that's the facts of the matter, the fact that they spent so much money with a code of conduct examiner over code of conduct complaints, pretty poor.
I think this is a really important case in terms of its implications for the sector more broadly, and I'm specifically trying to come back to this issue of councillors being asked to make decisions on potentially incomplete information, because this isn't isolated. In your view, for example, if a council or a general manager has obtained a report, whether it's a conduct report, whether it's legal advice, should councillors actually have access to that full information when they're making a decision?
Councils are entitled to whatever information they need to have to make their decisions, and withholding material from councillors who are entitled to it is not appropriate. I'm going to try and address some of these issues in the last of the integrity compliance documents that I've got to try and stop this. I think they're isolated instances, but I don't like to make rules just because there's a handful of problems. But we do have to have rules to stop democratically elected people not having access to material they need for the purposes of making decisions on behalf of their community.
Thanks, Minister. And to assure you, I'm asking these questions because some of these things are not isolated issues, and not all councillors have the courage and the determination that Councillor Darley did, actually taking this all the way to the Supreme Court.
Dr. Conn, I just say that we happen to see the problem ones, but as you move through the sector on a far broader scale, the percentages become, refreshingly, the percentages become smaller in compared to the total sector.
And I know you've made an announcement just yesterday about misconduct proceedings going to the Land and Environment Court. You've mentioned in one of your earlier answers already the significant costs associated with court proceedings, and some councillors are remunerated as low as $10,000 a year. Most councillors are on less than $50,000 a year. Sometimes complaints of misconduct can be vexatious. What are you proposing will be in place to ensure sufficient access to representation and procedural fairness for councillors caught up in court processes?
Well, the purpose of the bill that will shortly be introduced is to deal with matters of relatively serious misconduct. At the moment, as you would know, there is a convoluted legislative regime that virtually prevents the OLG from acting quickly without going through a myriad of processes, including procedural fairness, or their fear of procedural fairness at every corner of the decision-making process. So, For matters of relatively serious misconduct, I'm proposing legislation that will remove all of that from the Local Government Act's processes and create just a new process that will enable a minister, the OLG, a statutory authority, including ICAC, third-party individuals with leave, like the Protection of Environment Operations Act, to commence proceedings in the Land and Environment Court to seek disqualification if serious enough, suspension, fines and restitution of stuff that they might have stolen or misappropriated. The court will also have the power to immediately suspend somebody pending a hearing of the matter, and the hearing of the matter will be relatively prompt. So that if you've got, for example, an issue like a councillor from down the southern New South Wales, you could make an application to the court reasonably quickly to have that person suspended, and you could have the matter determined in a few months. And the reason I selected that court is, firstly, the Land and Environment Court is a superior court and a court of record. Second, if you are talking about disqualification of democratically elected councillors, it needs to be done by a superior court of record, not a tribunal. Thirdly, the Land and Environment Court has considerable experience in dealing with local government litigation. It is the normal court under the Local Government Act that does it, so it just doesn't do planning, it does administrative law matters for local government. And fourthly, the Chief Judge of the court was prepared to take the work and agreed to take the work and agreed to be able to do it expeditiously. So for the matters that aren't of serious nature, and what also could be serious is not behaviour, it could be pecuniary interest breaches, which regulations are currently being worked on, similar to the Parliament ones that are going to apply to members of Parliament. So they could be pecuniary interest breaches that require disqualification, so when they occur, proceedings can just be commenced. So the ones that are relatively minor can be dealt with in a different mechanism, and I'm hoping that arising from the Code of Meeting Practice, the Code of Conduct, the pecuniary interest regulations, that the recurrence of 2,000 weaponised complaints a year will no longer exist. That's the plan anyway.
Thank you. The opposition.
Good morning, Minister, and thank you to all the officials as well for appearing today. Minister, when did you first commit to fund Bayside Council to upgrade the Lestrange Park playground in your electorate?
I think I'd been campaigning for the council to upgrade that playground since about 2021, I think.
And as part of the local small commitments allocation, was this something that you committed to before the election or after the election?
No,
as part of that program?
No, I've been campaigning for that for several years. You're pretty good at stalking my Facebook page. You'll probably see some photos down with me down in that playground with all the problems down there, me complaining about fixing it up. I mean, I'm happy to talk to you about it, but do you want to use your time for something that relates to my functions as the member for Heffron? I'll talk to you about those things all day as well.
Well, I saw that there was something on your Facebook from the 14th of October 2023 with the big novelty check down at Lestrange
But if you
Park.
go back to 2021 and 2023, I'll show it to you now if you like. You'll just have to do a search of Lestrange Park.
I know you've been fighting for it for some time,
Yeah.
but when did you first announce it as part of the local small commitments program?
Oh, well, as soon as I got told that we had 400,000 that we could promised before the election.
Before the election?
Yeah.
So, Minister, that's a little bit strange because we, through documents that we've been able to get through SO52, what we've seen, and I've got these documents here that I can provide to you, is that before the election and all the way up until as late as the 14th of June 2023, there was no record of any commitment to the Lestrange Park playground upgrade. It was merely that New South Wales Labor would deliver up to $400,000 to local councils across the electorate towards upgrades to playgrounds and parks. So why is there a difference between what you're saying and what the documents say?
I don't know what's in the documents. I can only tell you what I've been doing for a couple of years, been jumping up and down about that, and by having $400,000 to do it, I could speed up maybe speed up the process.
Well, who did you tell then during the election campaign that you were going to allocate $400,000 to the Lestrange Park playground?
I don't know if I would have said $400,000, but you could be sure that every door I knocked in Mascot, I told them that I was going to, if I was elected, they were going to get money to fix up a playground across the road.
Well,
you don't think I'd say no to a playground that's a shambles and been campaigning for it for 2 years and not be using it in an election campaign, would you?
Sure, but you never announced it until the 14th of October 2023, so that's after the election, is that right? You didn't make an announcement during the election campaign?
But I didn't have it available to me until after the election.
Yes, but
because the quid pro quo was we had to win the election, we had to win the election.
Yes, but the program is such that you needed to make commitments before the election to be funded after the election. And what I'm asking you is why, and I'll provide these documents to you if that's okay, Minister. I've made copies of each for you to take a look at. But essentially what, thank you, there's 12 copies there, so there should be one for everyone. Essentially what the documents show is that before the election, there was no commitment made in the electorate of Heffron, meaning the money was supposed to, $400,000 was supposed to be allocated amongst the 4 local councils in your electorate. That was before, all the way up until the 14th of June 2023. But after that time, on the 28th of July 2023, all of a sudden the spreadsheet has changed where the full amount, the full $400,000 is to be allocated to one park in one council area rather than distributed amongst the 4 councils in your electorate. Do you have any explanation for that?
I don't know whose document this is, so I can't even accept the premise of that document. But all I can tell you is that out of my 4 councils that encompass my electorate, and of all the playgrounds of the 4 councils that encompass my electorate, the only shambles was Lestrange Park, and it had been it was dreadful, in a dreadful position. It was right next to a park where kids are playing soccer, a basketball hoop. Parents were complaining if you went down there, it made you sick. And I had been on about this one playground for several years. So,
I'm sure
what occurred afterwards, in respect to, so it's the only playground that I had been on about, and as a result of winning the election, I had $400,000 to be able to contribute to the council about the issue I'd been pursuing for some years.
That these things needed to be announced and committed to before the election, not after the election. That's part of the grant guidelines. If a project wasn't announced during the election, it's supposed to be allocate the funds, the $400,000 is to be allocated amongst the councils based on population inside your electorate. So in your electorate, for instance,
Yeah, but I'm not giving-
Bayside is supposed to get 124,000.
I'm not giving $400,000 to the City of Sydney that just spent $5 or $6 million on Turrawal Park. They don't need the money. Randwick Council just spent a fortune on Kensington Oval and renewing their playground equipment. They don't need the money. The ones that I can't get any work out of is Bayside Council with a park that needed the money. So I was told I had $400,000 I could promise. I'd been running this issue for 2 years, and I am so grateful, and so are the people of Mascot, for at least inducing the council to at least fix up what was a disgraceful shambles.
Well, Minister, you therefore...
And if you want to say that they shouldn't have got the $400 and that playground fixed up, you say it, and I'm happy to tell them what your views are.
I'm not saying that it's not a project of merit. What I'm saying is that that the election commitment, if you didn't make one within the electorate of Heffron, $196,000 was supposed to go to Sydney, $48,000 to Randwick, and $32,000 to the Inner West, and $124,000 to Bayside. You decided to give all $400,000 to Bayside after the election because you viewed that $400,000 as a grant that you could allocate post-election. Is that true?
No, I promised that we'd fix up Lestrange Park, and because I was told that we could make a commitment for a project.
And who told you that, Minister?
And I did it.
Who told you that?
I don't know. It was part of the Labor Party campaign. They told 93 candidates.
And after the election, who told you that you could allocate that $400,000 as you see fit?
I don't know. It came out of whoever was managing the grants.
Was it Cherie Burden?
Whether it was her or whether it was somebody else in the office, I don't know.
Well,
I mean, my office was asked for details of the election promise that I made.
So they were in contact with your office. You said
my electorate office,
and then you informed them that during the campaign you had made a commitment to Lestrange
my
Park
electorate office
football.
would have told them what the commitment was.
Okay, and all of the documents leading up to the 14th of June says that it was to be allocated evenly amongst the councils. Then it was changed. So that was clearly a post-election thing. So, Minister, will you offer an apology to the people of the City of Sydney for shortchanging them $196,000?
No.
You just think that you can change the amount of funding allocated post-election, which isn't in accordance with the grant guidelines?
I'm prepared to have you telling the people of Mascot that they shouldn't have had Lestrange Park fixed up, because that's effectively what you're doing.
So it's okay if you break the guidelines.
But at the end of the day, how's this relevant to the local government portfolio?
Well, it's money that you gave to Bayside Council as part of the local small commitments allocation. And the reality is your justification today says it's okay that City of Sydney was shortchanged $196,000. I gave all of the money to Bayside because it's a meritorious project. Doesn't matter if you broke the grant guidelines. You're happy just to give the money to Bayside because it was your favourite project.
Well, I didn't know that it broke any grant guidelines. My view is that I promised that I'd fund $4,000. You know that I had been campaigning on a particular issue. You know it's the only park that I was campaigning on, and there was a $400,000 commitment to be allocated to promises that were made in the electorate. And I won the election, and the $400,000 was paid.
Moving on to another Bayside related matter. Minister, did you ever discuss the 2024 Labor pre-selection of Bill Saravinovsky for Bayside Council with Brett Whitworth?
No.
Well, you didn't?
No.
Have no recollection? Well,
no. The answer is no.
Well, Minister, in Mr Whitworth's citizen's reply, right of reply to the Legislative Council, he said, and I'll quote to you, while the issues of then Councillor Saravinovsky's potential pre-selection, the timing of the hearings and any public knowledge of the proceedings were raised with me by Minister Hoenig, we were both clear it was not a matter that I was going to engage in as the decision maker under Local Government Act 1993. So who's lying, Minister, you or Mr Brett Whitworth?
I reject the premise of the question. You can't... I didn't discuss that with him.
So he's lying in his right of reply to the Legislative Council.
No, don't put words in my mouth. I didn't discuss Bayside Council pre-selection with him.
Have you ever declared a conflict of interest when you've been dealing with the Saravinovsky matter?
I just want to say this about the Saravinovsky matter, if I can. As you know, there is the sub judice convention that matters before the court. There are the non-publication orders by NCAT, and there's secrecy provisions of ICAC. So let me tell you what I think I can tell you, so I don't infringe any of those orders. As the committee would be aware from previous discussions on this topic, and also the testimony from the Chief Commissioner at Tsitsigos.
Just on a point of order, Chair, the question was about whether the Minister's declared a conflict of interest, not to give us a recital of different legal matters unrelated to the question that's been asked. Can the Minister answer the question?
I will actually leave that to the member asking the question. Whether
Yeah, I think for the clarity of the committee, I'm not asking about the matter that's being pursued by the DPP and potential matters regarding Mr Saravinovsky's testimony to ICAC and whether that was truthful or not. What I'm asking is whether you, Minister, have ever declared a conflict of interest regarding the Bayside matter. It's completely separate to the current legal proceedings.
I'll answer the question this way. If you're asking me, do I have a conflict in any decision, or do I have a conflict in anything I may have done in relation to the Bayside matter? And the answer would be no.
So that's even...
So that any conflict I may have had has been managed as I'm required to manage it.
Has been declared...
has been managed in the way in which I'm required to manage it.
Did you talk to anyone about the ICAC investigation regarding Mr Saravinovsky after you found out about it?
Just let me tell you what I can tell you, and then if there's anything I can tell you after that, you can at least you'll get some idea what I can answer and what I can't answer. That's why I'm being very particular, because I can't infringe. I can't infringe orders. Otherwise, you'll just get no answers. So I'd rather just tell you what I can tell you, and then if there's anything flowing from that, you can ask. You know from the evidence given by the Chief Commissioner in estimates recently that I'm limited in what I can discuss in relation to this matter. The secrecy provisions of the ICAC Act, as well as the disclosure orders, the non-disclosure orders made by NCAT in its judgment in relation to proceedings concerning Councillor Saravinovsky remain. I understand the Legislative Council was informed of the Commission's general concerns in relation to the sensitivity and confidentiality of matters via a letter from the Solicitor to the Commission, Philippa Hook, to Stephen Reynolds, Clerk of the Parliament's New South Wales Legislative Council on the 21st of May 2025. I reference a public document available by ICAC dated the 14th of August 2025, which states, the ICAC examined an allegation that from about 2016, then Bayside City Council, Councillor Bill Saravinovsky and others inappropriately or partially shared or disclosed confidential information to property developers in breach of their duties as public officials. It was also alleged that from about August 2017, Mr. Savranovsky exercised his official functions by supporting an unsolicited development proposal by a property developer. Operation Aspen did not proceed to a public inquiry or public report, and the matter concerning Mr. Savranovsky's conduct was referred to on the 14th of December 2022 to the Office of Local Government under Section 53 of the Independent Commission Against Corruption Act. Further, on the 29th of August, advice of the Director of Public Prosecutions was sought in relation to possible criminal prosecutions pursuant to Section 14(1) of the ICAC Act. The document then provides what the Commission then did. That material that was disclosed on the ICAC website was not as fulsomely conveyed to me by Mr. Whitworth, who told me sometime in 2024, I think to the latter part of the year, that he had received some material from Independent Commission Against Corruption relating to two councillors that effectively alleged what was encapsulated in what I had read. That they had received that material, they'd received it the year before. He told me what the nature of the material was. And nothing much had happened with it. And I said to him, effectively, you've got to get on with this, you can't just sit on it, and suggested to him that he brief external counsel with criminal experience, because that counsel would have the ability to be able to lead evidence in relation to the nature of that material, nature of which I can't disclose. And that was the end of it as far as I was concerned, until the following year the matter was listed. It appeared in the list for NCAT. That's during 2025, I think. 24. Anyway, it appeared in the list in 2024. It was then public that there was disciplinary proceedings. I advised the local member. I advised Labor Party officials that the proceedings were in the list. Shortly thereafter, NCAT made non-publication orders and non-disclosure orders, and I then didn't discuss it with anybody in relation to it.
So, Minister,
till after the hearing is when I became aware of further details.
So, you find out about the ICAC investigation?
No, I find out about material from ICAC that had been received in the Office of Local Government for the purpose of disciplinary proceedings against several councillors from several councils.
And you're putting together at this time, so this is in the lead up to the 2024 local government election.
No, this is well before. This is this is more than a year before that.
Well before the 2024 election, but surely in your own electorate, when the Labor Party is trying to put together its team, its council team for the 2024 election, surely this is a consideration, a factor, when you're assisting the local Labor team putting the council ticket together. Surely this is on your mind when you're putting that ticket together. Surely you spoke to people about.
No.
You didn't speak to anyone about it?
No, I told the local members when it was public, when it appeared in the list at NCAT,
right
that they should know about those matters, because they may not want to be photographed with a person or something of that nature. The Labor Party should know there's disciplinary proceedings taken against a councillor. That's before NCAT. So they were told that, but after that there was no discussion. That councillor doesn't represent any part of my electorate or anything of that nature. He's from that Rockdale side.
But he was the mayor.
Oh, not at the time he wasn't.
Order. We've now run out of time. Thank you. We now go to Mr Latham.
Thank you, Chair. Thank you, Minister, and to the witnesses. Minister, you mentioned you spoke to a Labor Party official about Sarah Vanosky. Who was that official?
I just can't remember. It would have been either a Labor Party organiser or somebody employed in the office, the party office.
It's a pretty important matter in your electorate, telling us you can't remember who you spoke to.
Well, it's not really my electorate, but it's adjacent to my electorate. It's one of the 4 councils in my electorate.
Okay. You said that you declared an interest, some kind of interest about the Sarah Vanosky matter, and then it was managed. Who did you declare the interest to?
No, I manage any conflict of interest I have in accordance with my requirements.
Who did you declare it to?
I manage my conflicts in accordance with my requirements.
What, you declared it to yourself? Is that what you're telling us?
I manage my conflicts as I'm required to in accordance with my requirements.
Well, aren't your requirements to declare it to either the head of the Office of Local Government or the Secretary of the Department?
Well, whatever my conflicts are, I have declared to the Secretary of I have done that.
And then how did you manage it? What was the nature of that conflict you declared to Ms Fishburn?
That my wife works at Bayside Council.
That's it? Not that you'd known Sarah Vanosky for over 30 years as a Labor councillor?
Well, I've known you for more than 30 years, Mr Latham, and I probably know you better.
Well, that's not relevant. That's
that,
totally irrelevant. You're dealing with someone you've known as a Labor colleague for over 30 years. I'm not in any matter on your desk.
No, Mr
So
Latham,
just relating to your wife.
No, Mr Latham, he hasn't been a Labor colleague of mine for 30 years. He's been a Labor councillor of adjoining council for me over a lengthy period of time.
Well, previously at estimates you said that. So it was just relating to your wife?
Yes.
And what's the conflict concerning her at Bayside?
Oh, just the fact that she works there.
Okay. So there's really not much to manage then in the nature of what you declared?
No, but it's something that you need to advise.
So it's on paper with Ms Fishburn. It's on paper with Ms Fishburn, yeah?
Yeah.
We don't hold the conflicts of interest for ministers, but the minister would make that known to me.
Okay. But concerning Sarah Vanosky himself, you didn't declare anything?
Declare what? The fact that I know him. I think.
And you've dealt with him in the past, and he's been a mayor covering your electorate.
Oh, yeah, I think that's well known.
Okay, but it's not declared. When we were last here at estimates, Minister, I had an outstanding question that Mr Whitworth took on notice that's been subject to a fair bit of debate in the upper house. I asked Mr Whitworth, did you as the Minister mention the Labor pre-selections and the forthcoming election, to which Mr Whitworth at the time replied, I'd have to go back and try to recollect, and he took the question on notice. Minister, what involvement did you have in producing the answer that was subsequently given to this committee on the parliamentary record?
What that Mr Whitworth gave you?
Well, I'm asking the involvement you had in the answer that came back saying the matter was listed at NCAT in April 2024, which wasn't an answer to the question I'd actually asked.
Well, I think there may well have been a reply drafted for me.
By whom?
Well, staff, or whether it came via the OLG, I don't know. But it's true.
What's true?
What you've just read out. If that be the date it was before NCAT, then that would be the date.
I asked the question that Mr Whitworth took on notice. Did Mr Whitworth have an opportunity to draft his own reply in his own words to the question that he took on notice?
I don't know. Are you talking about an answer I've given or an answer?
Well, it's the answer that came back to this committee, and you know the matter I'm talking about. Did Mr Whitworth have an opportunity in his own words to draft the answer to the matter he took on notice?
Any answer that Mr Whitworth would give that he would take on notice would come from him without it being vetted by me, if that's what you're asking.
So your evidence is that it's Mr Whitworth in his own words, his own initiative, forwarded an answer that said that the matter was listed by NCAT in April 2024.
I don't know what answer you're talking about, but if it's an answer from me, it's come from me, would have been drafted from someone else. If it's come from Mr Whitworth, he would have done it himself.
Okay, and what's your recollection of the status of that? Some ministers say that they take over all the answers that come on notice to a committee like this. The question was, did you as the minister mention the forthcoming Labor pre-selection and the forthcoming election? Mr Whitworth replied, I'd have to go back and try to recollect, and he took the question on notice. The answer then came back to us officially that the matter was a non-answer, that it was listed at NCAT in April 2024, which wasn't what I was asking. So where did that answer come from?
I don't know, but if we're talking about sometime in 2023, I couldn't see on what basis any of those issues would have been even relevant to a discussion.
No, that's not the question I'm asking. I'm asking where on the
but I don't
parliamentary
follow.
record the answer came from and how it was provided to this committee.
I don't know.
You don't know?
If it's got my name on it, I could tell you. I would adopt it as coming from me. If it hasn't got my name on it, I don't know.
Okay, well, it was a non-answer. Then subsequently on questions directly to you on the notice paper, through your representative in the upper house, questions 3522 and 3720, I was seeking the answer that Mr Whitworth hadn't given, whether it's from him or you, out of budget estimates. Who provided those answers to the upper house?
Well, they usually come via me. If they're the same things, if we're talking about the same thing, they usually come via me, but they usually come
Right, and what conversation did you have with Mr Whitworth about the nature of those non-answers?
None.
None?
None.
Would it be useful if I clarified the department's practice in relation to questions on notice?
Yes, it would be.
So when we receive a question on notice into the department on behalf of one of our ministers, the general practice in the department is that the subject area experts provide some information back to my parliamentary and government services team. All of the drafts then come through my office and are signed off by myself, and they are then forwarded to the Minister's offices. At that point, I can't tell you what occurs.
Okay, well, after the budget estimates on the matter that was taken on notice, what input did Mr Whitworth have, Ms Fishburn, to the answer that he took on notice?
I couldn't answer that question. I don't know. I've just told you the process.
Can you take that on notice and go find out? Because it's a frustrating mystery. to this
I'm
committee.
happy to take that on notice, but the process would be that information is provided by the subject matter experts. That comes to my parliamentary
So
and
you're
government
assuming it was
services
Mr
team.
Whitworth as the subject matter expert, given he took it on notice?
I simply don't
Can
know.
you go check that?
I can check that.
Please,
Yep.
check that and let the committee know. Well, Minister, in the substance of it, when did you first find out that Mr Whitworth was furnishing a citizen's right of reply to the upper house?
After he's done it.
Right, so you had no prior knowledge or discussion with him about the contents?
No.
How do you explain in his, what looks like a de facto answer to the question that hadn't been answered 3 times arising from the 28 February estimates concerning whether or not you'd raise Labor pre-selections? Mr Whitworth, on the parliamentary record now, as tabled in our chamber, has said, while the issues of then Councillor Saravinovsky's potential pre-selection, the timing and the hearings and any public knowledge of the proceedings were raised with me by Minister Hoenig, how do you explain the fact that you're denying something that your head of Office of Local Government has furnished to the Parliament as a matter of fact?
I can't, because I would not have even had those discussions with Mr Whitworth.
Mr Whitworth says you raised with him the question of Labor pre-selection for Saravinovsky, which would have been judged as an abuse of ministerial office. When did you do that?
To my recollection, I never did.
Have you got...
I effectively never discussed the issue with anyone at all until after the hearing.
How do you explain that the head of your Office of Local Government has told us on the parliamentary record you in fact did do that?
I can't.
Have you had discussions with Mr Whitworth about that particular matter?
No.
You never had a discussion with him about answering the question out of the last budget estimates?
No.
Well, how did that answer arrive on
I
our
don't know.
parliamentary
You'll have to
record?
ask him.
You've got no knowledge at all, that's your evidence, of how the non-answer arrived for the matter Mr Whitworth took on notice from the 28 February budget estimates?
No.
Are you embarrassed by this?
No.
Have you got full confidence in Mr Whitworth, given he's told us something that you're saying didn't happen?
I have the highest regard for Mr Whitworth. He is a experienced for the 30-year public servant, of award-winning public servant, and I'm terribly grateful to the previous government of having left him to me. And I find really the allegations that are made against him to be generally to be pretty contemptible, really, Mr Latham. Attack me if you like.
Well, I am. I'm trying to get answers from you. So if Mr Whitworth has that character reference, you'd believe he's telling the truth in his citizen's right of reply?
I'm not going to, I can't comment on somebody else's evidence or their recollection.
Have you always found, as a public servant...
I can only tell you what's on mine.
As a public servant serving you, Mr Whitworth always tells the truth?
I've got the greatest confidence in Mr Whitworth.
So why then would he be saying something that you're denying?
Well, you'll have to ask him.
Thank you. Dr Con.
Thanks, Chair. I'd like to come to the Local Government General Amendment Tendering Regulation. And I understand since that came into effect, there have been a number of meetings between interested stakeholders and the Office of Local Government,
Yes.
with discussion of some potential amendments to that regulation.
Yes.
Where's that work up to?
Mr Whitworth, where we're to with it?
We are still finalising some of the last bits of engagement with some of those stakeholders. We have commenced the process of instructing Parliamentary Council for the regulation, and we hope that it will be gazetted shortly.
Okay. Can you provide us any more accuracy than shortly?
Days,
weeks, months?
Hopefully months, hopefully less than months, but we'll appreciate Parliamentary Council has had a number of significant challenges on its plate when Parliament sits, and we have had a number of bills put in front of it as well. And we have, it has been a bit of a challenge to pin down some of the more challenging details associated with the industrial relations component of the provisions.
Okay. Thank you for the update, and I look forward to seeing those amendments. Minister, I wanted to ask you about delegations of authority by councils to senior staff, and particularly to general managers and CEOs. Notwithstanding that there's obviously a huge variability in budgets and operational plans for councils, and it probably wouldn't be appropriate for the City of Sydney and Greater Hume Shire Council to have the same delegation to their general managers. Do you see a role for yourself or the Office of Local Government in providing guidance about what an appropriate limit on delegations of authority should be?
I've not thought about that before, but I think it's a worthwhile suggestion, because part of the local government culture that I'm seeking to change is to actually empower councillors to take greater control and responsibility for their decision-making roles. And so and I don't like to tell councillors what to do or what they should delegate or what they don't. So I'm not sure, but I'll give that some thought, because you've obviously got some experience that councils have given too much delegations, and that's causing a lack of transparency in decision making.
Thank you. I appreciate your willingness to consider the matter, and I suppose if I could put a couple of examples to you that have been brought to my attention. I understand that the delegation at Central Coast Council is double the delegation at the City of Sydney Council.
Financial delegation.
Sorry,
financial delegation?
To be clear, yeah, this is financial delegation.
Sorry,
there
just
actually
for
is a dollar value.
Yep.
Thank you for checking. So this is, in terms of the council engaging in tenders or contracts, etc. Central Coast Council's got a limit of $10 million, which I understand is lawful, but for some people doesn't pass the pub test. City of Sydney, for example, has a delegation of $5 million.
Yeah. I'll have a look at it, give it some consideration. I understand. I understand the point. You can't ensure accountability because you delegate the authority, but you don't delegate your responsibility. But the fact is, if you can't see it, you're responsible for what you can't see. So I'm pretty conscious of one of the things that I've started to notice, particularly with those large amalgamated councils, is that the council meeting folders are becoming huge. So apart from anything else, they're having a lot of material buried away in voluminous material. It's not quite as bad as a cabinet agenda, but it's getting that way. So I just, and they're also meeting monthly, and they're not meeting, and they're not having committee meetings as they used to have, so that they could distill their matters at committees before councils. So I'm hoping the changes through the code of meeting practices might, I mean, it'll require greater time from the councils, but I'm hoping that might that might break everything down a bit. I'll have a look at that. I think it's a good suggestion.
Thank you. Look, I appreciate your consideration of the matter of the financial delegations. You've segued into the code of meeting practice, and I had a number of questions about that anyway. Specifically to the question of pre-meeting briefing sessions, and you certainly have the enthusiastic support of the Greens in banning the closed-door confidential briefing sessions where that's not under the terms set out by the Local Government Act. I'm aware that it's the practice of some councils to have a pre-meeting briefing session for councillors, which include, for example, presentations from relevant council staff about design options for a building, or presenting results of community consultation, etc. And that can be done in a public forum in the council chamber, webcasted. Is it your intention with the new code to also ban pre-meeting briefing sessions where those are actually available and accessible to the public?
Yeah, there's some reasons for that, apart from transparency, and that is that councillors, they can have the same setup by actually formally having a committee meeting of the council. They can do. Councillors' only lawful authority is when they collectively sit either as a council meeting or as a committee meeting, collective function. That's when they have their statutory power, their responsibility, more importantly, where the councillors actually have control of their proceedings and can actually determine, for example, under section 10A, 10B, 10C, etc., whether or not matters are confidential and the press and public be excluded for sensitive matters. Absent that process, then there is no power that I can think of that makes those documents confidential or sensitive just because you say it is, unless the statutory processes are followed. So if you keep councillors doing what they're legally required to do, collectively determining their process, they don't all have to be on a committee, they can divide themselves up if they like the different committees, then you have them performing the functions that they're elected to perform. I mean, if they want to go away for a weekend and go and have some presentation about future planning workshops or something of that nature, that's fine. But this issue of corralling the councillors before a meeting and house training them to make a decision when they walk in the meeting, and it started in Albury, would you believe, about 14 years ago, and it was sort of just as a mechanism to avoid public scrutiny, and it just mushroomed from Albury.
I'm delighted you brought up Albury, because it was in my term of council that we made those briefings public, including webcasting.
Yeah. The man never told me that it was your instigation, but he certainly told me that they changed it and made it public. But I want it done by councillors that are lawfully sitting collectively as councillors, where they have the authority to make decisions and to control their proceedings, rather than. And the other issue is that council staff are easily influenced by views of councillors because effectively they work for them, and sticking, say, town planners behind closed doors with individual councillors who might have a view about a rezoning shouldn't occur behind closed doors. They should be
There's
public.
absolutely no disagreement from me
Yeah,
on that
so-
point,
so that-
Minister. I suppose what I'm getting to is if the councillors wanted to receive information and have a discussion in advance of having to make a decision, for example, because the subject matter is complex or lengthy and they might only have 3 days with a business paper, could they then, under your new code, invite staff to make such a presentation to a committee meeting for discussion and questioning without a decision?
The council can at any time resolve itself into a committee of the whole, for example, and the benefit of doing that is that you don't have to stand up when you speak and you can speak multiple times. So it's not unusual for a council, even in my time, to resolve itself into a committee of the whole so it can carefully examine something. So you don't need to call it at a separate time.
Thank you. The opposition?
Thank you. Minister, go back to Bayside. Upon hearing that Mr Saravinovsky was under investigation by ICAC, did you mention this to former councillor Joe Jansen?
I didn't know that Councillor Saravinovsky was under investigation by ICAC. I knew he had been from the nature of the material that Mr Whitworth had told me that the OLG had received.
And did you mention that to Joe Jansen?
I don't think I mentioned it to her, but she worked in my office at the time. She may well have been aware of that. Well, may well have been aware of what was occurring, like other members of staff were.
How would she have been aware?
Because your staff are aware of what goes on in your office.
So she overheard it or something?
Well, whether she did or whether she, it wasn't something that was, what was occurring was not something that was withheld from staff. You just expect confidentiality, that's all.
Is it your understanding that Joe Jansen then informed Labor headquarters that Mr Saravinovsky was had a matter currently being looked at by ICAC?
I don't know what. I would have been disappointed if she knew, and if she told anyone, I would be quite disappointed. Quite disappointed.
Did you talk to David Dobson at all about the nature of the ICAC matter into Mr Saravinovsky?
I don't know which Labor Party official I told that proceedings were before NCAT.
And what about ICAC?
No, I would have said matters are before NCAT. Disciplinary proceedings have been commenced before NCAT. And really, after that, I didn't discuss it with anyone really because of the non-publication orders.
And you don't remember who you had that conversation with at Labor head office?
No, I don't. I just wanted to discharge the obligation that I told them.
Did you talk to the Premier at all about this matter?
No.
You talked to Minister Camper?
Well, he was one of the local members I told.
And did any of the conversations you had regarding either NCAT or ICAC involve dumping Mr Saravinovsky from the Labor ticket at the 2024 council election? Did you discuss it at all with other Labor candidates at the time?
No.
Ed McDougall, Soraya Kasim, Joe Awada?
No.
And did you ever talk to Mr Saravinovsky about it?
No.
Did you talk to the General Manager of Bayside Council about it?
No.
And when were you first made aware that Mr Saravinovsky was going to be dumped from the Labor ticket for Bayside Council?
I was never made aware that he was dumped. I was made aware that his son was was taking his place.
Do you remember when?
No, they were all shortly before the local government election, I
Do
think.
you remember who told you, or how you were made aware?
Yeah, it was a Labor Party circular.
Right. And do you sit on Labor's admin committee?
I do.
As the Premier's representative?
Yes.
Did this matter come to the admin committee?
What came to the admin committee was the results of the nominations of candidates.
Like the final
for
ticket
for endorsements of all the councils come to the admin committee.
So like the final ticket to endorse, essentially?
Yeah.
Did you declare a conflict of interest when it came up?
No, why?
Well, because you're the Minister for Local Government, you had intimate knowledge about what was going on regarding ICAC and NCAT, and the ticket that was put forward had Mr. Saravanovsky dumped from it.
Well,
It's also your own council.
well, it's one of 4 councils. I mean, there's some 50 councillors that represent my electorate. I know them all. There would be 5, there would be 3, 15, and there would be about 52 or 53 Labor Party candidates that are vying for pre-selection for various councils in my electorate. So the names come up on a sheet as to who happens to be the candidates or not on an administrative committee list. What's the problem?
Well, you're the Minister for Local Government.
So-
You have governance capability for all of the councils across the state. A
Yeah.
ticket comes forward that you had in-depth knowledge about the reasons why certain people were no longer on that ticket, and you didn't think it was a good idea to declare that you're potentially conflicted in that regard,
Well,
given
well,
all the relationships that you had, given as you said before, your wife works on the council, you have all of these relationships, you didn't even think it was a good idea to declare a conflict?
I don't accept the premise of your question, really.
Well, what bar do you think, or what do you think is the threshold for declaring a conflict, whether it either be at Cabinet or at the Labor Admin Committee or in decision making? It seems that whether you have decision-making powers and extensive relationships doesn't seem to reach that threshold to you.
Yeah, well, I mean, in any event, those are matters for the ALP, not for this committee.
Yes, Minister, but the issue is that you are the Minister for Local Government. You also sit as the Premier's rep on the admin committee. Does the information that you receive as Minister for Local Government influence the decisions that you make on the admin committee?
No.
And do you ever report any issues regarding your portfolio as a Cabinet Minister to the Labor Admin Committee?
No.
Minister, are you aware, or what is your understanding of what happened to the previous proposal for the Boulevard car park in Brighton Les Sands, which was awarded to Boulevard Oasis Proprietary Limited?
I knew nothing about it at all until after the NCAT hearing. Absolutely nothing about it till after the NCAT hearing. And I can't say any more than that.
Were you aware that the current General Manager was aware that the proponent was the brother of a sitting councillor, Councillor Tarek Ibrahim?
Because of the variety of secrecy provisions, non-publication orders, I cannot either confirm or deny anything you're asking me about that.
Right, fair enough. Minister, would you consider a 20% increase in ministerial office expenses in 2024-25 a good use of taxpayer funds?
Yes.
You've got a government at the moment that's slashing public servants, reducing cost of living support, cancelling projects across the board, but you think it's a good idea to increase your own staff and expense budget by 20%?
Well, I don't know. I mean, you could probably go and ask all those councillors that I've been visiting on the road, all who want to meet, or who want to meet with me, or want me to visit, and ask them whether or not they appreciated me going, or whether they would prefer me to cut back on expenses and sit there in Sydney and not go and examine their problems in rural and regional New South Wales.
20% increase.
Was any of the budget used for developing social media content?
Budget. Were some of the staff utilised to assist me in social media content? The answer would be yes.
Have you ever used a private jet since you became a minister?
A private jet. Is that like chartering a plane?
Yes.
Yeah, I think the community cabinet went to Broken Hill and we all went on a chartered plane. I'm not doing that again because it costs 3 times as much to go on that thing out of my budget.
Is that the only time that you've used a private jet since becoming a minister?
Yeah.
How many ministerial staff are currently local government councillors?
Ministerial staff, none. I think. None. It is none, isn't it?
In your office, no.
Yeah, I haven't got any.
What, no, across the ministerial staffing pool.
None.
No ministerial staff across all of the ministerial offices.
In all the ministerial, I wouldn't know. I can only tell you who's on my staff.
None on your staff, but there are councils that work for the Mins government in ministerial staffing
Oh, well, I imagine so. I mean, I know one of my mayors.
Your local mayor.
Two of my local mayors work for ministerial staffers. Ministerial staffers. 2. Who's the others? The other one's Clover Moore. Yeah, I think 3 might be working in the political process. 2 might work for state ministerial staffers.
Are you confident that they've all declared conflicts of interests when matters have arisen?
Well, I don't know. They all do pretty good jobs, so I would be surprised if they didn't.
Why did the Mins government reverse the previous coalition government's directive of not employing councillors as ministerial staffers due to inevitable conflicts of interest arising?
I can't answer that question. You probably have to ask whoever made the decision, but you know, I mean, I'm facing this difficulty actually within the local government sector itself over conflicts of interest, whereby so concerned are councillors they're almost in paralysis from making decisions because they happen to know somebody or that they've gone to some football presentation and maybe they should have a conflict of interest. I think you can create paralysis by that. I mean, effectively, these conflicts are to avoid corruption or undue or improper influence. Just because you know somebody, that doesn't create a conflict in itself. Otherwise, you'd never be able to make any decision. And that's the sort of paralysis in some parts, particularly rural New South Wales, that's occurring with some of the councillors.
But you say you're a ministerial staffer advising the minister on a policy area, and an issue comes up before the minister about, say, funding in a particular council area that you happen to be the councillor for. Surely that's a conflict.
Yeah, well, if you regard that as a conflict, then you manage it, don't you?
Yeah. How should that be managed?
Well, you would declare it and remove yourself from the decision-making process if you were publicly perceived as getting a benefit from it. Sometimes you just declare it and just so that people know that you know somebody. Otherwise, you create paralysis. I mean, if I were to declare, I was in local government for 30 years before I got elected here. And I mean, as I'm moving around the state, I'm catching up with people. There's 1,276 councillors. I probably know about 500 of them. Mm-hmm. So, you know, just because you know somebody, it just doesn't mean that there's a conflict.
Was your advice sought when the decision was made to allow ministers to employ councillors?
No.
Was Office of Local Government's advice sought?
I don't know.
It's
No.
not
No.
a question
No.
for the Office of
It
Local
was
Government.
a decision presumably made by the Premier or the Premier's office.
I don't know. You have to ask them.
In terms of meetings, you've said you've met with lots of councils across the state. How many councils have you met with?
Oh. I'll tell you. I've got a list. Albury, Armidale, Ballina 2 times, Balranald, Bathurst, Bayside, Bega Valley, Bellingen, Blacktown, Bogan 2 times, Burke 2 times, Warriner 2 times, Broken Hill 4 times, Burwood 3 times, Byron, Campbelltown, Canada Bay, Canterbury, Bankstown, Central Darling 6 times, Central Coast,
Minister,
Cessnock
over
2
what
times,
period is-
Newcastle 2
over what
times, City of
period is this?
Parramatta, City of Sydney 4 times, Clarence Valley 2 times, Cobar 2 times, Coffs Harbour, Cootamundra Gundagai 4 times, Eurobodalla 2 times, Edward River, Federation, Forbes, Goldfields Water County Council, Glen Innes 2 times, Gunnedah, Greater Hume, Gwydir, Goulburn, Inverell, Hay, Hunters Hill, Kyogle, Kempsey, Lachlan, Lake Macquarie, Lane Cove 2 times, Lismore 2 times, Liverpool Plains, Lockhart, Maitland, Mid-Coast, Moree Plains 2 times, Murray 2 times, Narromine, North Sydney 2 times, Penrith, Port Macquarie, Randwick 5 times, Richmond Valley 2 times.
Minister, over what time period is this?
2 years.
And
I've got more.
over
Rouse,
Can you table it,
Rouse County Council.
Minister, maybe you could table that since.
Oh no, I think you should hear them all so everybody can hear it. Singleton, Silverton Village, Snowy Valley 4 times, Strathfield, Temora 4 times, Tenterfield 2 times, Tweed 3 times, Upper Hunter 3 times, Upper Lachlan 2 times, Urella, Wagga Wagga, Walgett, Walker, Warren 2 times, Warren Bungle, Waverley, Wentworth 2 times, Windsor Carriby, Wallandilly, Yass Valley. That's 80 councils.
And Minister, did you personally draft the changes to the local government code of conduct yourself?
No,
You obviously sought advice from OLG.
no, the code of conduct is not just a code of conduct. There are a number of parts to it. So do you want me to tell you what those parts are?
No, that's okay, Minister. What I would like to know is, with the Land and Environment Court, which is now part of the new process, what is the threshold to make a claim before the Land and Environment Court? Obviously, as you said, it's a superior court. I think you've said in the media release that it is matters regarding to misconduct, but what is that threshold? I assume it's quite a high threshold to go to the Land and Environment Court.
No, I've actually provided for a public interest test. So, because it is a superior court and its rulings will be law, I've given the court a pretty broad public interest test. So if you want to seek disqualification, suspension, fine, restitution, those would be the orders that you would seek, and the test that the court would apply would be a public interest test.
So, as an example, on the 30th of July, 2 councillors at Cumberland Council got into a screaming match that went viral. You're probably aware of that particular incident. Well, I suppose, firstly, are you aware of it? And secondly, is that the kind of thing that would go to the Land and Environment Court, or does that not meet the threshold under the test that you've set?
I would think that under the new code of meeting practice, the matter wouldn't have gone that far.
Because the mayor would have booted the councillor out?
Yeah, and the mayor would have known to sit the councillor down immediately as soon as he said something that he shouldn't have said. It's just part of that cultural change. So you nip all that behaviour in the bud by the code of meeting practice.
Isn't there a risk, though, that you could clog up the Land and Environment Court with personal disputes between councillors? And shouldn't the court be focused on more important matters?
No, I've talked to the chief judge about that. I don't think so, because there are leave. They would. It's like the Protection of the Environment Operations Act. You'd need to get leave if you were not a statutory authority or a minister commencing proceedings. So the court would be able to filter that out, and that prevents the vexatious litigation. There'll be another mechanism for minor matters, and that's that suggestion Mr Whitworth had, which requires legislation, which will be a privileged committee of former experienced or current mayors that sit there and deal with the relatively, minor matters.
Thank you. We now move to questions from the government.
Only one. Minister, are there any matters on which you wish to listen?
Maybe just for the committee to have some understanding about the code of conduct process. Everybody uses the code of conduct like it's a single type Bible that is solvable. The process is firstly multi-stepped process. So firstly, to prevent people from ignoring the right of political communication by doing a guideline. Secondly, was the Land and Environment Court process, so that there was a mechanism whereby effectively the government can take poor behaviour and get people out of local government to preserve it without going through the convoluted process. Then there is the code of meeting practice, which is effectively, it's a bit like going back to the future, like the old Ordinance 1 and old local government meeting regulations, whereby the mayor will take control of the council meetings and whereby their proceedings will be transparent, removing the general manager from the political processes of the council meeting to try and have the general manager removed from getting involved in the political processes. Then there are the pecuniary interest provisions, which I've extracted to go bulk of that into a regulation, which will be similar to the constitutional regulations that will be modelled on the constitutional regulations, which shortly will be which will shortly be regulated. And the delay in respect of that has been that the Privileges Committee of each House has had a different view as to what should be in that regulation, as did the Chief Commissioner of ICAC. So the two Privileges Committees and ICAC they've come to an accommodation. The government's come to an accommodation, so now I'll be able to regulate on that basis. I think the only dispute is, I think the Legislative Council and the Legislative Assembly have different views about private disclosures, because you're going to need to have private disclosures. But anyway, the regulation's ready, and that regulation will do what Ms Mihalich asked to do, and that is to have overseas property ownership required to be declared, and will also pierce trusts, so you won't be able to hide beneficial ownership behind trusts. So, and then there is the code of conduct, which is hopefully a slimmed down version, which will be divided into two, one for staff rather than having one for staff and councillors, and they're now sitting on my desk waiting for me to get to them. They've been drafted by the OLG, and I've just got to go through that carefully, because I don't want to hamstring councillors with micromanagement of words. I'm just trying to get it simple. I mean, because these are generational changes. They're not going to, it won't happen again for some decades. So I just want to make sure I get it right. and I just want to say about, and the reason I need to go through it pretty finely is that they have these rules that restrict certain things of mayors and councillors in the previous code, but it also restricted administrators, so that when you had a council sacked, the administrator goes in. The administrator goes in, you think, with executive authority to clean the place up, but he actually doesn't have that, he or she doesn't have that authority because the code restricts the authority of the general manager. So if the general manager is the problem, then the administrator just can't get to the cause of the problem. So I've just got to be, the last jigsaw puzzle, the last piece of the jigsaw puzzle is actually sitting on my desk, and I've just had not time to get to it. Hopefully, they'll all be in place by the 1st of January. That's the ambition. But the time's not been wasted because, as you can see from all those people I've met, the government can regulate, it can legislate, but it requires a cultural change, and you've got to take them with you. I'm not saying anything different now than I was 2.5 years ago. 2.5 years ago, they were complaining about everything I say. Now they pretty well, I've pretty well taken them on this journey, and so I think it's going to have a pretty dramatic increase. I've just got to be careful, is I can't prepare rules just for 4 or 5 councillors that misbehave when there's 1,276. So, and I think that will at least fix that issue up, which has been a major source of frustration, I think, to everybody.
Thank you.
If there are no further questions from the government, we'll break for morning tea. We'll be back at 11:15.
Thank you and welcome back. We will start with further questions from the crossbench. Dr. Amanda Conn.
Thanks, Chair. Minister, the submissions to the Companion Animals Act discussion paper closed, and the last update on the OLG website was that the government's now analysing the submissions and formulating the next steps of the review. Do you have an update on that work?
I'm sorry, I didn't hear that. Could you ask that again a bit louder, please?
Yeah, I'm asking about the Companion Animals Act review discussion paper and where that work is up to.
Mr. Webb, what's that up to?
We have been compiling the submissions, reviewing them, going through the normal process so that we can prepare to put them on the website. We also have a draft submissions report that has been prepared, which we hope to release shortly. As I've been saying to the team, now that we have a number of the inquiries have come and reported, including the cat containment inquiry, we're very much at that point to try and pull together the key themes and the reforms and the next steps of action.
And can I just clarify part of your answer there?
Sure.
Is it your intention to publish the submissions that you received to the discussion paper?
Yes.
Thank you.
Quicker than the last lot.
Sorry?
Quicker than the last lot in relation to the Code of Conduct.
Excellent.
I can tell you, Dr. Conn.
Thank you. The 2025 cost shifting report from Local Government New South Wales made a number of important findings, but one of them was the net costs in managing companion animals being a relatively significant increase. There's obviously really significant community interest in the ability of councils to discharge their responsibilities in this space appropriately. How are you supporting local councils to manage the increasing costs of this work?
I think ultimately you'll probably have to wait for the government's decision in respect of the Companion Animals Act and the POCTA Act, which I hopefully can be done in parallel with each other, because there's a number of policy decisions that have to be made along the way, and they're all going to be interrelated, and they're all quite difficult to land on.
So for councils struggling financially to meet their current obligations, they have to wait for the review of the legislation for financial support?
In this area, so I mean, you're talking about what financial support for pounds? Is that what you're talking about? They've got an obligation to provide pounds. They're given back at about the 8.5 million that's taken for pet registration fees. They get back about 6.5 million of it. Pounds are their responsibility, but as you know from the Pounds inquiry, they're at capacity. The government outsources its POCTA responsibilities, which are not my portfolio responsibilities. If the Pounds aren't managed in accordance with animal welfare standards, so and the councils don't want to take any more into their Pounds because otherwise they might infringe those standards. So there's just so much work got to be done in this space. I'm struggling with a variety of solutions. I'm conscious of the problems, but I'm struggling with the solutions.
I just wanted to come back briefly to City of Parramatta, which we touched on this morning. It's also been reported that City of Parramatta spent over $4 million in payouts to staff over about a 3-year period, including non-disclosure agreements with staff who were terminated. What access should councillors have to those sorts of arrangements when you're looking at costs like $4 million? Surely councillors should have access to that kind of information in terms of their strategic planning for the organisation.
Without signalling out Parramatta, because ultimately the councillors have the authority to force the production of whatever they want to force production of, in my view. And where the code, which is given regulatory force, prevents that from happening, that's one of the matters that I want to ensure are fixed. So there has been a culture, this is part of the changes, that's why they're taking so long. There has been a culture whereby somehow or other councillors have been marginalised to think that all these things are all just determined by the general manager. Some of them have given themselves a self-appointed title of Chief Executive Officer, where the Act only provides for general managers. And I've got to redress that balance, but I've got to work a way to address that balance that that enables proper scrutiny, but is not open to abuse. But so as far as Parramatta, I don't want to single out Parramatta, but I just want to say that generally, the point you're making is well founded.
It's not my intention to single out Parramatta either, but it's
No,
a timely example for
but I don't want to single out.
issues.
I don't want to be seen as a minister of local government singling out Parramatta in respect of something that I think is a cultural issue.
Sure. While we're on senior staff, Section 333 of the Act, which relates to the review of the organisation of the structure of the organisational structure of a council. When it says the council must review and may redetermine the organisation structure within 12 months after the ordinary election of the council, is it your understanding that that refers to the councillors as in the governing body, or the council as the organisation run?
No, the councillors as the governing body, they determine the structure. And Brett's got a different view, but that's never been my view since 1993, and my view will prevail, and if it doesn't prevail, I'll seek to amend the law to ensure that it does.
Thank you. That's a helpful clarification. We were talking earlier this morning about councillors having access to complete information in making decisions, and you indicated that withholding material from decision makers isn't appropriate, and I agree with you. I'm aware of a number of instances where mayors and general managers have been able to access advice through either the Office of Local Government or Local Government New South Wales, but councillors are then not given that advice or not given the opportunity to seek their own advice. Would you consider extending that kind of information or informal advice to all councillors?
Look, I happen to have sent to me, probably by somebody who is making a complaint, this detailed opinion given to them by obviously a very smart employee of the Office of Local Government as to what a two-page single-spaced email about what the solution of a particular issue was. I'm always on Mr Whitworth's back about getting stuff back quicker, and he doesn't say it to my face, but he probably complains to Ms Fishburn that I've got unreasonable demands in terms of speed of things getting done. But I'm not comfortable with utilising the resources of the Office of Local Government providing that type of advice that I saw to whoever got the provision of that advice. Local councils are members of the local government of New South Wales, whose function it should be to provide them with that level of advice. It's a different story altogether if it's a regulator function. So if it's a function of the regulator, say, to approve something or to monitor something, you know, maybe financial, it might be permission to borrow against reserves, it might be that to do something may be said to be unlawful in terms of to achieve an objective, and the OLG or the regulator. It's a different thing to be providing, you know, detailed advice on how to chair a meeting or how to, you know, how to deal with a problem councillor or, you know, that sort of thing. It's just, I'm not sure that's their function. I mean, I've not applied my mind to a whole range of what they may be doing, but I think some of that stuff should be going to Local Government New South Wales.
And in the instances where that advice has been provided or does exist, and it's been given to a mayor or to a general manager, is it your view that all councillors should have access to that advice if it relates to a decision they're being asked to make?
If it's a relevant issue that is needed for the decision-making process of the governing body, then they should have it. And you probably see that I've incorporated in the Code of Meeting Practice a requirement that if a councillor wants specific information prior to a meeting, that information given prior to a meeting is available to everybody. I think that's just the way the council should generally operate.
Thank you.
Thank you. Minister, in the last round, I was asking you about the pet registry, and I know people were talking about the fact that the funding for the pet registry has now gone to complete the work that needs to be done in regards to the puppy farming legislation. Are you aware that the Office of Local Government has been trying to get funding from DPERD to ensure that that work can be complete? And at this point, I did ask yesterday in the budget estimates for agriculture, and I was told that DPERD are providing some money, but it's unknown how much or when that will come. I know that's been causing the Office of Local Government a lot of stress because they're having to try to find the funding for this aspect of the puppy farm bill. Are you aware of this and what's happening now to support the Office of Local Government while this funding hasn't come through?
I think Ms Fishburn's been working on that, so she can give us information.
Yes, thank you, Minister. So there have been discussions ongoing with DPERD about a contribution to this particular work. I've discussed it with my counterpart, the Secretary of DPERD, and we're just working out the final logistics of it. There's no dispute, it's absolutely fine.
Okay, thank you. Minister, have you spoken to Minister Moriarty about this at all?
I don't recall that I have. I've spoken to her about some. No, I don't think so. Not this issue.
Okay. If this issue isn't resolved in the next, few weeks or so, is that something that you're willing to do?
Yes.
I will be resolved in the next few weeks. I can assure you of that.
Thank you.
Yep.
Thank you, Ms Fishburn.
And I can confirm from our end.
Great, thank you. No, I appreciate that. Minister, last week I tagged you in an Instagram video posted by the Real Housewives star and Bondi vet, Dr. Kate Adams. In the video, Dr. Kate Adams talks about the fact that yet another stray cat has been dumped outside of her vet clinic. She indicates that she called the council pound, who refused to take the cat. She called every rescue organisation, who was told, of course, that they're all completely full. And this left her in the absolutely awful situation that many vets are faced with, where they have to deal with the emotional burden of euthanising a healthy cat or releasing the cat into the wild, not knowing what would happen to the cat or what will happen to wildlife. This is happening to vets every single day. These are very small businesses. Even where they euthanise that cat, obviously it costs the business money as well as the emotional burden. The cat overpopulation crisis is not really the responsibility of vets and small business owners, as I'm sure you would agree. Minister, what is your response to Dr. Kate Adams and to every other vet out there who is dealing with this heartbreaking situation every single day?
Well, thank you for the tag. I haven't actually seen it, but I haven't actually seen it. We have to, according to the pet registry, there's 1.5 million dogs registered and there's 500,000 cats. I don't think 500,000 bears any semblance to the amount of cats that are actually out there. And whilst I would like to be in a situation whereby we have sufficient pounds, we have sufficient rehoming organisation. And I say this, I don't know, have I announced that funding yet for rehoming?
Not yet.
Not
No,
quite.
Okay.
Not
Anyway,
yet.
you know,
I'm more than welcome to do it now.
yeah. Those rehoming organisations are just remarkably successful. They're rehoming something like 70%. If you tell somebody who doesn't know anything about this space, they wouldn't believe that they're being so successful. There are so many decisions that have got to be made in this space in relation to cats. You know about the chaired the committee of cat containment, and I read what you published today in your op-ed. The funding is needed at some point for a desexing scheme for what some call community cats, others call feral cats, because just simply catching them and euthanising them is not necessarily a solution either. So funding is needed for that. A coordinated approach in respect of pounds, in relation to enforcement, in relation to how much revenue you can derive through registration, what level of regulation do you apply, if you apply certain levels of regulation, is there a cost, and therefore does the cost of that regulation become and registration become a deterrent to low socio-economic sections of the community who want the benefit of pets? I just think it's. I just think it's a very complex area that I don't have a solution for.
And I totally appreciate that it's a very complex situation. But I guess my question to you is, what is the government doing right now to actually support these vets that are now at the forefront of having to deal with the homeless cat crisis that we've got in New South Wales? At the moment, obviously there's no quick, easy solution, but they want to make sure that action is happening so that they can see an end to this at some point. And I just wanted to get from you an answer to those vets. What is the government doing right now to urgently begin to address this situation?
Look, I don't want to use this terminology to put you off, because I very much value your advocacy in this space, because without your advocacy we wouldn't have achieved what we've achieved. So I concede that. So, and the trendy buzzword is whole of government approach, and that's often used to push something away. And I'm not pushing you away, but I am saying to you that I'm conscious, and I'd like to make interrelated decision-making processes at a similar time to the POCTA legislation with the Companion Animals Act, come to a resolution about what sort of registration fee we apply. I'd like to be convinced that community education campaign where funding's going does actually work, or whether it doesn't work. I'm told it does, but it may well be the only option, because no one sees another option. I can just tell you that I get it. I see the problem. I don't have an immediate solution. I know everything's incremental, but just ask the vet to be patient. I get it. I just don't have an immediate solution. I mean, I can't even. So I'm not sure what to do with cat containment.
I guess, Minister, I mean, with that comment about asking the vet to be patient, what do you think vets in this situation should be doing right now? If the council won't come and pick up stray cats, if they can't rehome those cats because the rehoming facilities are all full, if they don't want to euthanise that cat because of the emotional burden, what do they do in these situations?
Well, with the Companion Animals Act review, the current Companion Animals Act that hasn't been looked at for 20 years doesn't apply to dogs. So if a dog's running around the streets, they can be possession. With the Companion Animals Act, there'd be an expectation, I'd imagine, from the community, and not an unreasonable one, that the same would apply to cats as well. That would be seized wandering around streets. I haven't got a finalised view, but I just think that that's probably reasonable, and that means that there are going to be more cats picked up and taken to pounds. So the problem's going to be exacerbated. But I suppose if the council's picking up the pets, it's bound to take it to a pound, isn't it? Because it's picking up the cats.
Have you heard, Minister, that the RSPCA are now also refusing to take stray cats? And have you heard any feedback about any additional burden on council pounds since, because I know some pounds do take cats and some don't. Have you heard about additional burden on these council pounds that do take cats since the RSPCA has
I don't know
announced?
whether the burdens are specifically in respect of that, but as you know from the pounds inquiry, the pounds have been significantly burdened really since after COVID.
Thank you. Opposition?
I was just, Chair, just on a point of order, I was wondering if we could have a very short deliberative. I know, sorry to do this, but there's an issue I think we need to discuss very briefly. We're happy for it to come out of our time, but we do.
No, that's fine. I think that's fine. Thank you. I'm sorry, we're just going to have to go into a short deliberative. If I could ask everyone to clear the room, and the Secretariat will contact people when we're back on. Thank you.
been made aware, but I guessed.
Thank you. The Honourable Nicole Overall.
Indeed. Minister, as such, quite fortuitous perhaps, I'd like to go to the newly released Code of Meeting Practice for a bit of a more in-depth chat about that. Will be as professional as I always am. It is good to see that it is, particularly in circumstances that we've witnessed here this morning, but even the ICAC Commissioner has stated his clear concerns in the fact that it's taken 2.5 years to be done. Why was he so concerned about the delay?
I suppose that's something you'd have to ask him, not me.
So he hasn't expressed to you.
I can't speak for him. I just want to say this, that when I became the minister, the OLG had 45 people in its office. Had a Auditor General's report was the first thing presented to me, saying that the organisation was not capable of doing or discharging anything, and there had been substantial failings. That's what I inherited, and when I go back and look, it had been like that for more than a decade. So what I worked out was that when my predecessors were supposed to do something, they didn't have the staff that were able to do it, so they'd just get a consultant's report, and that would be how they would manage to do it.
So you've increased staffing levels, Minister?
What's that?
You've increased the staffing levels of the OLG?
Yes, substantially. So
what numbers are you looking at now? If you said 45...
at the moment, I'll tell you exactly what they are at the moment. At the moment, including parliamentary and government services, they've got 101 employees.
And that's up from 45?
That's an increase of 31 employees compared to the 1 year earlier. And once all positions are filled under that new structure, they'll have 129. They'll have 129 staff members.
Okay, that's great. So more resourcing for the Office of Local Government.
So what I'm saying to you is, now I was able to get 9 million from the Treasury in the first year to try and add capacity to the Office of Local Government. It was given to me conditionally upon the Greater Sydney Planning Commission going, but very few people would take positions for 1 year's worth of funding. So the following budget, I got 37.2 million from the Treasury for funding for a 3-year period, and Mr Whitworth has been restructuring, and Ms Fishburn have been restructuring the department and the office, and they've been equipping themselves.
I get it, that's
great. The only reason I'm telling you that is that when it's taken longer than I wanted it to take, it was an internal capacity issue that we were building.
Okay, so
right,
it wasn't that it was sitting on your desk, Minister, it was the internal capacity to deal with it and provide what was required.
And as I said before the break, what you refer to as a code of conduct.
I'm aware.
There's a number of other steps.
I'm aware of how it works.
Which I've separated all those things.
Yep, and I got that from your previous answers. Yes. Thank you. Just quite a lot that I want to get through with you. So if we could move along. So in relation to your proposed reform for the Land and Environment Court and the suggestion that it is a superior court, isn't it already under immense pressure in dealing with all of the other important matters brought before it?
Well, Ms Overall, I can say this to you now because he's not in the room. You'd be more comfortable, but I can tell you that the OLG proceeded under this convoluted process with Thaler as quickly as the Act allowed it to be.
I do understand, and I appreciate it.
I'm prefacing that.
Yep,
I also want to tell you that I used my power of the Act to request a departmental report because I don't get involved in, Minister has no involvement in code of conduct complaints, but a departmental report I requested because I was authorised to do it, and it was completed and given to me, and that was the first time, other than media reports, did I see the extent and seriousness of those issues that have been concerning you and a number of others.
Yes.
If this bill would have been able to be available to me, I would have, because the bill enables the Minister to do this, I would have commenced proceedings in the Land and Environment Court. I would have sought the immediate suspension of Thaler for what he has been doing, and I would have saw his disqualification. So I would have had him out, 6 months, 8 months before all this happened.
And I do appreciate the work and the attention that you paid
so that's
to it.
That's one example.
Yes.
There are other examples that I'm not permitted to talk about, but there are other examples where people have no business being in local government who should be at least removed immediately, where the system does not allow it to occur. You're only talking about a very small number.
Yep, and again though, I know that it is a small number of very problematic cases, as you've pointed out, but you've also pointed out the number of code of conduct complaints that are continually being received and escalating. But I am pleased to hear that defined description that you gave there, that you as the Minister are then able to provide that direction to the Land and Environment Court to have the things potentially looked at more quickly. My question to you, though, comes down to the level of resourcing and the burden that the Land and Environment Court is already under. Now, you talked previously about attending to these matters expeditiously is the word that you use. So how can you guarantee that in circumstances like we've just seen and the ones that you've been presenting about are going to be dealt with expeditiously, given the volume of the backlog for LEC?
Because, firstly, legislation I'm proposing doesn't occur in a vacuum. I've consulted with the Chief Judge of the Land and Environment Court.
And is the Chief Judge able to give a guarantee in that regard, though,
He's
Minister? I mean,
indicated
what's the
that-
prioritisation going to be?
If you're a litigator, you know that you can make urgent or applications to the court, or you can make interim applications to the court, and the court's available to hear it. That's why they have duty judges. So,
but again, this is about the prioritisation process. So
Yeah.
if it's going to step through all of that, doesn't it not necessarily expedite matters, that it could be bogged down in more bureaucracy if you're trying to prove an urgent matter?
well, put it this way: if the Thaler matter was brought to my attention, I'm mentioning that because it's one you know about, and I had the material, then I would be instituting proceedings. I would be instructing the council, and I wouldn't have to work through a convoluted bureaucratic process to get it done.
Okay, so coming back to that then, the convoluted process that you talk about, so when it comes to the bureaucracy, isn't that embedded in the existing legislation? So why haven't you looked at altering the existing legislation directly rather than abrogating responsibility when it comes to, it essentially looks like you're passing the circumstances onto someone else to be dealing with, in this case the Land and Environment Court?
Because I've given you my mode of reasoning for selecting that court. Of course, I've spoken to the Chief Judge and the Attorney General, and they say they've got capacity and are prepared to do it. Firstly, so if they would have kicked up a stink, I would never have got their agreement, and I would have had to look for some other, some other judicial mechanism.
So what will be the measurement for success then,
and
Minister?
so this enables quickly, if Parliament approve it, for there to be just that process. So instead of having to go through a myriad of steps and procedural fairness issues and all that sort of stuff, of which, you know, the department always get concerned about, the court's a procedural fairness. So you just cut that process out. So that means that I can deal with the matters that are serious matters. I can get them out, because you've also got issues where people are operating where there might be evidence of corruption. The NCAT's not an appropriate jurisdiction. I mean, with Thaler, for example, because no one's here, I'll tell you, Thaler.
It is still being broadcast.
Okay. I asked NCAT for an expedited and urgent hearing, and they said no. Now, you know.
So you're suggesting that the Land and Environment Court would look at that differently? Okay.
And I mean, as I indicated when I read the departmental report and understood the seriousness of it, the health impacts on people and etc. People come to the government for protection when circumstances like that exist, and we can't have a legislative regime that basically doesn't enable the government to act quickly in circumstances that it needs to.
I agree. So I think that there are questions around how that will be measured and what you will deem a level of success in this new model. But what I want to get to more pointedly is that it's well known that the funding of the court already isn't keeping pace with demand. So has the Labor government, will they apportion more to, I understand that the funding is through Department of Communities and Justice, is there going to be more funding in order for them to fulfil this new and additional role?
Well, the courts do what the law requires them to do. They've agreed to do it. They've been consulted on the legislation.
But if it needs to be more timely and better resourced, Minister, and clearly there's only been one new judge appointed, when does that take effect?
Well, if Parliament's got to approve the legislation first.
No, I'm sorry, the appointment of the new judge.
Right. Well, you need to ask the Attorney General that. I mean, I can do no more than what I have done, so that we can have.
So will you advocate for additional funding as well to ensure that this new process that you're putting forward can function effectively as you foresee it?
Well, I'm responsible for making sure that this process, if approved by Parliament, functions effectively. If it doesn't function effectively, I'll be accountable to Parliament for it not doing so. I'm not responsible, though, for funding of the judiciary. You need to speak to both the Treasury and the Attorney General.
And DCJ, and you are giving them additional responsibilities and roles in this. So I would expect that you would be advocating on their behalf to ensure that they are adequately resourced in order to deal with it effectively and what those measurements are. But I'm sorry, Minister, I don't mean to rush you on that, but I do have other questions that I want to get to. You also talk about strengthening the power of mayors. Now, what if the mayors are behaving badly? What's the process for that?
The process is that the councils can dissent from the mayor's ruling, because ultimately it'll become a matter for the council.
So you would still require a majority for that to occur.
Well, it would require a motion of dissent from the mayor's
that would be supported by a majority.
Yeah. So if the mayor makes a ruling, we've got to be in a situation whereby there's culture coming in whereby councils are being intimidated and many of the mayors aren't experienced. A lot of mayors and councils left a number of years ago. They don't know that the council can empower the mayor to throw someone out. They don't know how to deal with an unruly council.
But if you still have a majority in a council Minister, the power imbalance remains,
No.
regardless. If it's,
like a
they
house-
may have a movement of dissent, but the mayor, if it's the mayor behaving badly, it doesn't necessarily mean that it's going to take effect in that. Now, look, of the 49 recommendations from the Keller report, which I raised with you last budget estimates under our former government, and one of the recommendations was the establishment of a commission. I've heard you earlier discuss a privilege committee. Have you ever given consideration to the appointment of a local government commissioner for better oversight and more effective outcomes?
No. The reason I've adopted Mr. Whitworth's view is this.
So this is Mr. Whitworth's
Mr.
initiative?
Whitworth's view is about having eminent mayors or former mayors making these decisions is this, and this has become quite apparent to me as I was drafting the code of meeting practice. People write these rules as brilliant as they might be, but they've never seen an angry man. They've never chaired a council meeting. They've never been on a council. They've never had to deal with a public gallery. They've never had to deal with constituents. And so, with the best will of the world, unless people have experience in doing that,
But a local government commissioner could be appointed as someone with experience in such things.
Yeah, but one
Minister.
person's not. I don't like one person because people have their prejudices. I'd rather have those things dealt with by a number of eminent people, so I get a cross-section of people. I get a cross-section of people from both rural and regional areas as well as Sydney making those decisions. I just prefer that because then I get a combination of experience.
Okay, thank you. Look, you've acknowledged openly that councils are struggling structurally, public confidence and financially. Where's your response to the local government financial sustainability review?
Well, the government have responded to the financial sustainability
And your
review.
Your response to it?
And you would have noticed that the government have adhered to a decision-making process about retaining IPART for both oversight of rate increases.
Yes.
The response also is that where councils assert, so you've got to remember the review came at an approximate time to when IPART had already changed the rate peg system, so it's more forward-looking, it's population-based, there's a range, there's pass-through for ESL, so they're really happy with the current rate peg methodology. And these recommendations came sort of overlapped a time when they didn't quite understand the position that they're in, which they do now. For councils who wish to make application, and this is what the government response is, for increase in their rate take, all right, as distinct from special projects, then they're also going to have to satisfy IPART as to an expenditure review, so that their rate base and their expenditure efficiencies justify a potential increase. And if they want an SRV for the purposes of specific projects, then that becomes a separate application to IPART as well.
So we do have councils that are continuing to at least give consideration to special rate variations.
Yes.
So again, you talked earlier about the speed of needing to attend to these things in a more timely manner. When can we expect a resolution?
Oh, because coupled with that, those things is also a change in the council's financial systems, because I think I've talked to you before about, because I talk ad nauseum about it, is the council's financial systems, which are completely opaque to councillors, to the public. I suggest to OLG councils have no idea where their money's going under the current financial systems. They are required to prepare depreciation schedules for non-realisable assets.
And where are they at with, where are most councils at with their audits?
When I first started talking about making those changes, I looked up like I had two heads on, but over a period of time now I've got the Auditor General agreeing with me, I've got all of the state local government ministers agreeing with me. Now the Federal Treasurer has written to the Australian Accounting Standards Board and said that local government accounting systems are not fit for purpose in local government in Australia. So, I mean, there are things moving. I mean, I'd like to go back to, and that's why I've got that expert panel recommended for appointment.
So just to wrap on, my time is done, but so at this point in time, you can't tell us when?
No.
No. Okay.
I can tell you the other codes, though. 1st of January is the...
Yes, the other code I'm aware.
Thank you.
Thank you.
Thank you, Minister. Before I throw to Mr Latham, just a reminder that the hearing is still being publicly broadcast. Thank you.
Yep.
Mr Latham?
Thanks, Chair. Minister, just a point of confusion from earlier on in your evidence, and if you can help the committee, with the conflicting accounts between you and Mr Whitworth. Do you acknowledge that if Mr Whitworth had been allowed to respond in his own words to the matter he took on notice on the 28th of February, that is whether or not you as Minister raised the Saravanosky pre-selection, he would have answered with the words he's given the Legislative Council in his right of reply. That is, the answer was yes, and you did raise with him the Saravanosky pre-selection.
I can't answer any of that because I don't have any of that in front of me. I can only tell you, and I've only told you what my recollection is of the conversation I've had with him. But just as a matter of chronology, the knowledge that I had beyond that very broad information that I was given the year before, that additional knowledge that I got that I couldn't talk about happened happened after the local government elections.
No, that's not the issue I'm raising
Yeah, well,
with you. That's immaterial.
Draw your attention to the chronology.
Minister, can you explain to the committee why Mr Whitworth didn't get to provide an answer in his own words to that question?
I've never put words in Mr Whitworth's mouth.
Who wrote the words that we're talking about?
I don't know.
You don't know?
I don't know.
You forwarded them to this committee through our
Anything that
secretariat.
came from me would have been drafted for me.
Okay, that's your evidence, you don't know. Okay. Do you accept that through this lengthy process, involving several questions on the notice paper since February 28, Mr Whitworth's been frustrated, he hasn't been able to answer in his own words, and he supplied the citizen's right of reply as a way of getting the truth, his truth, on the parliamentary record?
I can't answer for somebody else.
Do you accept that if this committee and the parliament were to view Mr Whitworth's answer on page 5 of his citizen's right of reply as truthful and accurate, it would represent a misuse of your ministerial office?
I don't accept the premise of the question.
The premise being that it's accurate.
Well, I haven't read it, I don't know what's in it, so other than generally what's in it.
You haven't read his citizen's right of reply?
No, not in detail.
Why would that be?
Because
he's putting evidence before the parliament. You've misused your ministerial office to involve yourself in a Labor Party pre-selection scam. That's a complete abuse of your power. Why wouldn't you have read that?
Mr Latham, I reject the premise of your question, and if it contains an assertion, then it is a categorical denial.
Okay. And Minister, you declared a partial interest about the Saravanosky matter because of your wife working at Bayside Council. Why didn't you do the same at the ALP Administrative Committee when it considered the Bayside pre-selection ticket when you were there as the Premier's representative, so therefore representing the government in your ministerial capacity?
And I reject the premise of the question.
What's that? You weren't there as the Premier's representative?
I reject that premise of the question. It contains factual matters that aren't correct.
And what are they?
Nearly all of it.
Did you declare an interest at the Administrative Committee representing the government?
Well,
you authorised the Saravanosky
that's a matter for the
minus, bill out, Chris in ticket for the Bayside Council election?
Well, I reject the premise of the question, and in any event, whatever occurs in the ALP is a matter for them.
No, it's a matter for your ministerial responsibility.
No,
you declared an interest to the Department Secretary you'd carry that interest forward in all roles, wouldn't you?
No, I reject the premise of that question.
Yeah, Minister, are you familiar with Section 5 of the Ministerial Code of Conduct?
I would have been. What does it say?
It says that, in the words of ICAC, a minister can't manipulate the words and advice of a public servant to suit his own interests.
If that's what it says, I accept from you that's what it says.
Yeah, and do you feel like you've done that with regard to Mr Whitworth?
I comply with all my obligations under the Ministerial Code.
Right. At estimates on the 20th of August, Steve Camper said you might have advised him of the Saravanosky issues prior to the listing of NCAT in April 2024. What's your recollection?
My knowledge is that it was already listed when I advised him.
So you're thinking Steve Camper's recollection is incorrect, that it might have been before?
I can't speak for him, but I know that it was listed because I saw the listing of it before, when I advised the local members and party officials.
Right. Minister, do you accept the clear evidence that this has been about a Labor Party pre-selection and ultimately state pre-selection issue in the Rockdale area, that with Mr Camper's health problems, if he doesn't run again in 2027, what's been engineered here is the political execution of Saravanosky to get Ed McDougall in as the mayor and the heir apparent in Rockdale?
I can give you a categorical assurance that that is incorrect.
When did you first discuss with Camper or McDougall that McDougall would be the next mayor?
I never did.
Okay. Why then did you take away the pre-selection numbers for Jo Jansen in her ward pre-selection, putting the voters in favour of Ms Kasim, again aiding the fact that McDougall would have the caucus numbers to become mayor?
I didn't participate in any Labor pre-selection for that ward.
You didn't advise a single person of how they should vote?
No.
No? Stayed right out of it?
I stayed right out of it.
Okay. When did you become aware, Minister, of the DPP advice to charge Bill Saravanosky regarding an allegation of misleading in his ICAC compulsory examination?
When I saw it on their website.
Right, so this was very close to the local government election and wasn't a consideration?
No, it's only just gone on
within
the website.
the Office of Local Government. Okay, well we heard from the Commissioner Hasistakos recently. Minister, did you order the Office of Local Government to refer all media inquiries regarding Saravanosky to your ministerial office so they could draft the replies?
No.
How did that happen?
I don't have no idea.
Do you feel like you're in charge of media in your office and would
Beg
know
your
that they're drafting replies about Saravanosky for the Office of Local Government? Do you feel like you're in charge as Minister, or are you just sort of passing through?
Well, I reject the premise of the question, but I don't know. You need to tell me precisely what you're talking about, Mr Latham, because if there's something I can
Your
tell
ministerial media staff were drafting responses about Saravanosky for the Office of Local Government to use in response to media inquiries.
What type of media inquiries?
Well, any inquiry about Saravanosky, that seemed to be the standard procedure, but you're saying you're unaware that this was happening.
Well, nobody knew about Saravanosky matter other than for the time it appeared in the list, and then there were non-publication orders, and then the following year when NCAT delivered a judgment. So until NCAT delivered a judgment, nobody would have known anything about it, which would have been 2025.
There was a fair bit of publicity, a series of articles by Elizabeth Pike at the Daily Telegraph. They weren't exactly accurate or on the scent that we've uncovered here at this committee, but there was media inquiries that went through to the Office of Local Government. Were you aware of those?
No.
No? And you're not aware of your media staff ever playing a role in drafting those replies?
No.
Okay. Minister, do you look back now and believe that you should have declared a very clear conflict of interest in having any involvement in the Saravanosky matter, to accelerate it, to advise a criminal barrister when Mr Whitworth did the opposite, to give advice about the mystery third matter, and to have your media office involved?
Well, because you've got a whole range of factual scenarios in there, most of which aren't correct, I reject the premise of the question.
Okay, and given that you advised for a criminal barrister and instead OLG ended up with Mr Cobb Clark, who's never run a criminal case in his life, he's an admin
well,
barrister, why do you think that happened?
Well, as a result of your forensic knowledge, because I didn't know that, they clearly ignored the advice I gave them, didn't they?
Yeah, why do you think they did that?
Well, you might ask them that, because I don't know. I don't know that.
Well, I'd put to you, Minister, that you were constantly trying to exaggerate the nature of the Sarabutnosky matters before you as part of this attempt to get rid of him as mayor and put in Ed McDougall for future state pre-selection purposes. How do you respond to that?
I say to you, Mr Latham, you should be, as the Chief Commissioner told you in evidence last week, you should be patient. You should wait for the papers to be produced when they've finished their work, and then all will be revealed, and you can use your forensic abilities to be able to examine it, which I'd probably find helpful.
Okay, well, with all due respect to you, Minister, I've been very patient since the 28th of February waiting for Mr Whitworth to furnish a response to the Parliament, in his own words, accurately, about what you've done behind the scenes. I've been very patient indeed. I put to you, Minister, to the point where your head of the Office of Local Government had to take the unprecedented step of furnishing a citizen's right of reply to get past your obstruction, your involvement, to give us the truth. So I reject to you that I've been impatient in any shape or form, and quite frankly, Minister, you should be ashamed of what you've done.
Well, I reject the premise of your question, Mr Latham.
It wasn't a question, I'm letting you know what I think.
As usual, though, things are just false.
Thank you. Dr Khan.
Thank you, Chair. Minister, I'd like to turn to the issue of financial sustainability in the local government sector.
Sure.
And I know that the government's made a number of commitments in its response to the Upper House inquiry into this. My first question is about the cost of council elections. Have you given consideration to independent oversight of the New South Wales Electoral Commission charges to councils?
I've had some private discussions with the former Shadow Minister for Local Government in respect to the Elections Bill that may provide a solution to that. I don't know whether or not the opposition will want to continue to have the same discussions since there's been a change, but one of the reasons that I propose to introduce the bill that I've second read in the Legislative Assembly is conscious of election costs. You'd also be aware, I'm advised, that as a result of some changes, the Electoral Commission picks up the administrative costs, of which they say are 55% of the costs, so I'm told. I've also tried to make some practical changes in that legislation that would reduce costs, make sure the councils are consulted at the location of polling booths, stop multiple polling booths, restrict pre-poll booths, all of which just increase the costs for councils and not a cost to the Electoral Commissioner. I think I've gone as far with, and also where there's a proportional representation ballot to ensure you haven't got to go for 4 years. You can just take somebody off the ticket if they get elected as part of a group or they're a member of a registered political party. So that should reduce the burden. I've got another, like I said, I've got another idea that might achieve that objective. I'm just not in a position to discuss that openly now. I'll speak to Mr Rathsley whether he wants to still have that discussion that I've had with Mrs Tucker, whether he's interested in it, and that might be something that'll help.
So your proposed reforms to improve the cost of elections are a matter for a closed-door discussion with the Shadow Minister and not the sector who are interested in the answer to that question?
I've been trying to effect these local government reforms on a bipartisan basis because I've been in the sector for a long period of time before I got elected to Parliament, and I know that partisan responses are corrosive. So I've been trying to effect bipartisan changes, bipartisan response, and I think that's been really well welcomed by the sector itself. So, I appreciate, your constructive input, Dr. Con, but at the end of the day, the Greens will never be the government of New South Wales.
I don't think you'll get any disagreement from the crossbench about the importance of collaborations with other parties from the government. But in response to a question that I've asked you on the public record in a public hearing, your answer is that you'll discuss it in a closed-door meeting with the Shadow Minister.
Because I need the support of the opposition to achieve something that I don't want to publicly disclose at this particular point in time. As soon as I'm in a position to tell you, Dr. Connell will tell you, but there's no point telling you early, and then as a result of that, I end up not being able to achieve what I want to achieve, even if they then subsequently agree.
Sure. It's got nothing to do with me. It's the people who are interested in this issue who are watching these proceedings.
I have their best interests in heart. I accept that they have been overcharged, if I use that conservative word, overcharged over a long period of time. It probably prompted in 2011 and 12 the taking away from the Electoral Commissioner the running of elections to private providers, which turned out to be pretty unsuccessful because the Parliament had to keep making changes from that. That was done on the back of councils being charged a huge amount of money for the running of elections.
I also wanted to ask about the financial assistance grants, which are of course a matter for the federal government. The sector has been advocating loudly about the need to increase those grants back up to 1% of Commonwealth taxation revenue for a number of years. What action have you taken to lobby your federal colleagues for that change?
Well, together with all the ministers for local government, we've been pressing the Commonwealth Government about that, and there was a House of Representatives committee inquiry into increasing the take of the financial assistance grants. As you appreciate, the New South Wales government's not all that happy with the federal government in a number of respects, let alone us being ripped off on the GST. So, but in this, where all the states aren't uniform because we're the ones that are ripped off the worst, but in respect of financial assistance grants, there's unanimity of views of the local government ministers.
In the context of that House of Representatives inquiry, did you make any direct representation to those members or to the federal?
I've certainly spoken to the federal local government minister in relation to it. As you know, these things not only you haven't only got to get the minister on side. I mean, dealing with treasuries is not the most easiest hurdle to overcome.
Coming back to things that are within your control, one of the government commitments from the inquiry was to undertake an audit of statutory fees and charges and user fees to align them, where appropriate, with reasonable service costs. Where's that audit up to?
I don't know. I'll ask Mr. Whitworth there.
We're going to commence that with the guidance of the expert advisory panel. We've commenced a very preliminary sort of overview of which fees and charges we need to be talking about, but the approach of the government's response to the financial sustainability inquiry is to have the expert advisory panel to drive a lot of the policy and provide a lot of perspectives and strategic advice on the policy issues.
Understood. A number of those proposed initiatives are quite complex, and I'll come to the comprehensive spending review process a bit later. I suppose I'm focusing on this one, the audit of statutory fees and charges, because it's relatively straightforward. I was a member of the committee that conducted the inquiry. I mean, we received quite a comprehensive list of fees that councils believed were an issue through submissions to that inquiry. We listed a number of them in the report. What's being done with that work that the committee's already done to identify the fees that needed some attention?
Sorry, that's a question for me, or? Yep, certainly. As I said, we wanted to use the expert advisory panel to drive the policy perspective. So you're right, we know the fees and charges. I mean, I think everyone is, the two examples that people regularly use are DA fees and the stormwater charge. So that's not a surprise. understanding what the policy rationale for the stormwater charge is, for example, working out what the right policy response is for the DA fees, and that's why we wanted the expert advisory panel to help guide that strategic advice that we provide to the government in terms of how those will be changed. Some of them will require legislation, some of them will require regulation.
Minister, there's also the proposal for the government to prepare legislation and regulatory changes to allow the review of council income and expenditure through a comprehensive spending review process.
Yeah.
Certainly that proposal has some merit. I'm not intending to criticise it wholesale. A review like that, how will you ensure that it can be advisory and not override the priorities of elected councillors on behalf of their communities?
It can only be advisory. If you can make their expenditure transparent to councillors, and I've been trying to convey this to general managers and senior council officers, if you can make their expenditure transparent so that elected councillors can make the decision, you'll be surprised at how good they are collectively at making those decisions. That they shouldn't fear them making it. I've been through that process of cutting rates and having to go through that process. And as I've moved through the state, talking to various council and councillors, some of these rural and regional councillors got nothing. They're operating on a shoestring. They know where every cent goes. You can, if you make the information available to them, you can trust them to get it right. And in any event, they're entitled to be wrong, aren't they, because they're elected, but they've just got to have the material. And that's basically my aim, because I suspect that a lot of the financial sustainability problems, not all, some of them, relate to their inability of the councillors to be able to scrutinise expenditure that is not in accordance with their priorities as distinct from what their statutory obligations might be.
I'm out of time.
Thank you. The opposition?
Thanks. I'll be brief. Minister, Libby Austin is a Penrith councillor. She's also an electorate staffer for the member for Camden. Councillors are required to seek permission from council general managers to attend council meetings online when they can't attend in person. Penrith Council GM granted Libby Austin permission to attend council meetings online. Libby Austin has been actively campaigning for the Labor candidate in Cayama during work hours. Did Libby Austin seek permission not to attend council meetings so she could campaign for the Labor candidate in Cayama?
I don't know. That's a matter for the council to manage, and a matter for the member for Camden to manage. It's not a matter for me.
Are you able to take it on notice in case Office of Local Government's been made aware in any way of this
it's
request?
It's not really an issue that would.
I'm looking at Mr Whitworth.
I thought that in order to attend a meeting online, you need to seek leave from the council, and the council needs to grant that leave. So it's not the role of the general manager. The general manager needs to be advised
By a motion of the council?
Yes.
Yes.
Is that logged with Office of Local
No.
Government?
No.
Are you aware of?
No, it's internal council function.
So each council manages it?
That they are the independent third tier of government.
And they've got to, and if they refuse, they've got to give a reason. Under the current rules, it'll change in the Code of Meeting Practice.
Do you know Libby Austin, Minister?
No.
Do you know if she's taken leave from
I wouldn't know.
the member for Camden's office?
No.
Has Libby Austin provided false reasons to council for missing council meetings, or are you aware of that?
How would I know? It wouldn't be a matter that come to me.
Thank you, Minister. Is the OLG investigation into Newcastle City's GM special leave still active?
Well, the OLG has never conducted an investigation into the General Manager of Newcastle Council. The General Manager of Newcastle Council is employed by that council.
Was he not referred to ICAC?
Well,
or the matter, not him,
certainly not by either me or the Office of Local Government.
No.
I received a complaint and some material came to me, maybe via the Newcastle Herald, and I wrote to the Lord Mayor of Newcastle and said, I've received this complaint about your general manager. It's your obligation to consider those matters relating to your employee.
Okay, so if I'm to understand correctly, so with the model GM contract, if one were to seek special leave, it can only be done via a full council resolution?
No, I think that matter's been, that matter was looked at because that was subject to that matter was subject to another complaint to me, and the advice I got back was that that special leave could be granted by the Lord Mayor, and the Lord Mayor at the time granted special leave. That's correct, isn't it?
That's true. The council delegated certain powers to the Lord Mayor, and so the Lord Mayor provided that. And I don't quite know that it's special leave. I understand that it was study leave, and I understand that it was recreation as well.
Okay, so there's no sanctions or remedies as far as you're aware because it's an in-house matter, not for OLG, or does OLG offer guidance on that?
Sorry, Minister.
Well, there's no guidance to offer because it's a matter for them to conduct their own affairs with their own employee in accordance with their own employee contract.
Okay, thank you. Well, I'll move on then. With regard to, say, financial delegation for councils, I'm of the understanding, and it's already been noted, that Central Coast has 10 million and I forget what the other, City of Sydney has 5 million. Is there guidance, or I thought the regulation said that if there was delegated authority for tenders, is there a set amount normally before they seek special?
Mr. Whitworth?
There is an amount in the regulation which identifies where council is procuring material that they need to go for a tender process. There is also a mechanism in the regulation that allows for councils to procure without going through a tender process if they use a prescribed provider, which there is a prescribed provider there. So, but that's about procuring, that's about the decision as to whether to procure goods and services.
And so in, say in Newcastle City's example, Minister, they were going to go for 1 million, but at the meeting just most recently they've upped it to 5 million. Do you believe that, say, retrospectively monthly reports provide the same transparency as open debate and a recorded vote? No. Do you know of other councils that have other delegations besides the two that were just mentioned above 5 million?
I think they've all got extensive delegations to various amounts. That doesn't mean to say it's right, but they all have. But I can't make a sort of commitment in a vacuum because there are so many reforms needed in this sector. I mean, some issues are raised that I've not thought about, usually from these estimates committees that actually end up getting in the queue.
Well, do you think, say, like, would OLG review the procurement delegation policies when councils lift those thresholds, especially if it's 1 million or above?
Look, there's something. I'm prepared to look at the delegations because there are other delegations or restrictions that are in the code that I'm going to remove. There's some in the Act that become a bit more complicated to remove, but I think they're in the code or a regulation. So I intend. I said it's sitting on my desk. I haven't got to it, but I'm just going to go and look at that. I mean, there's routine delegations to give, and but a number of others have cropped in, or there's been a number of restrictions to exercising that delegation that's cropped in over the years. It's removed councillors further and further from the decision-making process.
Yeah, okay, thank you. And just on that, has the member for Swansea ever raised Newcastle City Council tenders or contracts with you or your office?
No.
No? And has the member for Swansea ever sought advice from you or the Office of Local Government about Newcastle's procurement practices?
Not procurement practices. She has complained to me about. I met with her and some of the other local members, and they were complaining to me about something, but while they were in administration, I just can't remember what that was.
Has the member then...
I think it might have related to, I might be wrong, so I should check. I think it might have related to asset sales, but I think as some of you might remember that as part of the administration and part of the loans, there was a requirement for asset sales. It may have been that, it may have been the councillors, former candidates complaining about that, but I do remember meeting with a group of MPs from the Central Coast. They were complaining about the council, but I can't remember what it was.
Okay, all right. Okay.
It wasn't something that I could do anything about anyway.
So would you guarantee that no political pressure has been applied to Newcastle?
To me?
Yeah.
Absolutely not.
Okay, thank you. So I'll move on to Central Coast now. When a councillor I'll just ask it, has the Office of Local Government been advised of assault and affray charges and an AVO against Councillor Corinne Lamont of the Central Coast Council?
Yes. Know anything about that?
Yes.
Yep, it has. And what specific powers then do you currently have, and I know you're changing them, or you have under the Local Government Act to when a sitting councillor is facing serious criminal charges?
So there is a provision under the Local Government Act that identifies the eligibility to be a councillor, and if a councillor is convicted of a serious offence which involves a criminal or a serious conduct of more than 5 years, then they are automatically disqualified.
Okay.
So the Office of Local Government is watching and monitoring the issue.
All right. And Minister, do you know if OLG have issued any performance improvement orders or misconduct directions or interim measures to this councillor since the charges were laid? As you said, like they're monitoring, but has it gone beyond that?
No, they're just monitoring is the answer that Mr. Woolworth gave you.
Okay. And do you know how many code of conduct or conflict of interest complaints about the councillor has OLG received in the previous 12 months?
I would prefer, happy to talk about code of conduct complaints in the abstract and numbers, but when you start talking about individual code of conduct complaints for individual people, you start weaponising that process, which leads us to the very situation that we've been talking about this morning, for example, with Councillor Darley and the Parramatta matter. So I find that it's, not terribly appropriate to discuss individual cases.
All right, I'll move on then, Minister. Minister, what is your assessment of, say, the financial sustainability of New South Wales councils, given the Auditor-General's recent warnings that many are at risk of not being financially viable?
You're reading from the 2000 and
it was a report titled Local Government
2023 audit report.
2024.
2024.
2024, yeah.
So I've just been given
you can take it on notice if you like.
Mr. Rath asked me a question. I've just been given some information about the question you asked me. Information provided to me in relation to Ms Austin by the ALP. I'm advised she's currently on the payroll of the ALP to work on the campaign. I'm further advised she's not missed an in-person ordinary meeting while working on the campaign. I suggest, Mr Rath, you'd be more careful casting aspersions against the character of a young woman active in politics. You might want to consider apologising to her.
That's a very diligent staffer that's given you that note.
Do we get an apology? I mean, I'd apologise if it was me that was that wrong, but you know.
You've got a lot to apologise for.
Well, I've got nothing to apologise for.
If I may.
Yeah, I'm sorry. Yeah, I'm sorry.
Sorry. I was asking you about the report.
Yeah, could you just ask me that question again? Sorry. I've distracted myself. I'm sorry.
I said, what is your assessment of the financial sustainability of New South Wales councils, given the warnings that they're not financially viable? Or many are at risk of not being financially viable.
Many councils have financial sustainability challenges, and there are some that are struggling financially. They're either supported and are on watch lists and being provided either have performance improvement orders, or alternatively there's been financial intervention, or alternatively they're being monitored by the OLG to ensure that they are equipped to handle their challenges. Sometimes when you look at the financial performance of a particular council that looks horrifying, and you visit them and you see that there is a newly elected mayor and council, and you see one I feel very sorry for. She just gets elected. She's faced with really difficult challenges. She's got to the first thing she does is got to put through an SRV to try and convince the community to increase the rates. But you see that they're actually switched on, and they're determined. It's actually travelling through regional New South Wales, it's actually quite inspiring to see
what they
to
do
see
with
them
so
addressing the challenges.
Would you say then, Minister, that councils across New South Wales are reporting a massive backlog in local infrastructure maintenance? And do you know what the total backlog figure would be, or do you hold that figure?
I don't hold that. I don't hold what they say is their total backlog figure. I think every council and every government have probably got some sort of backlog figure of a maintenance.
Yeah.
But mind you, despite councils sometimes, I mean, we complain to the feds, they complain to us about lack of funds. They're really well supported by billions of dollars in grants. It's taken me a while to work this out, but I've now, with a couple of council visits, knowing that they're going to complain about how much they've got to pay for something, pull out a list of all the grants that they're getting.
I've got one more question, then I want to pass to my colleague. Would you say, Minister, isn't it the case that ratepayers across New South Wales are paying more but receiving less from their councils under your government?
You're asking me whether or not I should accept responsibility for the adequate performance of councils throughout New South Wales.
Are the Minister, yeah.
And I say, we've only been in for a couple of years.
I don't think you can use that excuse anymore, Minister.
I don't think that's. I think that's not a question.
You've got just over 12 months to get the act right, but I'll pass over to my colleague now.
Yes. Just a quick one, Minister, on a more specific example. The Clarence water treatment plant, are you aware of it? Clarence Valley Council.
Ms. Overall, I've visited so many councils.
Oh, you visited
this
Clarence
year.
Valley
I-
twice. You said so in
Yeah,
your litany of...
I can assist Ms Overall if you have any questions. I'm familiar that there
Well,
is
I
a
do
project.
have questions, but they're really to the Minister. Thank you, Mr Whitworth, at this point in time. It's an $84 million water filtration plant that has to be constructed by council, and in the circumstances that we've just heard, where we know that many of these councils and this particular council isn't in a position to come up with those sorts of figures. Minister, your Labor candidate for Clarence, Dr Leon Ankersmit, you're aware of commitments he made in relation to the Clarence water treatment plant? Well, he said, and I quote, on March 1st, 2023, if Labor is elected in March, we can expect priority investment for this project from the Safe and Secure Water Program in partnership with local councils and the federal government as well. I'll acknowledge that. Well, there is a Labor government, Minister, so what are you doing to help Clarence Valley Council facilitate this project? And I do understand that the incredibly hard-working New South Wales Nationals member, Richie Williamson, hasn't had any information from you or the Labor government about this.
Well, I'll get you an answer because I actually visited the very talented and energetic Richie Williamson's Electorate at his invitation, but I'll just get Mr Whitworth to...
So, Safe and Secure is a program that's run by DQ,
Minister Jackson.
So it's Minister Jackson.
Yep, that's okay.
Yeah.
I'm asking
Yeah.
the Minister what he is doing to advocate on behalf of the Clarence Valley Council to assist in this matter, given they are not receiving any answer from the Labor government.
Well, I will do whatever I'm asked to do, and as Mr Williamson knows, anything he asks me to do,
$84 million, that'd be great.
Even visit his electorate when he asks me to.
Okay, another very quick one just to finish off. How are local councillors designated under the New South Wales Work Health and Safety Act 2011?
I don't know.
Right, do you know they're considered officers or workers, and so that means that they don't really have proper cover when it comes to work health and safety matters, and councils like Glen Innes are putting forward their own guidelines to address these serious matters. So surely there needs to be more formal protections for councillors rather than them having to do it themselves. Have you given any consideration to this?
I haven't, but I will now that you've raised it.
Excellent, thank you very much.
Are there any questions from the government?
Only again to ask Minister, are there any matters on which you wish to elucidate?
No, not really.
There being no
So
further questions
further
from the
questions?
government.
We're very satisfied with all the answers.
That brings us to the end of this morning's session. Thank you, Minister, for your time this morning, and we'll be back at 2 o'clock for the departmental witnesses. Thanks.
Thank you.
The Secretary.
Thank you, and welcome back to the afternoon of budget estimates. I will start with the crossbench, and I believe my colleague will be here shortly. Mr. Whitworth, I've got some questions.
Sorry, I believe we need to
we do need to swear in other witnesses. Yes, thank you, Ms Fishburn.
I've been to plenty of these.
I do have some additional witnesses I need to swear in. We have. Could I please get Ms Nashi Rahman, please, come forward?
Hi everyone, my name is Nashi Rahman and I'm the Director of Companion Animals Policy and Programs at LG. I solemnly, sincerely and truly declare and affirm that the evidence now about to be given by me shall be the truth, the whole truth and nothing but the truth.
Thank you. Ms Nerida Mooney.
Good afternoon. My name is Nerida Mooney. I'm the Executive Director, Digital and Customer, New South Wales Planning, Housing and Infrastructure. I'm going to read the affirmation. I solemnly, sincerely and truly declare and affirm that the evidence given now and about to be given by me shall be the truth, the whole truth and nothing but the truth.
Thank you. Mr Andrew Nichols.
Good afternoon. Andrew Nichols, the Chief Executive Officer of IPART. I swear that the evidence now about to be given by me shall be the truth, the whole truth, and nothing but the truth, so help me God.
Thank you. And Ms Fiona Towers.
I'm Fiona Towers, Executive Director at IPART. I solemnly, sincerely and truly declare and affirm that the evidence now about to be given by me shall be the truth, the whole truth, and nothing but the truth.
Thank you. Thank you so much. Right, now, Ms Whitworth, I've got some questions around spending on council pounds, and I'm very sympathetic that many councils, particularly in regional and rural areas, can't afford pound upgrades. It's also a reality that some councils simply choose to spend their money on other priorities. How can we ensure councils are contributing a fair and appropriate amount towards their requirements around companion animals and particularly the need for impounding services?
That's probably a policy question, so I'll take it on the spirit that it is a policy question and that we're still working through those issues. I think there are probably three key things to say. One, we're quite clear that there is a need for a code for pounds, and I think that's quite clear in the report of the parliamentary inquiry, quite clear in the government's response that we will be working on a code, and a code will then give some structure and firmness around the animal welfare elements, but also the operational elements. So that's the first point, that a code will help drive some improved standards. There's still the question then as to how it will need to be funded. I think we obviously need to recognise we're within a government structure that there is quite a lot of pressure on the budget. And so it is a challenge for us to just go and say we want a new set of grant processes and so on. But we probably need to be thinking about how do we incentivise councils to improve the operation of their pounds, both from a regulatory perspective and also from an incentive perspective around the provision of grants. I have, and that's probably gets me to my third point, which is we've long talked about the Companion Animals Fund, which is the receipts from the registration of companion animals. At the moment, it's a almost straight pass through. There's a percentage that comes to the government and there's a percentage that goes to the councils. I think I've given evidence before that those councils that have a large number of animal registrations and a large population get more than the lion's share of the amount. I think without wanting to name any councils, but I have signed off remittance advice that gave a council for a quarter $29, which was their share of the registration fees. But you just can't do anything with that.
Yeah.
So we need to be thinking about how do we leverage the Companion Animals Fund to get more money into those places that need that funding. So whether we can leverage it, and as I said, this is more in a policy conversation rather than a perspective of government, but is there an opportunity to leverage some of the Companion Animals Fund to actually target specific improvements and incentivising councils to improve their pound operation?
And will part of that be around sort of tracking and transparency, or will we be able to see how much councils are actually spending on their animal welfare initiatives specifically, so we can implement and see sort of more transparency that they're meeting their obligations in that space?
Again, a policy sort of perspective, but we don't delve into the budgets of a council. That's the job of the councillors, to delve into what the budget is for each council. But what we can be doing is asking for more detail around some of the output and operational sort of components of the operation of a pound. We already have some of those statistics, but we need to get better at getting that information out. And I think that again is where we can use part of the Companion Animals Review to improve on that. I'm really acutely aware that the operation of pounds is quite a challenge for council general managers, for example, where they're taking the view that this isn't necessarily their biggest focus or the issue that's driving them to deliver. When you've got councillors asking for parks to be improved, you've got the state government wanting to ensure that we can address housing affordability issues and so on. So it is going to be a challenge to carve that space out, and using some of that operational data to get a comparison of how some councils operate their pounds versus others.
There was a recommendation in the Pound Inquiry report that the New South Wales Government require councils to publicly report budget allocation for pound operations. I know that it wasn't that long ago that the Pound report came out, but has your office been given any directions to work on that space?
Look, our direction was that we would pick up the parliamentary inquiry reports as part of the review of the Companion Animals Act. Mm-hmm. That review has, again, we haven't come out with the answer. We've gone out with a series of questions, and now we need to go and start framing up how we can better respond to those questions and some of the issues that we can address. I think we do have a pretty good understanding of the themes, and there were over I think there were 3,600 odd submissions. Other than, whilst there were a lot of submissions about cat containment, there were still, I think by my reckoning, about 800 submissions that came from councils, members of the community, other interested parties that had, quite a large number of issues that they wanted us to investigate. So there's a lot of policy work to unpack there, and to tie that in with the creation of the Office of Animal Welfare and working with our colleagues in DPIRD. One of my frustrations with the pet registry is that I'd like to get better data out of the pet registry, and so that would also help with that policy process. So that's, to me, those are the elements that I want to bring together. Hopefully we can have some policy conversations with stakeholders, targeted groups, in the coming months.
Thank you. And in regards to the pet registry, and I think you and I were sort of talking about it a little bit before, and I said the email might have been talking about the car, but I actually think it was about the Link My Pet functionality of the pet registry. That's the part that actually saw that specific increase of over 1 million and the delay of 4 months. Can you give some background on the decisions and the delays that caused that cost to increase and with a lower sort of functionality in the outcome?
I can seek to assist as best I can. As I said, when I'd not long come into the role of Deputy Secretary in early 2023, and there was a decision of government that there would be funding allocated for the pet registry off the back of the initial funding out of the Digital Restart Fund, but we needed to do a business case, and that business case had promised effectively that there would be, and I've written, that by December 2023 we would have the breeder and owner portals established, which means that we would have had the whole system built and ready to go, and then we would have vet portals and so on by June 2024. Now, obviously, we haven't achieved that. And when I started to, I think it was as a result of budget estimates that we were asked questions around what the timing is of the pet registry. And the more we started to look at the issue, we understood that there was a bit of a debate between, and this is a programming sort of, or an ICT development, the concept of an agile process versus a waterfall process. Waterfall being you get a fixed amount of money for a fixed, for a fixed amount of money you'll get a fixed product in a fixed time frame. It might mean that you don't get the same degree of functionality, so I understand why people want that agile process. But it seems to me that we had not delivered using the agile process, and we needed to give confidence to the government, to the community, to this very committee that we were providing and delivering on an important project. So we said that we needed to have the registry up and running by July 2024, and then that we wanted that functionality around the Link My Pet by the end of 2024, which we managed to deliver. But we needed to do quite a bit of governance change as well, which I'm happy to keep talking about, but where my time's, your time's up.
No, thank you. Dr. Con.
Thank you very much, Chair. I have a number of companion animals related questions, so we can keep you in the same headspace, Mr. Whitworth. Do you have an update on when the review of the Animal Welfare Code of Practice for breeding dogs and cats will be completed?
The animal welfare, I'm not sure, sorry, can I hand over to my DEPA colleagues?
Yeah,
please.
Thanks, Brett. Yeah, so I'll take that question. So look, with the breeding code itself, we're keen to we're probably looking at a two-stage approach, working on initial review to ensure that definitions in the breeding code are consistent with the new measures under the puppy farming changes, and that also that the requirements around those breeders seeking a cap exemption are also dealt with in that code as well. So that'll be our first tier. We'll be looking at launching a consultation program shortly to support the code being finalised, with our aim to have the code finalised by March next year, 1 March, and effective from 1 April next year as well.
Thank you very much. You also mentioned the changes that came through with the puppy farming bill.
Yeah.
Do you have an update on how much the Department of Primary Industries and Regional Development is funding the OLG for its new responsibilities under the Act?
So, as Ms. Fishburn alluded to this morning, we're in the process of sorting out the funding arrangements between the two departments. So our secretaries, my secretary met with Ms. Fishburn last week, so we're in the process of finalising that. But until the grant's processed, I would prefer just to take that on notice, if that's okay.
Can I also just step in to say that we're not sitting waiting for the funding arrangements to be resolved. We're working to deliver the upgrade to the pet registry to deliver the breeder identification numbers, which are an essential part of the puppy farm legislation, by the 1st of December.
That's correct. The funding will be reimbursement of funds that have been expended at present.
Okay. Thank you. That clarification is helpful. At last budget estimates, my colleague asked about compliance around advertising animals on websites or social media sites. So specifically the requirement that councils must, before taking action to destroy a seized or surrendered animal, give notice to at least 2 rehoming organisations. The response from previous estimates was that where non-compliance is reported, OLG will make the appropriate inquiries. Can you explain in a bit more detail what that means, what the specific actions are that the OLG takes in instances of non-compliance?
I suppose that it can be a challenge in terms of whether it's a non-compliance that the council has a role in, or whether it's a non-compliance that might require some sort of police action. I think that the particular, I remember the question and I remember the issue because I think I met with someone that had raised that from a Shoalhaven perspective, but I think they were talking about another council to the north of them. It's the challenge we always have when dealing with these sorts of matters is what sort of evidence do we have? How do we find the person? Who's got the regulatory powers to make some sort of impact? So typically what we would do is identify, is it in such and such an area? We'd bring it to the attention of the council. The council rangers have far more sort of far more effective regulatory tools and experience to apply to that those sorts of instances. But again, if someone's advertising something on Facebook, which I think was the allegation, how do you know that it's a genuine person? How do you know that it's a genuine advertisement, and so forth?
Sure. And what about in the instances where the non-compliance is by the council itself?
Well, I'm happy to take that on notice in terms of whether we've had instances where non-compliances have been reported to us about council activity. I'm not aware of. I'm not aware that there are a significant number. I do know that there was a particular circumstance in Moree, and I wrote to the council and asked for advice in terms of how they were addressing their compliance with the Companion Animals Act in terms of the operation of their pound. And I actually raised it when I went up there to meet with the acting general manager at the time. And they talked about some of the challenges they have with the companion animal issues in Moree and the challenges they have in actually identifying who's registered and, the vast numbers of dogs that are unregistered, for example. So it was clear to me that they weren't trying to abrogate their responsibility. They were just dealing with a very difficult set of circumstances.
Are you able to tell us, for example, year to date, how many complaints the OLG has received in relation to the condition of council pounds or animal welfare issues for impounded animals?
Given its data, I'd like to take that on notice, if that's okay.
No problem, thank you. And when will the 24-25 council pound data report be published?
I don't have a time frame on that. Normally we get that data with the annual reports and so forth, so that's normally around September that they come through. I think we managed to get it released. I mean, I'd like to think that we can get it released before the end of the year with the other annual report data that we put up on your council website.
Thank you. I just wanted to ask about the responsible pet ownership reference group, which I understand the OLG was not planning to reinstate because some of that work was going to be brought in-house. Can you talk us through how that's working?
There hasn't been a responsible pet ownership group under a formal process under this government. I do know that there has been use of a number of members of that group in a sort of unofficial capacity to help us with companion animal processes. I don't know whether Ms. Baldock can talk a little bit more about that group, or she's, yes?
Only to reiterate what you've already said, Mr. Whitworth, so there hasn't been a formal RPO under this government, but we do have close relationships and do work with different key animal stakeholders as part of the companion animals work, particularly now that we're working on the Companion Animals Act review itself.
Okay. And in the absence of a formal group, what kind of transparency or public accountability is there over who you're working with? Is that reported anywhere?
Well, I suppose we're working with the stakeholders that we had identified when we had a number of the workshops on the companion animal reforms. We probably wouldn't even have that level of detail in our annual report, given the sort of level of detail that you have in annual reports these days. Is there a particular concern or issue that people are feeling that they're not being consulted? I know the Companion Animal Act review had, I think that we had over 300 participants across 3 different seminars. Some were online, some were actually held in person. So I feel like we're trying our very best to make sure we're reaching out to as many stakeholders as we can. I do take on board, I think there is a concern that perhaps some of the rehoming organisations and networks feel maybe a little bit overwhelmed because they're in the same room as council officers and RSPCA Animal Welfare League. So maybe we need to take a slightly different approach and make sure that we can give them their own voice, because I think we've heard testimony this morning that the rehoming network is at pressure, at crisis point, and we need to work out and make sure that we can work with those groups to alleviate that pressure as much as we can.
Okay. Thank you. I won't change tack with 30 seconds. I'll have that.
In that case, I'll throw to the opposition.
Great, thank you. Thank you, everyone, for being here. I wanted to talk a bit about cost shifting. I don't know, it came up in the morning session from Dr. Conn, but I wanted to go to the Local Government New South Wales report, where they've said that New South Wales councils had a $1.5 billion cost shifting imposed on them in 2023-24. Is that also the department's view? Is that Office of Local Government's view that cost shifting has been a $1.5 billion impost on councils?
Cost shifting is like it's like an article of faith. You either believe in it or you don't. The detail in that report identified a number of matters that in some cases were the election of the council to deliver. So, as an example, there is an argument that healthcare services and aged care services are really important in regional areas, and they absolutely are. If the Commonwealth doesn't fund places, then it's up to the council to fund that. That's an election of that council to make that decision. Yet that appears in that report as being a cost shift. There are commentaries around the provision of emergency services levies as being a cost shift. Now, there is an argument that if you trace back to one of the origins of local government, that it was about providing safety and security, which also included fire services and in some cases police services. And you go back to, the origins of local government in other jurisdictions, you have police services provided at that more municipal level. And so when you have combined them, there has been a decision that we'll use an emergency services levy to pay for that. Is that a cost shift? These are philosophical questions. I know that if I had Local Government New South Wales in the room, they'd say absolutely it is.
Well, could it be that it's an unintentional cost shift rather than a deliberate cost shift by the state or federal government?
Well, I think you could also argue that what are the services that local government provides? What are the services that communities expect that their local councils will provide. And some communities will expect different levels of service, and B, different expectations about what those services will be. I've travelled quite a bit with the Minister in the last couple of months, particularly talking to councils that are in the process of demerging. And one of the things that strikes me really markedly is that those smaller communities that want a council back, to use their argument, have said we are prepared to have a lesser quality or a lesser standard of service, which then goes to, this is the whole thing about local government, is that it's intrinsically local. The services that you want as a council are local services identified by the community. If the community says, I actually want that, but I don't want that, is that a cost shift? I mean, this is, I mean, it's a useful conversation to have, but it's an abstract conversation, I'd argue. And just to, to use a final example, I think Local Government New South Wales has identified as a result of the cat inquiry that they would be all for improved containment of cats, but they want the government to pay for that. So that would arguably be a cost shift, but I don't, they're asking for more powers and more responsibility, but then saying you've got to fund us to have that.
Yeah. No, thank you. The does OLG has any work been done to look at whether there has been any increases in cost shifting over the last year or two? Is that something that your office has looked at?
No, again, I know that Local Government New South Wales produces its report. That report's not a detailed financial audit. That report is a survey of councils with them providing perspectives. What we do is we work with the audit office. We work with the data that we obtain from councils. We try and give them the ability to manage their finances within the service levels that they identify.
One potential cost shift back the other way is the Red Fleet RFS assets. What is the current cost to local councils in total, and maybe if you've got it on a per council basis, of owning the Red Fleet assets? And I know there's been a lot of work done on this over the last year or two, so any updates would be very helpful.
Sorry, the cost. Sorry, what was the specific question? Because I feel like that's probably one that we'd need to take on.
Yeah, we need to take that on notice.
Yeah, current cost to councils of having the RFS assets on their books, and on maybe on a per council basis as well. And I suppose just if you take that on notice, but I suppose maybe the broader question is what any update, because I know there's been a lot of engagement between the New South Wales government and local councils on this.
So we can provide you with a list of assets that the councils, the RFS has identified for us. We provide that list to Local Government New South Wales. Under the accounting standards, I understand that it's up to each council to then value those assets. So it's not necessarily as clear cut as the state government has an answer for all of the total number. But I do believe that there were some estimates identified in the Public Accounts Committee report, which we can draw out for you. In terms of the response to the Public Accounts Committee, that response, the whole of government response, is being led by the Premier's Department, and they will be drawing together the different views of the different agencies. I mean, ultimately, the recommendation of the Public Accounts Committee is that there needs to be an amendment of the Rural Fires Act, which is not within Minister Hoenig's purview as Local Government Minister, but would sit under both Minister Dibb. And I think the Premier may have some role in that, in terms of the sort of emergency management centralisation functions that sit within his department.
But essentially, it's just they don't want the depreciating asset on their books. That's the sort of main
respectfully, that's a very simplistic view, because I think that there are other perspectives that are, it's not just about the depreciating asset, it's also about, if you're telling me that I have that asset on my book, then can I use it? Can I utilise that asset? Can I utilise it in an emergency? Can I utilise it for other purposes?
Can I put the council livery on it?
Yeah, and essentially they can't, right? I mean,
No,
it's,
they
it's,
can't.
it's controlled by our New South Wales RFS, but the cost is borne by the councils, which is why why some of them are so frustrated.
Again, RFS provides the new vehicle.
Yeah.
And and there are maintenance arrangements that are signed between the councils and RFS to maintain where councils receive some funds. And they do vary. I'm not going to say that it's a universal agreement, but it's more. I think it's almost again philosophical perspective. You know, you're telling me that I've got something, but I can't actually control it.
Another issue on costs is regarding the quite large costs, recent increases in running local government elections. I've certainly had feedback from a range of councils that the cost of running elections now has gone up. I think in the case of Camden, it went up 93%, and I think statewide it was on average 13%. Has OLG looked at any ways of potentially assisting councils with that very large increase in costs that they now have to wear?
Not on a program basis. The costs of the elections are set by the statutorily independent election commissioner, and the funding of the electoral commissioner is set through conversations that they have with the treasurer, and the special minister of state has a role. And so it's been as a result of that there's been an ability to share the costs. So councils don't carry the full costs of elections. They carry the direct costs in terms of the booking of the halls and the employment of the returning officers and so on. The centralised costs of running an election, including the tally rooms, the IT, the centralised staff at Elections New South Wales, are all borne by the state, who fund the Electoral Commission. The Minister talked about it being a 45-55% split, which isn't a guaranteed amount, it just was what was the split at the last election. What I can also...
Has it always been that?
Sorry?
Has it always been that
No,
proportion?
it has shifted, and I think earlier elections there was even more numbers, councils...
Had more of the cost.
Bore more of the costs. The other thing that, and I'm not saying that the government has done this because it's been set by the independent regulator, that the base cost change model for the setting of rates has recognised the differential election costs that councils have as well. I don't know whether Mr Nichols wants to add to that or whether you want to ask him that specifically.
Yeah, Mr Nichols.
With the reforms to the rate peg that occurred 2 years ago, we included a specific adjustment for election costs. We are currently consulting with local councils and the broader community about smoothing that, so that instead of having these costs spiking every 4 years, that we have a smoothing out of that over a period of time so that councils are able to collect the necessary revenue. So we've certainly now factored that in to the rate peg and ensuring that councils have the capacity to pay. While I don't have the detail, IPART did conduct an examination of the question of election costs in 2019, and I don't have the recommendations in front of me, but if it's something of greater interest, we can certainly make that copy available to you.
No, thank you. I think it's just the more recent large increases. I think from the 2024 local government election is where a lot of the quite sizable increases have come through. The expert advisory panel, could you please provide clarity regarding the timing of the formation of the panel and the process that will be involved in the selection of members?
The panel will be appointed to provide strategic advice to both the Minister and to myself in formulation of an implementation of the work program to deliver the government's response to the financial sustainability inquiry. There are a number of processes under Premier's memorandum about the appointment of boards and so on. So we need to go through that process. There needs to be consultation engagement with the Public Service Commissioner, which has commenced. We had been talking to the Minister around a number of different options for the expert advisory panel. I think we had put options to the Minister that effectively was let's use it as a stakeholder-driven panel. So we would go and say to local government New South Wales, to the unions, to the finance professionals, would you like to nominate someone to participate? We also had the perspective and that would have given us a panel of maybe 15 people. We also had the perspective from the Minister that no, I want experts and I want them to be giving me advice and to pierce some of the issues around local government financial sustainability that has been discussed, in quite some detail this morning, just as an example. So it's really a case of identifying those people that understand local government, understand how local government has shifted and changed over time, and the professional viewpoints that they bring from their experience. So that's the process by which the panel will be appointed, and it will be appointed to give the Minister strategic advice.
Thank you. The issue of Cumberland Council, I sort of raised this in the morning session, but the two councillors that were screaming at each other, and then the clip went viral on social media and got some media reporting. Has any action been taken, or has it been escalated to OLG, or in that case is it simply a matter of going through the existing code of conduct and code of meeting practice arrangements internally at Cumberland?
I don't want to get into specific examples of complaints. I don't want to do that because it just weaponises that process. People make complaints because they were unhappy with what someone said. Then someone retaliates with another complaint. We end up with people making a complaint and telling people that they've made a complaint, which they're not supposed to do, or you end up with people making anonymous complaints or complaints under an alias, and then telling people what the status of their complaint is, and it gets written up in the media. All of these things are not hypothetical. These are things that I've experienced in the last 12 months. So I don't want to entertain actual discussion of specific issues. I think where we're talking about issues emanating from council meetings, ministers talked quite extensively this morning. You've seen the updated meeting code, the importance of bringing dignity and prestige back to council chambers. And it can be as simple as the way the council chamber is set up. I mean, if you look at this chamber, for example, there's quite clear that there are elected representatives and there are staff, and there is a clear separation, there is a clear degree of respect. In some council chambers that I've visited, it's effectively a couple of formica tables, with people and daggy chairs, and there might be a picture of the king in the background somewhere. It does not lend a degree of respect and decorum that proper political debate should entail. And I do think that when you get councillors yelling and screaming at each other, it's a bit of a reflection of the fact that decorum has been lost.
Thank you. demergers. I was wondering if you could provide an update on the cost, demerger cost involved to the ratepayers and to the state government of Cootamundra-Gundagai, and then also for Snowy Valleys. I know they're two different processes that are in place, and different funding arrangements, but yeah, an update on that would be helpful.
Minister Hoenig has announced, in the case of Cootamundra-Gundagai, that the council is free to go about its demerger process. He has also met with the council. I was in the room when he met with them and said, it's up to you to identify how to best manage this demerger. He encouraged, and I'm quite pleased the council has taken this up. They've established a committee, so a demerger, project committee, and that committee is working through the issues that they need to put in place to implement the demerger. And so any costs that will come from that, they'll be able to understand and manage and look at that.
But they have to fund it themselves.
They have to fund it themselves,
yeah.
And ministers made that quite clear to them.
Yeah.
In the case of Snowy Valleys, the minister has said we have a positive report from the Boundaries Commission. The next step for Snowy Valleys is once the consultation with the Electoral Commissioner is complete on a referendum, they will go to a referendum. So that consultation with the Electoral Commissioner has started. The Minister also encouraged Snowy Valleys to look at the costs. The Council has presented as part of its demerger proposals a business case and then a more detailed implementation plan.
But if the referendum's successful, it would be similar to Cootamundra-Gundagai where they would have to fund it themselves?
No, because they're two separate paths under the Local Government Act.
So they could have a different arrangement?
They could have a different arrangement, but the view that the Minister gave to Snowy Valleys Council is their implementation plan calls for special rate variations of between 10 and 15% in Tumut and 44 to 64% in Tumbarumba.
Wow.
And the Minister said, perhaps you want to go back and look at that and see whether that's what you need, what you want, and what is driving those transition costs, including things like IT. And perhaps you can update that as part of putting a case to the community about the referendum. And the comment was made that once the referendum is held, and if it is a positive outcome, then they can come to the Minister and he will consider it. But he also said that multiple issues on the government purse that need to be considered as well.
Thank you.
Thank you. Back to the pet registry. Mr. Wentworth, I just want to take a step back and sort of pull apart some of the different sort of bits and pieces that seem to have gone wrong with the development of that pet registry. There was the incident, and I raised my concerns at the time that community members, particularly those non-registered rescues who were using the pet registry, were taken by surprise by the changes, and many found themselves actually locked out of the pet registry, including, for example, a pet shop and 80 plus dogs registered to them. Are you able to explain why there wasn't a proper marketing and education campaign, including to key stakeholders, to let them know that those changes were coming?
The funding that was provided for the pet registry also included some operational funding to develop education materials and advisory materials. There is also an extensive database of contacts, and I was assured that we were using those extensive database of contacts. I had seen some of the collateral that had been produced, and wanted to make sure that, and I cannot but express my frustration about the pet registry. It is a good product. It will secure important data. it will make it easier for people to get access to that data, but we just need to keep going and improve its delivery and its operation. I do feel that we also have a particular issue, and this goes to that question about collateral and communication, that there is a very low transition from microchipped animals to registered animals, very low. And that with improved knowledge and understanding of the registration processes, we can actually increase the number of registrations. You increase the number of registrations, you get a much better perspective from owners as to their obligations, because I'm paying money, so I must have an obligation. The more money we receive also means the more we can invest it into education programs, improved pound programs, improved animal welfare outcomes. So a lot of this stems from we need to do a much better job at that education and that making people aware of the registry. And so I run a very fine line here in that the pet registry is not as operational as what we'd like it to be, but it is operational, it is functional, and we can improve it, and that people should not be afraid of registering their pet because it will actually make it better for them in the long run.
Yeah, no, I'm definitely not encouraging people not to use it. I think I'm just trying to sort of find out the background as to some of the concerns that had come up. And talking a bit about some of that sort of background educational piece and marketing, I understand around that at some point in time, $100,000 was spent with an external creative agency to mock up designs and a 60-second video to explain the new pet registry process. Has that ever been used?
No, I don't believe that it's been used. I also was somewhat horrified when I saw the outcome of that. You know, for reasons that I don't want to go into, there is a lot of collateral that was developed, and I want to make sure that we can still, I don't believe that it's soured, so it's still usable. It's just getting it in the right place and at the right time.
Okay, so there's still hope to release that information at some point, that video that was... there will be elements to that. I think there were some elements to the video that I was just somewhat horrified about. Right, so the video itself has to change?
Elements of it, I believe, yeah.
Okay. So after the, just going back a bit when I talked about those people getting locked out of the pet registry, we then went into this sort of limbo period where it was anticipated that the full Link My Pet rollout would be delivered by September or October 2024. That got delayed until January 2025. I understand that was a really difficult time for the help desk and the call centre staff who were inundated with calls and complaints with the registry. Can you talk a little bit about this and any support that had to be put into place during that period for those workers dealing with the extra complaints?
We certainly had to increase the number of people working on the pet helpline, and I think the challenges were there were some circumstances where where all the data has been entered correctly and where the Service New South Wales account links up with the data that's been entered correctly with the microchip, then it all works perfectly. Where there is some sort of data, inconsistency, then the whole thing is challenging. And that was one of the reasons why there were so many people that kept calling the pet helpline. We did move quite quickly. We got more staff in. We used, and again, I had to use money for staff that I probably would have wanted to use in other, more reform areas. So again, another degree of frustration for me that a system that was going to work had meant that we actually had to sort of go backwards. And invest in people to help, through that process. Norshi, I believe we have how many people now working on the pet helpline? It's We have 3 people working on the pet helpline. At one point we had, I think it was 8 people working on the pet helpline. So we used some funding to surge, up the personnel on the pet helpline, and also, and I kept asking the question, what can we do to make this better? Because I was concerned about, the welfare of my staff, dealing with some pretty frustrated people. So what lessons could we take and how could we make it better? And I hope that we're able to do that.
Thank you. When we spoke at the previous budget estimates in relation to Pet Registry, you said that that you've created a new governance structure to ensure that we can improve the understanding and knowledge of the more senior executives in both the Office of Local Government and Department of Customer Service. Can you explain any concerns that you might have had about governance concerning the Pet Registry?
I had a lack of vision over the project management of the Pet Registry project. I would ask for updates and I would be told that it's okay. I had multiple people, look at it. We were required by the fact that it's an ICT project to have a health check done. So it's an independent health check process, and it had identified a large number of concerns with the project management. There wasn't a project control group. There wasn't there was nothing to escalate up. There was very active and willing engagement between the Office of Local Government staff and the Department of Customer Service staff. So there's no allegation that people weren't talking, but there was no clarity around how decisions were being taken. So I found out that decisions have been taken that should have been taken at my level, where I should have even consulted with my secretary or with the minister, that had been taken and that I was unaware of. So I was absolutely horrified. And so it was as a result of that we implemented different governance arrangements. And I also wanted to make sure that the Department of Customer Service was aware of the importance of this project and that they were giving me their support and a direct line into their senior management, which they have done and they do.
Thank you. And can you give me a bit of an insight into what those different government arrangements will look like now?
So we have a steerco. We have a Norshi can probably help. Ms. Rahman can help with some of that detail. But we have a steerco that meets monthly, and we have a project control group
That meets monthly, but in between the steerco, so every fortnight. We also have 15-minute catch-ups at the DepSec level between DCS and OLG. That's a recent development where we just got, And
that's a weekly meeting.
Great. And will that include oversight of specific senior executives as well within that, or?
Sorry, but
So will that sort of those changes around the different government arrangements, will that include greater oversight of the specific senior executives?
Well, I have the senior. So I have the executive director for sector development, who Tina is acting in that role, is part of that. Ms. Rahman is part of that. We have the relevant project director and the executive director from DCS and the deputy secretary from DCS, and I'm also in that meeting as well.
Thank you. Ms. Abigail Boyd.
Oh, thank you, Chair. Good afternoon to all of you. My questions are going to be for IPART, actually. So I'll start with you, Mr. Nichols. How many SIV applications did IPART release a second version of the document with revisions or corrections?
I think there was 2. Yeah,
two? What were they?
There was some typographical errors that were identified in 2 of the documents that were corrected.
So which councils?
Northern Beaches and North Sydney, I think. I'm just checking with the team. That's
Northern Beaches and North Sydney. Okay. And how was the community notified of those revisions?
The revisions were placed on our website, and we communicated to the relevant councils as well.
Okay. I understand that when the original decisions were released on the 16th of May, IPART accompanied those decisions with a media release. Were the media notified when there were updated versions?
I don't believe that they were, no.
So you say they're typographical errors. I'll take you to one example. The Northern Beaches Council special rate variation application was granted a partial approval, and then 6 days later the document was amended to make a number of corrections. The original report made multiple references and considered as a relevant factor in declining the SRV in full to the impact on pensioners, and the report made the claim that in order to be eligible for a pensioner discount, a certain number of volunteer hours must be demonstrated by these pensioners by the council. That is not and has never been a policy of the council, and IPART was required to make corrections on multiple pages to remove that entirely fabricated claim. That seems more than just typographical.
Well, there was a misunderstanding about how that particular arrangement was working with the council. IPART prides itself on ensuring that our documents are accurate and can be trusted, and we wanted to correct the record. The reason I say they're typographic is that they weren't substantive changes that would have changed the decision of the tribunal.
Where did that claim come from, though? Like,
Sorry.
how does that kind of claim that there's a policy that council has for requiring pensioners to do volunteer hours to be eligible for a pensioner discount, which is completely not true and has never been true for Northern Beaches Council? How did that make its way into the document in the first place?
Look, I believe it was a misunderstanding at an officer level, but I'm happy to take that question on notice.
So although one of the relevant factors in declining the SRV in that case was the impact on pensioners, you're saying that this particular error had no substantive impact on the decision?
So that's correct. The tribunal, so just to perhaps take a step back, I'm not a member of the tribunal, I lead the secretariat. The tribunal makes its decisions, looking at 6 criteria that the Office of Local Government has laid out that councils must meet in order to meet the necessary hurdles to have a special rate variation approved. And so that particular issue would not have changed the assessment against each of those 6 criteria in any substantive way. It was a misunderstanding at an officer level. So
sorry, just to drill down into that. So then when the error was picked up, did the tribunal meet again to consider whether it was substantive? It did. And they...
Yes, we always, yes, that's right.
Okay.
Yes.
So let's look at North Sydney Council. They had its SRV application rejected. 10 weeks later, IPART made a really quite large number of corrections, and those changes went unannounced, despite the high level of community interest and engagement in the matter and the amount of reporting on it. So, for example, a data table had been updated in the corrected version to show the average of rates not on the minimum, and the differences in dollars and percentage terms were recalculated. The sources for the data in the table have now been included, and the percentage in the sentence current minimum rate of $715 is 31% lower than the average residential rate of those ratepayers who are paying above the minimum rate, has now been changed to 55%. So you've got 31% going to 55%. Clarifications are made to a number of pages to include footnotes and notes to tables to explain the impact that the proposed minimum rate increases are partly offset by the council's proposal to remove the additional levies that apply to minimum rates assessments, previously paid on average around $97 that are now included in the proposed minimum rate. I could go on. There's one in relation to the cash expense cover ratio as defined by the Office of Local Government. All of these things are quite, when you put them all together, are quite a significant number of financial errors and assumptions. Are you saying that, I mean, firstly, how does that many errors get made? And how does none of that have an impact then on the decision?
So we had representations made for those errors that you've identified. We brought those to the attention of the tribunal immediately upon those issues being raised, and we made corrections. But if you recall, in relation to North Sydney, the decision was to reject the application in full, and those amendments did not change the perspective of the tribunal that was, presented with those issues in terms of changing the decision to anything other than the rejection that they approved.
So when you say it happened at officer level, so is that the officers that sort of put together the information
That's right.
for the tribunal?
That's right. So that's correct.
Okay.
So we have officers within IPART that examine all of the special rate variation applications that come in. They will get input from the community, they'll get input from the council, and they piece together the reports that go to the tribunal. And so in both of these cases, there were either methodological errors or misunderstandings that were drawn to our attention that we fixed, brought to the attention of the tribunal immediately and fixed. And we do that as a matter of course in IPART. Whenever we identify that there is something that's incorrect in the public domain, because we think it's important that the reports of IPART can be relied upon.
I mean, that cash expense cover ratio error was quite significant. Firstly, I don't really understand how a person who is in charge of putting this sort of information together wouldn't know what the definition of cash expense cover ratio was. But it overstated the liquidity levels that the council has available to meet short-term liabilities quite significantly with that error. Is there just a reticence that once IPART's made a determination that it doesn't want to go back on that regardless? Is it just embarrassing that there's that amount of errors?
We are very open that there are the errors that occurred and we fix them. The tribunal will, as a matter of course, consider if there is any change to their position, and this applies generally, not just specifically to this matter, and there was no decision taken by the tribunal to change the decision that they took.
The IPART determination in the case of North Sydney directly commented on the cash expense cover ratio and used that as one of the reasons, one of the rationale for why it rejected the SRV application. Was there no sort of need seen, I guess, to, when that was then raised with the tribunal, for them to acknowledge that that was a significant difference and maybe issue some sort of communication about that?
Well, these are things that we did communicate back to the council, and we have published an erratum online. And as I say, there was no basis to change the decision to reject that proposal.
I understand that IPART's supposed to be independent. It's in the name. Do you think it would be inappropriate for IPART leadership to be meeting with elected representatives, lobbying one way or another on application?
Well, IPART, the tribunal members will from time to time meet with stakeholders to explain processes and to give consideration to how input can be made. That's a matter of course. We publish a public register of all meetings that occur, including if there are meetings with elected representatives, and we have complete openness about that.
So looking at that register of meetings, there's only been 2 meetings with elected members, with IPART members since all the way back to 2022. The first one was with the member for Barwon, Roy Butler, relating to the investigation to Broken Hill and its loss of power. Makes sense? The other, on the 7th of March 2025, was the member for the North Shore, Felicity Wilson, who met with the IPART chair, Carmel Donnelly, and IPART staff. What was that about, and why was it felt appropriate to meet with somebody who was actively lobbying for a decision one way or the other with IPART?
The local members, I understand it, I wasn't at that meeting, but there was certainly an IPART officer who was present, and the meeting has been recorded appropriately in our public registers. Was an opportunity to explain to the member about how the IPART processes work, what we can consider as part of our assessment, and it was confined purely to process.
Could you provide on notice some minutes of that meeting?
I believe we could
Thank you.
take that on notice.
Thank you. The opposition.
Thanks, Chair. Mr Whitworth, The new influx of staff members that the Minister raised, 129 in total, I believe, what roles are to be fulfilled with the new staff members?
It's additional roles throughout the structure. So we've moved to increase the investigations team. So we've increased the number of people in the investigations team. The investigations and the interventions team. We've recrafted it. So we have more investigators, but we also have more people that have the role of managing the interventions that we do with council, so performance improvement orders and the like. We have increased the strategic reform team so that we can implement the Minister's agenda around the improved councillor conduct framework, the financial sustainability reforms, and to assist with the meeting code of practice changes as well. I have been trying to increase the companion animals team and the companion animals policy team and bring some more structure to it. So I created quite specifically a director of companion animals policy and programs, Ms. Rahman, who's here today. And I did increase the, I did install 2 executive directors. There was 1 executive director, but I had 2 executive directors that relieves, not just relieves the pressure on me, but also enables me to be more strategic in the way I'm dealing with councils and to give my 2 executive directors far more responsibility around the program delivery of both reforms and reviews of council activity. And I kept thinking I've missed one, and I have. I've missed 2. We have the increase of staff as a result of the $252 million investment in apprentices, trainees and cadets and that grant program. So that's a full team that's stood up and funded under that program. And we also have greater financial and data analysts in our performance and delivery area.
And what is the time frame for all of this? So I believe the answer previously was that some have already commenced, and the total number of 129 is to be achieved
by the end of this year. So Minister Hoenig had figures by the end of June this year, and tell you as of today the head count for the Office of Local Government is 115. When I started in the Office of Local Government in January 2023, there was effectively 45 people.
Yep, he mentioned that.
Well, I do mention it because we've had a lot of criticism of the local Office of Local Government and our performance and delivery, and we've worked hard to try and address our credibility with Treasury, our credibility with the local government sector, and our credibility with our own staff by increasing both the number of people but also getting results.
Don't get me wrong, Mr. Whitworth, I agree with you needing more help in OLG. Absolutely I do, and I'm very, very aware of it. So I am pleased to hear that this is the case. I am then just mindful of when and how quickly we can expect this additional help to start rolling out, because then I come to the questions of when can we expect the 2025 Auditor General's report?
Well, that's a question for the Auditor General.
But I mean, you normally have an idea of when it would be expected, don't you? Is it? I mean, this year I believe it was released in March, so you wouldn't be expecting it until early next year. I'm talking about the audits of councils.
Yeah, so that's the Auditor General. So the audits of councils are going on right now for the 24-25 financial year.
Okay, so they're not completed yet.
No, but they would very rarely be completed this early.
Okay, sorry, I'm just trying to get the time frame right. So we had 2024 that was released in March this year, is that right?
That seems to be about the right time frame.
Yeah, okay. So we'd be looking at early next year for that to then be brought
forward. It's roughly
forward.
the same time each year.
Yeah, right. So, okay, it's just that I'm harking back then to previous figures because the number of councils then as part of that, can you confirm the number in the previous, or the current report, I'm sorry, considered unsustainable or at risk?
Well, that was quite a controversial decision by the Auditor General.
Right.
And that decision related to the amount of cash that those councils had based on a performance ratio. And there are a number of councils that argued that that didn't take into account some of the other reserves that they had, and it didn't take into account the way that that cash is calculated. And I just, wanted people to confirm that if my memory serves correct, Camden was one of those councils that was a problem council. Yeah, Camden Council has a significant amount of developer contributions. Those developer contributions aren't necessarily identified as available cash because they're restricted accounts. And so, but the council is spending the developer contributions to provide the new infrastructure and services for its new community.
Yes.
So it looks like it's spending more money than what it has, but it's actually spending the money it's received. It's just the way the performance ratios, the accounting standards, it implies that it has a cash flow problem.
So Camden Council, through VPA, got a new library and nearly completed their new sports centre, but that wouldn't be captured in the way the accounting standards work.
So,
okay, but when you're using the word controversial on whose part? Are you suggesting that councils aren't being, let's be generous and say, fully transparent about the information that they're providing?
So this is also one of the reasons why we have moved to require councils to produce in a consistent format a quarterly budget review statement and to provide us with that information. So in terms of our job as a regulator of councils and the risk management approach that we take with council finances, I can't wait until March to understand the risk that we had from the previous year. So we use quarterly budget review statements, we use regular conversations with councils. So what the Auditor General reported on was the extent to which councils met the performance ratios that the Office of Local Government had identified, and one of those was cash. And I have identified, and in fact the Financial Sustainability Inquiry was critical of those performance ratios because they don't give a true record or measure of how a council is performing. It was, as I said, one of the reasons that we moved to have the quarterly budget review statement, which was consistently identified, consistently provided to councillors, so that they've got a much better understanding of where they're at in terms of their budget and what their financial risks are, and given to us in a consistent digital form, so that we're able to analyse and review it in a much more effective way, and a much more timely way too, I should say.
So, am I hearing you correctly, Mr. Whitworth? Are you suggesting that it's not as bad for councils as they're making it out to be? There
are some councils where we all sweat at the end of the financial year. And the part of the challenge was that our colleagues in the Commonwealth Government decided to give us, I think they gave us a week this time rather than giving us a day.
But the year that we're referring to was a day, because it was a horrible day.
Yeah. To provide the advance payment of the financial assistance grants and that cash injection into the councils. So what I am saying to you is that the financial sustainability of councils is an ongoing challenge. There are councils that we are actively engaged in. They know who they are, we know who they are. We work with those councils. We also want to have a better understanding more generally of the council sector, using the quarterly budget review statement process, and then the annual accounts. And this is where budget and accounts are not necessarily the same thing. The annual accounts that the Auditor General compiles does give us a useful understanding of the state of the sector.
Okay, so could you explain to me, because I don't know, is it in taking into account what you're talking about now, does that also factor in councils that fail their audits?
When you say a council fails their audit,
Doesn't meet the criteria that OLG has imposed?
the audit can either have a disclaimer of opinion, or it can have a qualified opinion, or it can have an opinion, and in that opinion there can be a number of recurring Tina, help me out, please. The recommendations. Thank you. Recommendations. So it's not that you can say a council fails an audit unless there is a disclaimer of audit. And so we've had a number of disclaimers of audits where the councils have either not been able to produce records, so because of an IT system.
So I'm just clarifying this myself. Yeah. So a disclaimer then is essentially suggesting that they can't meet the requirements as set.
They can't report that they've met the requirements as set.
Okay.
So we've had one where they couldn't meet that they had a disclaimer because they couldn't compile their records. We had another council that had a disclaimer of audit because their records, they could produce records of spending, but they couldn't produce it in a form where you could disaggregate the accounts in such a way to understand where the different accounts and obligations were going. Both of those, one of those councils is still on that path to recovery. Another one is, well and truly recovered. So this is part of that challenge between budget and audit. Budget is then how much money do we have to run effectively a council and deliver services to the community, and will we have enough money to deliver that by over the course of the financial year? So famously, the council that failed in that budget exercise was Central Coast, and this is harking back several years ago to the public inquiry and the process of administration, where the council did not have enough money to provide salaries and needed to get a letter of comfort from the government so that it could obtain external finances. So that's as I said, that council wasn't necessarily picked up through the auditing process. So this is why I try and take some time to distinguish between budgeting and the management of cash and the delivery of services, and auditing, which is a sort of end of the financial year assessment as to were all transactions accounted for, were accounting standards complied with, was there any inappropriate outflow of money, and so on. But it's not necessarily a health check on the council.
Okay, so if we come back to the Central Council example then, and you're also talking about the process. So what is the process if they can't recover? And what is the, I don't know, I guess I'm looking for here the level of concern around all of this. If you know that there are councils that are in difficulties, what is that process? They shut up shop and say we can't do it anymore, you appoint an administrator and we move on? How does it work?
Well, those are the extreme examples.
Yes, but that's what I would like to hear about.
I'd prefer to talk about our successes rather than
I'm sure we do, but we also need to look at the worst case scenarios.
So there are a number of councils, as I said, that were quite lean in their budgets, and this is where we talk about the finances available to a council are either their restricted accounts or their unrestricted accounts. Their restricted accounts relate to matters that funds that they are given for a specific purpose. So water, sewer, development contributions. We have had a number of councils where their unrestricted funds were quite lean. And in fact, they were on a trajectory, sorry, I'm not allowed to use that word anymore. They were going to end up into a cash deficit situation. One particular council had been relying on the sale of industrial and residential land. They were a property developer to re-inject cash into their business, and they were struggling with that funding. But they did have a healthy reserve in their water and or sewer account. So we authorised a loan so that they could manage that cash flow approach. When we do that with councils, we also talk to them about their long-term financial plan and ask them to update. So it's an obligation under the Local Government Act that every council has a 10-year long-term financial plan, and we ask them to update that.
Yep.
So the successes in that example are we know that Yass Council has a long-term financial challenge and that it knows that it needs to look at both its fees, charges, and whether it needs to look at rates as well.
Yeah, but it's also received election commitments around its current infrastructure upgrade as well, so assisting in that.
Yes, but in a strange, but that's about the water treatment plant.
Yes.
But that was also, again, that goes to the service issue that the council could have, the council's finances weren't tied to that water treatment plant. The council's service delivery was tied to the water treatment plant, but not the services. They could have continued to the community would be asked to continue to put up with bad water supply.
Yeah, that's right.
Or they get a grant
That's
to
right.
upgrade it. Yeah.
And I do want to get to that with you as
Sorry.
well in terms of, no, not at all. This is helpful. I appreciate it, but I do want to get up to the cost shifting. But before, let's sort of be a bit more definitive about this then. If we're talking about councils that are potentially in difficult circumstances, has the number of councils looking at levying special rate variations changed? So the figure for 2024-2025, I think we raised this at last estimates, how many there were?
So 24-25 was 6.
6? Why do I have 9 on a list?
That could have been the year before, 9.
I've got 24-25, could be.
So 24-25 was just the subject of the discussion. So there was there was
So,
North Sydney,
sorry,
Northern
it was
Beaches.
23-24 in that case. 23-24. So
Yep.
you're talking about 6 on the current list.
On the 24-25,
Yes.
and
So
I do
9
know-
on the 23-24 list.
Yep.
And are you expecting that figure to change for the next report? Just, like obviously you don't
Yep.
have the information to hand.
Yep.
Anecdotally.
Councils will need to make that formal decision by February in 2026, but I am expecting that that number will be as high as this year, if not higher.
Right. And that also suggests that these problems aren't just imaginary, that they are dealing with serious issues in this regard, or they wouldn't need to look at such a thing.
Oh, absolutely, and I don't think we've talked quite openly about the financial challenges in front of councils. We've had the financial sustainability inquiry. It's talked about the pressure being put on councils from the way statutory fees are established, the impacts of rating and some of the rating decisions and rating exemptions.
Yes.
We talked about the application of accounting standards and the implications of depreciation and valuation, and we've also talked about the impact of the financial assistance grants that come from the Commonwealth.
Yes, that's right, cut, yes,
and the
exactly.
need for a greater share of those financial assistance grants from the Commonwealth.
Yes, and I agree with that as well. But let's come back to when you talked about your philosophical debate on cost shifting. I mean, that suggestion is kind of a little bit difficult to marry with what we've just been talking about now, when you have the Mayor of Albury saying that council is absorbing $11 million annually in costs that should rightly sit with the New South Wales government, which is double the figure of 10 years ago. We had a parliamentary committee that found rural and regional councils in particular had become the provider of last resort, offering services like childcare and even medical facilities when there was no service delivery alternative available from the state or federal government. It's not really a matter of choice when there is no alternative. And how can you really suggest that councils are being, they have that option to say, well, we will or won't provide you with services that a community is otherwise not being provided?
So I know Ms Overall of a council in central west New South Wales that's facing a real challenge in terms of the aged care services that it provides.
I can name plenty of them.
And it is facing that really challenging decision. Can it continue to provide those services, or can it actually provide local services and keep its staff paid? And so it's asking itself the question, we are an entrant into a market If we exit from the market, will someone else come into
And
the market?
in that instance, when it comes to something like aged care, I agree with you in terms of it is not a council's responsibility, and outside of, some of those that do, traditionally it wouldn't be. But you can't really suggest that offering less services from a council outside of things like that, but in terms of everyday necessary services, that cannot be sustainable into the future. And the idea that cost shifting isn't impacting that is a little bit difficult to understand.
Well, I don't think you characterised my argument very fairly, but...
Well, we can get back to it the next time.
Thank you. I'm just going to start my round with a few minutes, and then I'll do a shorter round after our afternoon tea break. Mr. Whitworth, just to sort of round off my questions in regards to the pet registry, can you explain how the decision to integrate the companion animals register with the pet registry in 2023 delayed the planned timeline to upgrade the pet registry?
That's a pretty detailed question. And what I can tell you is part of the business case for the pet registry was the companion animals register is more than 20 years old. It's operating under an old system. That old system will not be supported soon, and is the third largest digital database in New South Wales. To have a system that is not supported provides a cybersecurity risk. Mm-hmm. And that was one of our propositions as to why we needed a pet registry. I found out that people believed that they could invest money into the companion animals register, secure its operation, and then move to the other elements of the pet registry. Mm. That was not a decision that was taken with my authorisation. That was not a decision that was taken with the department's digital information office, and so we ended up with a circumstance where we now have to move quickly to ensure that when the support for that companion animals register ends, that it does not create a significant problem for us. So when you say, some of the, how did that decision-making process go? I've talked about the health check. I've talked about the importance of improving the governance arrangements and decision-making processes. I think I'm just trying to understand a bit more about the impact of integrating the car into the pet registry. So I guess I'm just trying to understand, from someone that probably doesn't have as much oversight either, and I understand when you stepped in, you probably felt the same as me. You've got bits of information. And so I'm just trying to understand, when this pet registry was created and then there was this decision to integrate the car into it, and I'm just wondering how that impacted the whole project. Well, I think that impacted the project in that it gave us a very good interface, but it has still left us with the underlying structural issue of addressing the cyber security strength of the companion animals register. Now, I'm not saying that it's not secure, but it's not going to be supported in the future, which then creates problems for the security. Also, I'm sorry, I'll be brief as well. The way in which the integrations occur, if the data from your Service New South Wales account matches the data from the companion animals register, then they integrate beautifully. But where they don't quite match up, then there is a problem. I haven't linked my pet because my pet's owned by my wife's estate, and I don't know how to go. That challenging process of converting that across means that there will be a disjunct between the Service New South Wales account and the companion animals register. So these are the issues that we wanted to delve into and address as part of stage 2.
Great, thank you. The committee will now break for 15 minutes and we'll be back at 3:45.
Thank you, Chair.
Thank you. Welcome back to budget estimates. I might need Nushi to come forward as well. Thank you. Happy for Mr. Whitworth or whoever to take these. Actually, no, these are quite specific to Mr. Rahman. Now I'm reading through them. I'd like to ask some questions about your new role as Director for Companion Animals Policy and Programs. We know this came about after the allocation of $37 million in a previous budget budget to bolster the capacity of OLG. Are you supported by dedicated staff or a team, or are you sort of filling the role solely?
So, if it's okay, I still would like questions directed through me, if that's okay.
That's fine.
And I will let Norshi respond to the dedicated team, but the decision to have a Director of Companion Animals Policy and Programs was mine as part of the restructure of the Office of Local Government, because I knew that I needed a dedicated role. In the past, in the Office of Local Government, responsibility for companion animals had been split across the organisation, and I wanted to bring it together into a more focused area. And we are now in the process of establishing the dedicated staff for Ms. Rahman. We do, and there is a piece of work going on to establish that. Ms. Rahman, you've got how many people working for you at the moment?
There are 5 within the pet helpline, and then for supporting the puppy farm build, we have a 1, 2, 3, 4, 5, 6, 7, 8, 9 other staff.
And they're all just for the puppy farm build?
2 of them are. I mean, there's been a lot of turnover within and change within with the restructure, so people have been reallocated to different teams. Yeah. So we've got 2 staff who have corporate knowledge of the previous build, and so that's been very helpful for this project. And then we brought on 6 other staff for the puppy farm build specifically. Some are BAs, some are project officers, and some are doing the actual exemptions assessments, and then a very recent project manager who's going to support as well.
And I should say that Ms. Rahman can also draw on the policy team for the assistance around the Companion Animals Act review.
Okay. And will any of those staff be sort of moved into that sort of review as well at any point, or are they completely focused on the puppy farm rebuild and the helpline?
Well, I'd like to create a core competency around policy and programs within the companion animals team. So hopefully yes, but again, I need to manage that funding. I am managing the funding within the Office of Local Government. We do have more funding, that is absolutely true, but we're still a very small organisation, and every dollar is valuable in terms of our labour expense, and we're still operating under a labour expense cap. So managing that means that I need to be careful to operate both within the labour expense cap and to establish where I can obtain, for the want of a better word, cash to fund the people.
Mm-hmm. And can you tell me a little bit more about the priorities of the companion animal role? Like, will it be primarily sort of, overseeing some of that puppy farm build and sort of any sort of rollout of that pet registry, or will it be heavily involved with the review of the Act as well?
All of those. Why I created the title around companion animals policy and programs. Will have a significant role in being the policy and strategic driver behind. The government's identified that it's going to provide a $6 million grant over multiple years for rehoming the companion animal organisation, so important role there. A driver for the Companion Animals Act review and the integration with the work of our colleagues from DPIRT around the Office of Animal Welfare and the various reviews of the POCTA Act that are going on.
Thank you. And will anything be done to further support rescue and rehoming organisations within this role, given that, their constant struggle. I understand that there's more grants that are coming out soon, but will there be any additional support through the Office of Local Government or through this role?
So I identified earlier in my testimony the importance of how we work with the rehoming organisations and the companion animal volunteer groups. I think when you look at the policy environment of companion animals, you can immediately see that there is a crisis point in terms of the way the pounds are operating and the network of rehoming organisations. So some additional funding will certainly help that, but we need to tap into that expertise and the significant contribution and knowledge that those people have to help us make the system work more effectively. We obviously need to talk to councils, and when we're talking to councils around companion animals, invariably we're talking to the rangers or the environmental health officers, so we're getting a regulatory perspective. We're not necessarily getting an animal welfare or a humane perspective, which isn't to say that they don't share that or carry that, but there are different mindsets that people bring to that. So I want to harness that more effectively and want to make clear that in the review of the companion animals laws that we need to tap into that area of expertise far more thoroughly.
Thank you. And I know, Ms. Rahman, we've spoken about it before, but I just wanted to get on the record in regards to the puppy farming bill. How many breeders have been granted an exemption so far to have more than 20 dogs under the new regime?
So, Ms. Rahman, can you
I can answer that.
Thank you.
So far we've had 42 breeders make applications for an exemption. So far through our approvals process, 25 have been approved. The total dogs included so far, in total would be 1,722. The range of exemptions between the smallest exemption to the highest exemption so far is 25 dogs to 78 dogs. And so far there are only 10 breeders with more than 50 dogs, which means by the 1st of December next year, they would have to bring it down to 50.
Thank you so much for that. Dr. Cobb.
Thanks, Chair. Mr. Whitworth, you were just talking about the restructure. I asked you about the $37 million of funding about a year ago, and it was probably too soon to have asked that question. Can you provide some more detail around the rest of the restructure in addition to the discussion that we just had about the companion animals role?
Certainly. I do feel that I've given... so the answer that I've provided to Ms. Overall does give a perspective of the different areas in which I've increased the resources and the staff numbers of the Office of Local Government. Quickly recapping, more people in the investigations, a specific interventions unit, increase in our data and performance capability, the performance team, financial performance team, creation of the strategic reform team, and the creation of a new team for the trainees and apprentices and cadets. So that's where the bulk of that additional staff comes in, as well as with the revamped executive structure.
I'm not asking you to repeat the numbers that were already provided, but I suppose what was the capability uplift? What are the things that you feel the office is able to do now that may have previously been more challenging?
I feel that we are far more capable of seeing the early warning threats and signs in terms of individual council financial performance. Our data capability there is much improved, and it's not a criticism of the staff, it's just that we've got more people and we can be more effective in that. We've been in creating the interventions team. We have been able to take work away from our governance team. So our governance team had multiple responsibilities around interventions management, the provision of advice and policy development. And by taking the interventions roll away from that team, I've freed that team up to be able to do more policy work. So out of that team, we've had the policy work associated with the elections bill. We released last week the procurement guidelines, the draft procurement guidelines update, which is something that has been a long-standing, issue that lived rent-free in my brain because of multiple references from different inquiries about the importance of the procurement guideline update, meeting code, and that team is well and truly on its way with producing the diversity report on the 2024 council elections as well. So they're just a couple of examples of where that increased capability has come about. I feel like I've been able to get quicker at producing and releasing policy work, and the submissions that come, the fact that we're almost ready to go with the Companion Animals Act review submissions, which closed, I think, at the end of May. There were 3,600 submissions. We're just about ready to release those now, whereas with the meeting code and with the discussion paper, it took us nearly 6 months or more to do. So these are just examples of how we're getting better at and building that capability.
Okay. Thank you.
Sorry, you asked a question before about where people should go with where there's a report of welfare conditions or so on. And I probably should have also mentioned the fact that there are a number of authorised agencies under the POCTA Act. Some of those are approved charitable organisations like RSPCA and Animal Welfare League. We also have the police and the Greyhound Welfare Integrity Agency.
That's all right, thank you. I was more interested in your specific process of what happened when something came to your attention specifically. I previously asked the Minister a question about the issue of pecuniary interest disclosures for councillors, and particularly concerns that at some councils addresses other than people's primary residence were being redacted. You're also, I'm sure, well aware of the issue with overseas property interests. When I asked the Minister about it previously, he said, I might have the OLG have a look at the current provisions and see if I can make some quick change. Well, has there any work been done to follow that up?
The pecuniary interest the register of pecuniary interest happens as part of the Code of Conduct. And so the work that was alluded to this morning around the Code of Conduct will give us that update. So putting aside the alignment with parliamentary processes for pecuniary interest identification, we've talked about the importance of having all pecuniary interests identified, but not the specific address of a primary residence and a secondary residence, which I think is a fairly practical and reasonable approach. So that will be part of that Code of Conduct work that we are actively engaging with the Minister on at this point in time.
Thank you. Regarding Code of Conduct complaints, I've previously asked you about figures for
Yes.
numbers of complaints received. Have you got figures for 24-25?
I do not have figures for 24-25. We should have them shortly. I should explain that in order to get those figures, what we need to do is to take every bit of correspondence that comes into the organisation, and when it comes in, we characterise it, give the right metadata so it can be searched, but it requires human involvement in the sense that someone's got to characterise it in the correct way, and then we've got to make sure that they all match up. So I am assured that we are close, but I do not have those data.
Okay. Close enough that you could take my question on notice?
I can take that question on notice, yeah.
Thank you.
Although, I'm more than happy to take it on notice, but when I say I'm close, I don't know whether I'm close within 2 weeks or whether I'm close within 4 weeks.
Okay.
Which the time frame for response.
If it's outside the timing for questions on notice, perhaps my follow-up question to be taken on notice would be how can we access that information outside of budget estimates? That's really about how we produce the data.
and as I said, it's a very manual process. So it's really a manual process of the checking and going back and allocating. It's not just about code of conduct complaints. It's about every complaint that comes into the Office of Local Government, from someone saying, I rang the council and they didn't answer within the right time frame, to referrals from integrity agencies. So it spans the breadth of importance, but it also means that they're measured in different systems and different processes. So we've got to pull them out, review them, make sure that there's no errors, and put them together in something that makes sense and then is comparable with what we did last year and the year before. So that's why I'm slightly hesitant to say yes, I can guarantee in certain timeframes.
That's all right. I appreciate it's a complex process, and I'll have to ask again next time if we haven't got it in time.
I think this would be a note to my staff that we should try and make sure that we can have budget, that information by budget estimates.
That's subtly done, Brett.
Has been expressed before.
My request has been received and noted. Thank you. In my remaining couple of minutes, you've got a list on your website of current and completed interventions with councils. Edward River Council, is there a reason that it's not listed under either current or completed interventions?
Should be completed.
Yes, Ms Hickey's identified that it should be completed. Can you just talk about how we completed that?
Yep. So that, I think that was in June or July. We received their fourth quarterly report. They'd addressed all the issues that we'd raised and the Minister had raised in the PIO, and so we recommended to the Minister that get closed off, and he agreed. So that was happened. So it's probably just the website not updated. I apologise.
Okay. So in terms of a time frame of the result of the
I'm just going to
intervention,
look it up for you.
that sounds like probably imminent.
Yeah.
Yes, I suspect that it's just a. I suspect that it's just a matter that a decision had been taken by the Minister. He signed off on that. He sent the letter to the council. We probably just haven't flicked the switch on the website to go from one to the other.
Thank you. And just, I've only got 20 seconds to go. You mentioned in passing the report on the 2024 election in terms of diversity, which I'm very interested in.
Yes.
Will that be a public report, and when can we expect it?
It is a public report. We did release a report on the 2021 elections, but as I said, that's one of the benefits that I take of freeing up the governance team. I don't have a precise time frame for that unless Ms Baldock has an answer, but I don't think that again, we receive all the raw data from New South Wales Elections Commission, and we need to actually go through large spreadsheets and so on.
Yeah, I can add to that. We're aiming to have that information released by December, and yes, like Mr Whitworth said, it is raw data that we need to go through individually and correlate. But I can give you some of the figures from those elections that maybe they help in terms of diversity outcomes. So overall, there was about a 4% increase in candidates who stood for election, so from 3,854 in 21 to nearly 4,000 in 2024. The figures show that the percentage of Aboriginal and Torres Strait Islanders appear to have increased from 3.8% in 21 to 4.1% in 2024. And I've also got a range of other figures that I can go through around non-English background speaking nominees, 11%. And the candidates who are identified as having a disability increased from 3% to 4.6%. There's also been an increase in female representation amongst the councils as well, and that's based on preliminary data rather than our fixed data.
Thank you very much. I have some follow-up questions, but I'm well out of time. So
The opposition?
Thank you. Mr Whitworth, in relation to, say, code of conduct and the procedures on the administration of the code of conduct and investigations, are councillors, prior to answering any allegations against them, entitled to procedural fairness and natural justice?
Well, everyone's entitled to procedural fairness and natural justice.
Good. Right answer.
My General Counsel's probably quite happy that I've given that answer.
I'm sure we'll find out from her in a minute.
And is a councillor under investigation, say for a breach of code of conduct, provided with all the credible, relevant and significant material against them in order for them to meet any case against them and allow them to... Sorry?
Sorry, no, I thought you'd finished, sorry.
Oh, and allow them to be properly heard in response to an investigation?
That's where the procedures provide that the councillor needs to be made aware that there is a complaint. I'm just checking that I've got yes, I do have the procedures. Needs to be made aware that they have received a complaint, but they don't necessarily get the full documentation of the complaint.
Okay.
And I know that this was raised this morning, particularly around the Parramatta issue, and I just sort of flag for that we're still within the appeal period of that, so we should be careful about making decisions and so on. But drawing that up to a more abstract perspective, a complaint that is made about a councillor or about a council staff officer, if it relates to serious wrongdoing, could also be classified as a public interest disclosure. And in making a public interest disclosure, there are provisions in that legislation around reprisal and preventing reprisal, and part of that is making sure that someone can't identify where that material came from. So we run a very careful line to make sure that someone is aware that there is a complaint about them, and they're aware of the nature of the complaint, but they don't necessarily get the full detail of that.
Okay. Right. And does a complainant lodging a complaint, do they have to live in the LGA in which the alleged breach occurred?
No.
No, okay. And do they have to disclose their personal home address?
Sorry, does the
complainant have to disclose their address?
We take them anonymously.
A code of conduct complaint could be made anonymously, for example. So in which case, and I mean, we have received, and I know I'm mixing the streams here, talking about referrals from different agencies and so on, but I know that we've received referrals from agencies where clearly an alias has been used, or the agency or the person has declared who they are to that agency but has asked for their details not to be passed on. So we don't receive those details.
Okay, all right. I think that's enough for that one. I wasn't here before, so I'm not sure. You may have already answered these questions about the pet registry. If you have, just say already. Sorry. So how much revenue was collected through pet registration and the companion animal permits in the last financial year?
It was about 8.6 million, which was a drop in previous years. We'd averaged about 10.3 million over the last 3 years. So we're actually seeing a decline in the number of pet registration fees.
Yeah.
Now, I don't know whether that's a decline in the number of animals being microchipped as well, or whether that's a decline in our ability to capture from microchip to registration. Could be a COVID sort of impact. So that's part of what I've very much been asking the team to investigate and identify what those trends are.
And of that, say, 8.6 million, can you say what the revenue was spent on, like whether it's maintaining and upgrading the pet registry, programs, rehoming?
So the money is spent. So we provided to councils. So we collected 8.78 million in the 24-25 financial year, and we provided 6.5 million to councils. So that was that pro rata return.
Yep.
The remainder of the funds were used for programs such as the Responsible Pet Ownership Program, which is that education program that we have where people can get puppies and so on and cats to come to schools, and kindergarten kids can learn about how to interact safely with an animal. We are also starting to look at whether we can better leverage that money. And I did provide the example before of quarterly remittance that I have provided, that I've signed off on, where I provided a council in, far western New South Wales with $29 in a quarter, and I provided another council with just shy of $1 million in that quarter.
Yeah.
And $29 isn't going to do. My comment was it'll provide biscuits for the pound staff for maybe that quarter, but it doesn't enable them to do some of the really fundamental things like improve the animal welfare and humane treatment of their animals, nor does it give the rangers a good enforcement toolkit to enforce the companion animals register. So whilst it's important for us to return money to councils out of the companion animals fund, whether we do it on a pro rata basis or whether we do it on a more strategic way and provide tools, resources, even grants potentially, so that there is broader benefit, is something that we are keen to pursue.
And are you able to say, with regard to the pet registry, when it was originally scheduled for completion, and what is the revised delivery timeline?
I think,
you may have already answered.
Yes, I have,
Okay.
and I don't, with my degree of frustration that it's not,
Okay, all right. I'll move off those ones then. And I'm just wondering, with the model meeting code of conduct that we really only sort of found out about yesterday, I know there's been consultation and discussion papers before. Are you aware of how many councils have formally commenced consultation on adopting the model?
I am aware this is a source of frustration for councils, and I have to acknowledge that. The Local Government Act requires councils to update and adopt a model code of a meeting code of practice within 12 months of an election. So we are, 3 weeks away from that 12-month anniversary, and so I'm assuming the vast majority of councils will have adopted their model, their meeting code. The provisions that will be regulated, and that regulation should happen imminently, will have transitional arrangements that say that councils need to have the meeting code in place and adopted by the 1st of January 2026. However, if they do not adopt a new meeting code, then they will operate under a hybrid system where they'll have their existing meeting code and the new model code will override that to the extent of an inconsistency. So if a council has said, we would hope that every council moves to update their meeting code, but if they don't update their meeting code, they will still have a meeting code that will be effective, and there's a degree of practicality and pragmatism around the timing in which they adopt it.
And so what monitoring will you then do, say that they're on these two different systems, or if they've adopted the new one, what monitoring will you put in place to ensure all councils do adopt it by that date?
Well, as I said, I mean, we won't be monitoring whether they have adopted it by that date. Because if they don't adopt it by that date, then the new system will apply over the top to the extent of the inconsistency. The Minister has discussed with me the importance of monitoring council meetings to the extent that we want to, there are certain elements within the meeting code that will require us to review whether councils are complying with them, and I'm talking quite specifically about the briefing sessions. So I have not yet developed a program of what that monitoring would look like.
So if a council is struggling to, say, meet that, where they can adopt it, will the department provide additional resources or guidance to councils?
We will provide the same level of support that we do now. That's quite a comprehensive level of support, I would say. the governance team of the Office of Local Government is quite well known with the governance managers of councils and, dare I say, a number of mayors and councillors as well. So we will continue to provide that support, and Ms Baldock has flagged for me that she can assist me with the answer.
Yes, I'm happy to assist. We'll also roll out some additional guidance for councils to assist them with the transition, and that will include some model best practice public forum rules, also some guidelines for webcasting and the closure of council meetings, and we intend to hold a webinar as well to discuss some of these changes and go through some FAQs with councils to help smooth that transition process.
And then with regard to, say, compliance, or what will be the consequences to councils if they fail to adopt for whatever reason, whether it's because of IT or capabilities, what will be the consequences if they're unable to comply?
So I'm assuming some hypotheticals, the live streaming, for example, or the briefing session. So we will need to identify for the council that they're in breach. We will need to identify a way in which the council can, is that a breach because they've put an order in for new cameras and it's 3 months away, or is it because they have a philosophical objection?
Okay.
Depending on the nature of the sort of issue, will depend on the nature of our response, which may include the issue of a performance improvement order. I think you've seen that Minister Hoenig has issued a performance improvement order to Edwards River Council for the way in which they had managed their meetings in the past, as an example. So I think that there is a, I'm not going to say willingness because that implies that he's eager to do it, but there is a recognition that the use of a performance improvement order may well be an appropriate response in that circumstance.
Yeah, and so on that issue of, say, live streaming, so say from the 1st of January, all councils are meant to comply with that their meetings are to be live streamed and recordings are published. What steps will OLG or the government take to ensure that regional councils with limited IT capacity can comply?
Well, I actually think that regional councils doing a pretty good job of that right now.
Yeah, they are.
And it's part of the service commitment to their community. I think the Minister was actually pretty energised by a large Sydney council that didn't live stream. The obligation, so there is an obligation for councils to record their meetings and make those recordings public now. So there is a basis in the IT systems that councils can do that. It's more a switch of whether they do a live stream or whether they hold that recording for later and put it up later. But now they will be required to make it a live stream. I do know that some of the conversations have been held with, I'm trying to think, I think it was the drought tour of Greater Hume that the Mayor and Deputy Mayor were describing, that they'd like to move from multiple villages in Greater Hume. They like to move from one village to another just to do that, to have their council meeting, but some of the live streaming elements meant that they couldn't quite do that, but I'm sure that there is ways in which we can work to identify whether there is some sort of more portable technology that can be used.
And will the department measure whether these, say, like, it's enable transparency, because not everyone can go to the council chambers to view these, so live streaming would be seen as beneficial, but will you be a sort of measuring whether this is increasing community confidence in councils?
I have wanted to try and understand how to get at that measure of community confidence in councils. There's obviously people that are unhappy with their councils and they are vocal, some might say a vocal minority. There are those people that, any government is bad and we all suffer from that fate, whatever level of government we have. A number of councils run specific surveys on customer satisfaction and customer sentiment, and whether there's a way of aggregating that data but again, I don't want to necessarily create an obligation that every council's got to do a customer sentiment survey. So working out how we can get to that better understanding. These things would be great, but it's also, you know, I have a number of fundamental reform elements that we need to complete before, like that would be a nice to have rather than a must have at this point.
Mm. And then based on that, say, like if a public forum, councils now have to ensure, or it's mandatory, that they are also live streamed. Is that right?
The public forum, so there is an obligation. It's more a way of trying to give councils more flexibility over how they manage the public forums. So that is one of the areas where we're going to be providing councils with guidance on the public forum.
Yeah, that's what that was going to be the next part. So what minimum standards of accessibility and fairness will the department enforce across councils so that, you know, people who want to watch...
They'll have to look at the guidelines, but that'll be up to each council to determine. I mean, ultimately, the concept of a public forum is to assist the councillors as the elected, you know, democratically elected representatives of their community to be able to understand and hear directly from their community what some of their issues and concerns are. Now, I would imagine that there are a number of ways in which elected representatives gain feedback from their electorate. Public forums will be just one of them.
And the code now allows mayors to call extraordinary meetings without requiring signatures from councillors. What safeguards are in place to prevent misuse of that expanded power?
I suppose that will be one of the issues that we identify as part of the ongoing, you know, monitoring of how councils operate their meetings. If it becomes evident that a mayor is misusing the power, then that will be you know, readily identifiable through the way in which the meeting agendas are put together. I think just because there is an ability to hold an extraordinary meeting doesn't necessarily mean that the numbers on the council in relation to the votes on matters will change. So if you've got a mayor that has been popularly elected but doesn't have the numbers to carry a resolution, then they can call all the meetings they want. They still won't be able to carry the resolution that they're putting forward, and vice versa. Sorry, and I've just been told that the provisions in the code relating to live streaming of meetings also apply to public forums, so they will be live streamed.
Yeah, okay. And you mentioned that, like, you will be sort of reviewing these new code of conduct. When, like, will you be doing reports, or how will you communicate whether some of these rules are successful or need tinkering with?
Sorry, you mean the code of meeting practice?
Yes, sorry.
Sorry, okay. Look, we will, I don't want to end up in that situation where you're constantly tinkering with process. I come from a planning environment where for many, many years we constantly tinkered with the concepts of complying and exempt development, and people had trouble working out what was complying, what was exempt. I think it's more a case of building in regular reviews, making sure that we can try and program those reviews to a time when councils would be updating their meeting code anyway, in the 12 months between an election and the finalisation of the election.
Okay, thank you.
Thank you. I'll start with some questions to Ms. Connell and Mr. Day. I'm just wondering if I could get an update of how many pound facilities were inspected by enforcement agencies in the last 12 months.
Yes, thanks, Ms. Hurst. I'm assuming you were given the figure last time for the 23-24 financial year.
Yes.
And the Section 34B reports aren't due until the 30th of September this year. But for the last 6 months to December 2024, AW Animal Welfare League did 5 inspections of pounds, and the RSPCA did 1. And in terms of action taken, the RSPCA issued 3 pins to 2 pounds. There was 2 pins to £1 and 1 pin to the other pound, and they were a result of complaints. So there were 3 inspections as a result of complaints made, in addition to those other ones before.
And sorry, who gave those pins?
The RSPCA.
RSPCA. And did you say they've inspected 1 facility?
The RSPCA, so there was 4 all up. So 1 was what we would call a routine inspection, and the 3 from the RSPCA, in addition to the other one, was as a result of complaints.
Right. Okay. And they were the ones relating to the pins.
Yeah, that's right.
Yeah. Great. And then there was 5 by the Animal Welfare League.
That's correct.
And there was no pins or anything else from that.
That's correct, and no complaints either.
Okay, so those 5 were all routine.
Yes.
Great. The Pound Inquiry recommended there be regular and unannounced inspections of New South Wales pounds to ensure a high standard of care for animals, and that was something supported by councils and animal protection organisations. Has there been any work between DPIRD, OLG, enforcement agencies to try and ensure these types of routine inspections can occur?
That's only something we can look at in terms of the upcoming grants process, in terms of the ACOs applying for the funding. So yes, we could look at that.
Okay. I was asking the Minister this morning as well about the RSPCA's no longer taking in stray cats. Is that something that DPIRD's received any complaints from councils about, or is there any work that DPIRD's doing in that particular space?
Not complaints from councils to us, and also it doesn't compromise their enforcement ability in terms of what we provide the grant money for, so it wasn't really our purview.
So there won't be consideration of that in any future grants? Thank you. I've got some more questions around pound statistics, which I assume might be Mr. Whitworth or Ms. Rahman. I've previously asked about missing pound statistics for certain councils. At last estimates, the only council who had not reported anything was Murrumbidgee Council. Can you provide an update on whether they have supplied data now?
I do not remember reading about whether that's the case, but Ms. Rahman might have an update on that.
Just that, I'm just putting on my info. So that survey information is due by the 31st of August, so we'll have just received that. As of Thursday last week, 76% of councils had completed, 3% had not completed, and the remaining 21% had started. I reversed that. 76 completed, 3% not completed, and 21% not started. So I don't have a breakdown of the specific councils, and I would expect that, like many things, they get submitted at the last minute, so we can do an update at a later stage.
Thank you. Do you have any information about the previous year? So the year that I'm concerned about is the 23-24, and I appreciate this was before your time, Ms. Rahman, but I think I spoke at the last budget estimates with you, Mr. Whitworth, about the councils that hadn't reported anything. Are they still recorded as not having reported any data?
I thought that Murrumbidgee had identified. Can we take that on notice? But I thought that I remember dealing with this, and I thought that Murrumbidgee was either a case that they didn't have any circumstances, or that there was a shared pound arrangement. Another service. So they didn't believe they needed to report.
We had Lane Cove and Hunters Hill who reported 0, and they said that's because they were leaving it to Blacktown Animal Rehoming Centre to do the reporting on their behalf. And obviously there's concerns around that because it kind of gives Blacktown a bad look for
Yeah.
having all these lost animals and these other councils looking like, so it sort of creates this odd picture. But I think from memory, and I'm happy for you to take that on notice and correct me if I'm wrong, that Murrumbidgee was still a sort of an outlier that we hadn't, or at least I hadn't got information in regards to why they had reported nothing.
Okay.
But yes, I do have Lane Cove and Hunters Hill in that situation that you indicated.
We'll take that on notice and come back to you. I do remember us following it up, and I thought it was the subject of a response to a question on notice, and that they hadn't actually complete. They didn't have data, but I'll take that on notice and
Thank
give you
you.
a fulsome.
And is anything being done about the two councils that are sort of leaving it to Blacktown? Are we going to change that sort of system in regards to reporting going forward, given obviously some councils are sort of, there's quite a few councils using bark, and now it kind of creates this sort of strange view of actually what's happening in different councils?
Well, with Sydney Dogs and Cats Home starting to come out of the ground quite well, we'll have more councils using shared services. So the commitment that I make to you is that before we publish the data, we'll do a cut and review of it to make sure that if there are some of these unusual circumstances, we'll go back to the councils and see whether we can actually get the data that comes from their area.
Great, yeah, thank you. And so, sorry, Ms. Rahman, when I know you sort of said that there's a bit of time still going on in regards to getting that data in, do we have any sort of expectation around when those newer statistics might be published?
Yes, so we'll be running the final numbers at the end of this month, but we'd hope that in the first week of October or sometime within October.
I mean, can I just say that, this is my challenge in that we get this data and we rush to publish it, and sometimes we find problems, and we don't necessarily get, a proper outcome. So I'm always nervous about providing that sort of commitment that it will be, but we'll make every effort to. Can I just say, my dutiful team, my incredibly diligent executive officer, who doesn't get anywhere near the credit that she should get, has said to me, we responded to that question on notice last time. We contacted Murrumbidgee and they advised they didn't have any animals enter their pound during the period.
Okay, interesting. And has there, sorry, this is probably another one then on notice, was there any sort of follow-back correspondence about that, given that seems like a fairly unusual situation to have an entire year with an entire pound having no animals coming forward?
That sort of would go to the way in which their enforcement is being run as well. Murrumbidgee is centred around Jerilderie, and there's another town that I will forget. So they're not, it's not an urban environment, so the majority of the animals will probably be working dogs. So they may not have a very high number of strays and all animals that are seized in any case.
Okay. But we don't have any information about that. It's more just an assumption.
Well, that was what they told us. They didn't have any animals. I don't know how I could go back and interrogate that any further.
That's fine. Has the Office of Local Government done any consultation or analysis on the impact of RSPCA's decision in regards to no longer taking in stray cats? Is that something that you've been in communication at all with councils that might be affected?
No, we haven't. Have been watching this as an unfolding situation. We have reviewed the money that they have received from the government for capital improvements to a number of facilities. And I mean, we are aware that they made an announcement some time ago that they were going to move out of the rehoming practice. But the implications for councils is something that we have, I know that the Unanderra facility, RSPCA, had implications for Wollongong and Shell Harbour, and that those councils were working with RSPCA to identify an appropriate response. rather than the Office of Local Government intervening. If the councils are working with the RSPCA, I'd rather let them work it out and come up with appropriate arrangements.
Thank you. Before I throw to Dr. Connor, I understand, Mr. Day, that you may have requested to leave early. My understanding is the committee has finished with any questions, so you may leave when you're ready. Thank you. Dr. Connor.
Thanks, Chair. Mr. Whitworth, you've referenced the expert advisory panel regarding the financial reforms a couple of times already today. It's obviously the government's preferred way forward for a number of the recommendations out of the Financial Sustainability Inquiry. What's the progress on establishing the panel and next steps from here?
I can refer to my testimony already given, but the establishment of a panel or a board or a committee needs to comply with certain Premier's memoranda and guidelines, and that involves consultation with the Public Service Commissioner. That consultation has commenced. I think I described the differences between a stakeholder-based approach and an expert-based approach. So I think we have a number of experts that we'd like to approach and to seek their involvement. For me, the expert advisory panel has been critical because one of the challenges of financial sustainability is that we need to carry the local government sector with us on any changes. The repeated conversation about cost shifting shows that, you know, local government has a very legitimate and robust argument about cost shifting, and I've got a reasonably legitimate argument about there not being cost shifting, but that doesn't ultimately solve the issue that councils need more money to operate and provide their services for their community. And having conversations about cost shifting when we could be having conversations about what is the best way to deal with the growing trend and the growing need for greater diversity of housing, which translates to build to rent, and how do we ensure that that's appropriately identified as a rating approach, and what is the best way to pick up the differences in ratings between different council areas, where some councils want particular types of activity rated, others don't necessarily want it rated. I need to work with the sector so they can identify these are the things that will work and will give us more credible and enduring financial sustainability. So that's why I feel the expert advisory panel is so critical. I don't want this to be a government-imposed process.
I'm moving on, but only to note that I don't want that to be interpreted as acceptance that cost shifting isn't happening by anyone who's watching this.
I'm sorry, I'm not trying to make the argument that cost shifting isn't happening. I suppose what I'm trying to say is that there are deeper issues around cost shifting, and we could have a great conversation about cost shifting between the Commonwealth Government and the State Government, and it happens at every level.
I don't doubt that it's also happening at other levels of government too. I had a couple of questions around the new Model Code of Meeting Practice, which is obviously very fresh. Specifically regarding public forums, there's a comment in the FAQ for the Code of Meeting Practice that the public forum provisions are now mandatory, but that it's up to councils to determine whether to hold public forums before council and committee meetings. So it's not really clear if, when and where public forums are mandatory. Can you clarify that?
These will be the source of the guidelines. I think some councils have a public forum before a council meeting. Yep. Some have them before a committee meeting. Some councils have a disconnected public forum that Tuesday is public forum day and there's no other meeting. So what we're saying effectively is you've got to have a public forum either in front of a council meeting or a committee meeting. The fact that there are no, in the previous model code, my memory is that there were a number of non-mandatory provisions about public forums. Those have been removed from the model code to allow councils to structure the public forums in the best way that they want to have them structured. But we have, and as Ms Baldock identified, we will be providing a guideline to councils on how they could use effectively the previous versions of the model, of the the requirements to structure their own process around.
Okay, so just to clarify my own understanding, when it says it's up to councils to determine whether to hold public forums before council and committee meetings, it's up to them regarding the timing and the format of the public forums.
Yes.
But they must have them.
They must have them either before a council meeting or before a committee meeting. They don't need to have them before every meeting. That's my reading of it.
Thank you. That clarification is helpful. While we're on, Ms. Waldeck, you were in the middle of giving me some very interesting statistics out of the diversity report, which I'll just come back to before the end of the day. I think you were about to give the figures for disability and for women.
Disability you gave.
Disability, yeah, I thought I did cover disability.
You didn't cover women.
The women, there was 1,285 councillors elected at the 2024 local government elections. The preliminary data indicates that 522 of these, or 41%, are women. And that's an increase of 2% from the 2021 elections.
Okay. And for the other sort of priority populations you gave prior to women, that was the proportion of candidates, not the proportion of councillors?
So for the 2021 figures, let me see. The data indicates that the percentage of Aboriginal and Torres Strait Islander candidates appears to have increased from 3.8 in 2021 to 4.1 in 2024, and candidates whose first language is not English made up about 11.5% of the nominees, and the candidates who who identified as having a disability increased from 3% in 21 to 4.6% in 24.
That's right. This is all very helpful. Those are all the figures for candidates, not for elected councillors. And then for women, you've given us the figures for councillors
so
elected rather than
the elected
candidates.
is the information that we still need to be working through based on the final figures and part of that diversity report that will release by December.
Okay, thank you. And does the Electoral Commission collect any data on LGBTQIA plus identity?
I'm not sure if I'll have to take that one on notice.
No problem. Thank you. Coming back to the Code of Meeting Practice reforms, I just had one other clarification. Mr. Whitworth might need to listen to that.
Sorry,
to the question.
Running out of power.
The new provisions 9.3 to 9.6, so they're specifically about the ability of councillors to put on urgent business or business without notice. And there's a number of specific provisions in this section that only the mover of the motion and the chair can speak to the motion before it's put, and also 9.5 functionally contains a veto power for the mayor, so even if the council itself considers an item urgent, the mayor has the power to override that. Was there a particular rationale why, for this one provision, the consideration of urgent business, you're allowing the mayor individually to override the majority decision of the council?
Sorry, Dr. Conn, which clause?
So I'm looking at 9.3 through to 9.6, so the veto specifically is at 9.5. So it says the council may only deal with business at the meeting that councillors have not been given due notice of, where a resolution is adopted in accordance with clause 9.3, and the chairperson also rules that the business is urgent.
So this is, I believe, and look, we can take the question on notice, but I also understand that in my quick looking at this relates to, there are 2 points. One is, I'm putting a notice of motion forward, so I need to speak to the urgency of the notice of motion. So only the mover of the motion and the mayor or the chair of the meeting can speak to the urgency of the notice. And once the urgency of the notice has been established and voted on, then other councillors can speak to the motion itself. That is my quick interpretation, but we can take that.
Yeah, so you've just given me your interpretation of 9.4, but then specifically 9.5. So it seems to me very clear that there's an intention of giving the mayor a veto. So there's this reference to a resolution being adopted in accordance with 9.3. and also the chairperson ruling that business is urgent. And then specifically it goes on, there's added a 9.6 that a motion of dissent cannot be moved against a ruling by the chair. So it seems to me like a very intentional vesting of power in the mayor to veto business being considered urgent.
I believe that that's an existing provision.
I'm pretty sure from having sat through many council meetings, that's the way it operates at present.
So
we'll check for you. But
yeah. So the process is mover of the motion. There is a why is this urgent? The council will vote. Then the mayor needs to effectively certify, for the want of a better word, that the motion is urgent, and then you can debate the motion.
I'm sadly out of time to continue this discussion. We'll go to the opposition.
Right, just a couple of quick ones from me, please. The process when a councillor submits a complaint against a general manager or a mayor, is that changing as part of the changes that you're implementing?
That, in terms of the longer term changes, and the Minister spoke about the Privileges Committee,
yes,
that will change. But under the existing provisions and under the new provision that the Minister flagged with the transfer of jurisdiction to the Land Environment Court, those won't. So at the moment, the way Code of Conduct complaints are dealt with is under the procedures for the Model Code of Conduct.
Mm-hmm.
In order to create the new Privileges Committee, we will need to amend the Act and effectively change those procedures. So my ambition here is, at the moment, complaints are made, Code of Conduct complaints are made to the General Manager in all circumstances unless they are about the General Manager, in which case they're made to the Mayor, which puts the General Manager into the political frame of dealing with the Code of Conduct.
And then, that's right, if it's made about the Mayor, it goes to the General Manager?
Yes,
That's right, so there is issues.
So what I would prefer to do is to have a complaint process that is focused on whether this is an appropriate behaviour for councillors. Sorry, take a step back. The existing Code of Conduct and the procedures will be effectively split. You'll have the existing system will continue to apply to staff because it seems to be an effective mechanism for staff. So complaints about staff will be made to the General Manager. Complaints about councillors will be a complaint to the Privileges Committee, and that'll be a web form based process that will come to the Office of Local Government, triaged by the Office of Local Government, and then given to the Privileges Committee, unless it's a pecuniary interest issue, which would come direct to us, which it does now anyway.
So you just talked about complaints about staff. What if staff have complaints about the GM?
If staff have complaints about the GM, then that would need to be dealt with. We still believe that should be dealt with as a Code of Conduct complaint, but in that instance, it'll still need to be made by the Mayor. To the Mayor. And under the existing processes, complaints made to, under the procedures, are made either to the General Manager or to the Mayor, who then consult and talk to the council's complaints coordinator, who
so
then organises for a...
So you can see why this can be and has been an issue, but you are looking to change that. So have you got a time frame on what you might be hoping in that regard?
Well, we have been picking these things off progressively. It may be a little bit more messy than what I would have hoped originally, but we need legislation to implement the Privileges Committee, so there will need to be that'll need to be considered around the legislative agenda and timeframes.
Okay, as long as it's being looked at. Now, the other thing that you have raised earlier, and don't get me wrong, I want to encourage people into local government. Every fibre of my being I do, particularly women. But the eligibility to run as a councillor, you talked about when they have a prosecution charge against them for more than 5 years. Has that been reviewed as part of this, and does that need to be tightened up and looked at more closely?
That hasn't been on our policy radar.
I think it should be.
Well, I mean, if you read any number of court judgments or NCAT judgments about action taken against councillors, I was reading one last night where, and this isn't exactly the quote from the judgment, but it pretty much talks about if you are depriving a community of its democratically elected councillor. So you know where I'm going with that.
I do know where you're going with this, yes.
So this is a challenging
I'm talking
area.
about the eligibility for people to run.
Yes.
If we're already suggesting that it is in place if they have a judgment against them. I raised with the Minister at the last estimates the fact that those who choose to run, let alone be elected to council, aren't even required to have working with children and vulnerable people checks. Now, the Minister took that on board to look at that.
Mm-hmm.
I didn't have the chance to ask him whether he has looked at that. But is this not something that should be given serious consideration?
I would look. That's ultimately that'll be a policy decision of government. Ultimately, that will be a question as to the extent to which you want to put a limit and a bound around who should be an elected representative.
Well, I mean, we do have that around other levels of government. We have it, working with children and vulnerable people checks. I mean, for goodness sake, you can't even sit on a volunteer committee or a board without one of those. And we're also talking about and seeing for ourselves demonstrated unacceptable behaviour from elected officials. So I'm just talking about if we're going to be managing them reactively, is there more that might be done from a proactive position? And quite frankly, with all of the childcare, and you're talking about the other areas that council is now straying into, aged care and the rest of it, we should be having more protections, particularly around working with children and vulnerable people, when we know that councillors do indeed do that. And other states like Queensland, I understand, do have legislation that accords with such things.
Okay. Look, I mean, I think that it would be far easier for me to implement such a change if it was something that was being done at the state level as well. So, I mean, do parliamentarians consider what restrictions and requirements they need to meet in order to run for Parliament?
Well, yeah, we do. In terms of party positions, we're required to have police checks and working with children checks and financial checks, etc. So from a party perspective, we absolutely have those things in place. Independence, I can't answer to that, but it's fine. It's something that I will be pursuing a little more vigorously as well. So.
Thank you. I wanted to ask you about the Pathways to Prevention New South Wales strategy for the prevention of domestic, family and sexual violence. Do you know how much has been allocated to support councils to implement the Pathways to Prevention?
That's not within the Office of Local Government.
I believe that's Minister Washington.
Oh, okay.
But, yeah.
I
believe.
More than likely Department of Communities and
It's definitely Communities and Justice. I'm just not sure what the Minister.
Okay. I think
might
they
be
asked me
Mr.
to ask you.
Harrison.
Yes. I also wanted to turn then to the State Development Report into the ability of local governments to fund infrastructure and services and so the government has accepted 11 of the 17 recommendations from that.
15.
Sorry?
15 of the 17.
Oh, 15, sorry. Oh, yes, I meant support, and then there's, yes.
Partial support for
Partial
some,
support,
and of the
sorry.
two that we haven't. Sorry, you were going to ask me a question.
I was wondering if a framework has been established around those so that commitments can be delivered, and if so, what are those frameworks?
So I've provided testimony a couple of times now about the expert advisory panel and the process that we've been using to use the expert advisory panel to help us deliver the government's responses. We have already started by compiling the issues associated with each of those recommendations. I do note that whilst it says 15 of the 17, one of those relates to development contributions, which is sort of outside our scope, but still understand subject to discussions in other places.
That's correct.
And the 17th was about the Red Fleet issue, which we had left at the time because we didn't have the response of the Public Accounts Committee, which is coming. So you can see that we're already working through those. I do think that there's, I wanted to make sure that we could deliver the changes in a way that takes councils with us. The role of the expert advisory panel is critical. We come out with a list of, here's a set of changed exemptions for rates, for example, and some councils will say that's great, other councils will say you haven't picked us our concerns, etc., etc. So that's why the expert advisory panel for me is the glue that pulls all of those issues together.
Excuse me. Does the government intend to complete all of those supported recommendations excuse me, before the 2027 election?
Sorry, on the financial sustainability review. I can't talk to the time frame. I think we would be anxious to try and get them completed, but changes to rating exemptions requires legislation, for example. Changes to statutory fees will require changes to legislation. Changes to the account, some of the provisions around valuation and depreciation will require the Australian Accounting Standards Board to make changes to their processes, which they're working on. So we don't necessarily hold all the levers for the time frame.
No, okay. So based on that, have you been given additional resources or so that you can start putting into those places? And with the legislative changes, that wouldn't be coming from you, that would be coming from where?
So the resources to implement the financial sustainability review are part of those increased resources that the Office of Local Government has received. So the creation of the strategic reform team, they've got essentially 3 jobs. One is to improve the relationship and engagement the Office of Local Government has across government agencies to ensure that there's greater awareness of local government issues in their decision making. The strategic reform team is also working on the Council Conduct Framework, and the strategic reform team is working on the financial sustainability review, but with the input of, it is an issue that runs across the Office of Local Government, so the performance and delivery team has a role in that, the policy team has a role in that as well.
And so with those recommendations that do require legislative or regulatory change, has there been a process put in place for drafting of that, and when are we likely to see that come before Parliament?
As I said, we don't want to be drafting until we've got the policy components clear, and to get the policy components clear, we want to make sure that we're bringing councils along. And so part of that is the criticality of that expert advisory panel to help bring councils along.
Okay, so it could be a while then. Okay. And this is probably, I was just wondering, would you have like a dashboard that you will have to say, okay, this recommendation has been done, this one's like a progress on each one, or?
Did I ask for a dashboard on that at the last executive? I think we are working on a dashboard to help us with the recommendations and how
the broader governance area of DeFi as well has a general oversight role for recommendations that are made across the department.
And would that dashboard be made in a public so that other people can look at it?
I think the challenge with, I'd love to do that as long as everyone else in government put their dashboards up and made them publicly available as well, and we had reasonable conversations about whether something showing as amber doesn't mean that the world's about to end, but it's just about time and issue and resources, but that's not really what happens in those circumstances. So, I mean, there's certainly all documents that could be gippered. if need be.
And so on those recommendations, are there 3 that are a priority, or is that again part of what you were saying before with regard to you're waiting for the expert panel to do that?
Well, some of them the engagement with the Commonwealth around the increase in the financial assistance grants to 1%, that's already started, and I've always made the comment that I never let a meeting go past with my Commonwealth colleagues where I don't talk about increasing financial assistance grants. So some of them we're working already on and trying to do as much work in the background so that we're ready and prepared for when we have the expert advisory panel. We can go, right, here is the program of work that we're going to put to you, developing up those policy papers to get their head around some of the issues and some of the policy context, policy challenges, throwing out examples, what are the implications of of increasing the number of rate categories, for example, to capture some of the challenges of renewable energy zones and the number, the way that solar and wind farms are captured through the rating process there, or build to rent, or I could keep going with any number of those sorts of examples. I don't know that we'll get, the government's response has identified that some of the issues will be off limits to us, some of the charitable issues, and dealing with the exemptions that charitable organisations have, but that also then goes to some of the education issues as well, which I know is a subject of discussion at the moment.
Mm-hmm. And when you just said when you're meeting with the federal guys and you don't let an opportunity, how is that received by them? Or are you not allowed to comment?
Oh, well, other than when they roll their eyes at me and say, yeah, he said it again. No, it's received well. I mean, their response is, and it's probably the same response that I would provide to councils, is that there is a big draw on the Commonwealth budget, that financial assistance grants are just one of the things that the Commonwealth needs to fund. They point out to me that they have increased funding in other areas that doesn't necessarily get captured by the 1%, the financial assistance grants, like some of the direct funding for roads. These are all the things that I get from my Commonwealth colleagues.
Yeah. So is there, just on those financial assistance grants, is there another way we can divvy up that pie?
That is certainly the ambition of the Grants Commission. I put myself onto the Grants Commission as a way of identifying that is an area where we can address and get some change. We are, for example, the grants, financial assistance grants, are worked on the basis of a general purpose grant and a roads grant. The roads grant is worked on the basis of a formula that was calculated, I think, in the early 90s. Which doesn't seem to have as much relevance to some of the issues and challenges that we're facing today. Changes in the increasing rate of natural disasters means just the roads component alone, we're not picking up adaptation and resilience issues, for example. So yes, there is certainly scope to change and look at that. But the other challenge is that there is a pie that's given to the state, and it's allocated to 130 entities. If you're going to increase the pie, the slice of the pie to one of those entities, someone's got to get a smaller slice. So,
but that's in your consultation, and when the Grants Commission is going around to different councils and
yes,
explaining that process.
Yes, and
some would like the message, and some councils wouldn't like what they're hearing.
Yes, yes. We have tried to make, I think the model for the general purpose component is incredibly opaque, and we've tried to make some of the rationale and the process behind it more apparent. But again, we're reliant on this, these strange combinations of rainfall and number of pensioners and the number of I don't know, any other sort of number of weird combinations that have gone into a formula that sits in a black box that spits out a number. I'd like to get at that and make it a more effective process. And I know my colleague commissioners are keen to do that as well. But there is also that recognition that it needs to be done carefully. You don't want to end up... I mean, people talk about Queensland and how Queensland changed the model, and they talk about how the rural councils fared quite well, but they don't talk about some of the concerns that were led for the metropolitan councils that ended up with less money.
Yeah, okay. Well, good luck on that journey and on helping those councils with the greatest relative need. Yeah, thank you.
Well, we've got 30 seconds left, so I'll just throw a very quick one in there then, please. Consultation around the announcement of the mandatory FOGO services for all New South Wales LGAs by 2030. What specific consultation was conducted with regional councils prior to the announcement?
That's something that you'd have to ask Minister Sharp and the department. I think that's an EPA.
It's an EPA, I'm pretty sure.
Okay. Yeah, they manage that waste policy.
Okay, thanks.
Thank you. We've got 10 more minutes. I've only got one little question, and then I'll throw to the opposition for the rest of that remaining time, if you'd like to keep going. I've just got a question around getting an update on the work to build Sydney Dogs and Cats Home new facility, and whether it's still expected to open in November.
Yes is the short answer. I've actually seen pictures, and there is car park, there's framing, there's a roof, but Ms Baldock can elucidate a bit more.
Great.
Yes, so I attended a project control group meeting last week. Public Works have been allocated with the role of overseeing that project. And as Mr Whitworth has just said, yes, the project is tracking on time and to budget for a November completion. There has been some identified works around a sewer connection with Sydney Water, and Public Works are actually actively working with Sydney Water around that. In terms of Sydney Cats and Dogs Home, their lease actually expires on the 24th of October, and they've arranged an extension of that lease for another month to cover that time frame. So that was pleasing news to hear last week.
Great, thank you. And do you know if the new shelter is going to have all the facilities and outfittings that they originally planned and hoped for? I know that they were concerned for a bit and having to obviously fundraise to supplement how much they needed for that build. Is it your understanding that they're now in a position that they will have everything that they want?
I think that there needed to be a lot of value engineering. Whilst we were presented with we can build this for $12 million, when we auspiced the project and got Public Works to look at it, it was more like 17 million. So there has been a lot of value engineering to bring stage one down to the $12 million.
Okay.
I think there has been every eye kept on the opportunities to, recognise that it was always to be delivered in two stages. The 12 million was the government's contribution. There was going to be another 8 million from Sydney Dogs and Cats for second stage. So every opportunity to ensure that they could deliver the second stage as cheaply as possible. But I don't know that we can answer the specific question that you're asking, because the way in which that value engineering exercise happened, there was both paring back and pushing things from that stage to that stage.
And is it stage one that we're seeing is likely to be finished very soon?
Yes.
Yeah.
Yes.
Great. Thank you. The opposition.
I've got two questions. I'll go to you. So can you just confirm, like when a councillor does their disclosure of interest return, they need to include their residential address and any property they are paying rent or board for or being allowed to live in rent-free? Yeah.
The last one, I'd want us to take take that on notice. It goes to the nature of the contract. So if you're living rent-free somewhere, whether there's a contractual arrangement for you to live rent-free, or so how that manifests. But so they're required to identify that. but only as it relates to New South Wales.
Yeah, okay.
New South Wales or Australian property?
Probably.
Australian property.
Yeah,
So it's overseas. So the concern is that there is overseas property that's not being picked up, and that's why we want to, we want to address that. But as the Minister identified this morning, he wants a pecuniary interest scheme that mirrors the pecuniary interest scheme that parliamentarians have, which makes a lot of sense to me.
Yeah.
So there will be that mechanism.
Mm. And I guess because you took the last part on notice, what is the penalty for a councillor failing to disclose that information?
Well, I suppose that if it gives, it is a bit of a hypothetical.
Yeah.
Because if it gives rise to a involvement in a decision where the councillor actually did have a pecuniary interest, then that could be misconduct. And it could be, and if it's serious misconduct, then there are a range of sanctions that would exist after a departmental report and an investigation, which could include suspension or referral to NCAT.
I have one more for hypothetical. Just say they were in a council meeting and a matter came before council involving a property that a councillor may be living in or paying rent, or does that councillor need to disclose that in the meeting, like as a conflict?
It's a pecuniary interest, yes.
Okay, thank you. I haven't got any further questions.
No.
Thank
you. Government time.
I'm sorry.
Oh, sorry, yeah.
If that's sorry, Mr Primrose. Just there was a comment that was made earlier about Newcastle and the study leave versus special leave. And I think I was under the impression that the standard contract included study leave, but it actually includes special leave, which covers all leave not specifically mentioned in the contract. So I think I just want to correct that record. I do. The office, as I said, I try and avoid talking about whether we've been involved in investigation of matters or not, but the Office of Local Government did have cause to look at that, and we did receive a notification from another agency, but that's as far as I want to go.
Okay. And could I also just mention the Edward River PIO was closed on the 16th of June this year.
And we will update the website.
Yes, if it's not already updated.
If someone hasn't already panicked and done it.
They probably have as we're speaking.
Wonderful.
Well, my question, which has been preempted, is if anyone has any updates or clarifications they'd like to.
Sorry, Mr Primrose. I could have let you have.
No. I was delighted that you're prescient in relation to my question. Thank you.
Wonderful. Well, thank you to all our witnesses for your attendance today. We appreciate your time. The Committee Secretariat will be in touch in the near future regarding any questions taken on notice and any supplementary questions as well. But thank you all again for attending today.